Good morning, everybody. Welcome to the Committee on Housing and Economic Development. We are convened today to hear this morning for a number of public hearings. We'll get started and I'll ask for members to introduce themselves. Can we start at the far end?
Thank you, Senator. Hello, everybody. Big crowd. Good to see. My name is Arthur Mingo, representing District 9, Eastern Washington County.
I am Senator Donna Bailey. I represent Senate District 31, which is Buxton, Old Orchard Beach, and Saco.
Hi there, I'm Representative Cassie Julia from Waterville, which is HG 65.
I am Mark Walker representing District 84. That's Naples, Sebago, Baldwin, parts of Standish.
Hi, I'm Amanda Collimore. I represent House District 68, Pittsfield, Clinton, Burnham, and Troy, and I serve as the ranking member.
Good morning, everyone. I'm Tracy Gear. I represent District 134, which is Kennebunkport and Coastal Biddeford and Kennebunk, and I am the co-chair of the committee.
And good morning, I'm Senator Chip Curry. I represent the 26 rural, coastal, and island communities of Waldo County, and I serve as the Senate chair. Our schedule today is going to be, thank you very much. We have a couple folks on Zoom that are participating remotely. And so I'll ask Representative Lookner to introduce himself.
Good morning. I'm Representative Grayson Lookner. I represent House District 113, which is several neighborhoods.
Welcome. And Representative Mallon.
Good morning, folks. I'm Mark Mallon. I represent House District 133, which is part of the great city of Biddeford, and hope to finally join you in person again on Thursday.
Excellent. And I think that is all of our members. We that are here. We have no one else on participating remotely. Great, thank you. So our schedule today will be starting we'll be doing 3 public hearings in the morning. So we have LD 221. We're going to go in order from LD 221, 2211, then LD 2164, and wrapping up with LD 2173. Our afternoon schedule scheduled to begin at 1 o'clock is LD 916, and then afterward we have a couple work sessions, LD 2097, and then LD 2124. That is the plan for the day. As the folks who watch regularly see, sometimes that plan gets disrupted and changed, and this has already happened for some of the bills today, and so we'll try not to disrupt them again. Thank you for coming again. So with that, I'll hand over the gavel to my co-chair to introduce the public hearing for LD 2211.
Thank you, Mr. Chair. And with that, I will open the public hearing for LD 2221 and ask the bill sponsor to introduce the bill.
Thank you. Representative Gear and distinguished colleagues of the Committee on Housing and Economic Development Committee. Again, my name is Chip Curry. I have the honor of representing the 26 rural, coastal, and island communities of Waldo County. My testimony will be, you will receive written testimony sometime today. It's just not ready at this point. So I will proceed with this, with what I've written and get the printouts shortly. Thank you for the opportunity to present LD 2211 and an act implementing the recommendations of the Automotive Right to Repair Working Group on behalf of the Governor and the Attorney General's office. This bill is based on the consensus recommendations of the Automotive Right to Repair Group, specifically addresses the structure of the independent entity and proposes converting it into a commission based within the Attorney General's office. It improves the existing law and strengthens oversight in a way that is workable and grounded in the recommendations of the group convened to address these issues. A representative from the Attorney General's office is here today to walk through the details of the proposal and answer technical questions. I would respectfully ask that the committee call them up up next so that they can provide a fuller explanation of how this bill implements the working group's recommendations. Thank you for your time. I'd be happy to answer any questions.
Thank you. Representative Collmore.
Thank you, Madam Chair. Thank you for presenting the bill. Who actually wrote the bill?
This bill came from the governor's office. I believe the attorney general's office was intensely focused on the writing of it. So I think it was primarily the attorney general's office.
Okay,
But
great.
I do know there was review and between the governor's office and the attorney general's office. So the fact that the attorney general is their office representative is here should be you're talking to the author at that point.
Okay, thank you.
And could you just clarify the group you would like to testify next to explain?
A representative from the attorney general's office. I believe it's Chris Taub.
Thank you. Other questions from the committee? Seeing none, thank you very much. And I will call to the podium the representative from the AG's office to help us with more detail. And I'll ask a member who just joined us to introduce himself, please.
Thank you. My name is Rick Bennett. I have the honor of serving the people of 14 towns in Western Maine in the state Senate across parts of Androscoggin, Cumberland, and Oxford counties.
Please go ahead.
Senator Curry, Representative Gear, and esteemed members of the Committee on Housing and Economic Development. My name is Chris Taub. I serve as the Chief Deputy Attorney General under Attorney General Aaron Fry. And I'm here to testify in strong support of LD 2211, an act implementing the recommendations of the Automotive Right to Repair Working Group. In November of 2023, over 84% of Maine voters approved an initiated bill entitled an act regarding automotive right to repair. This bill, among other things, requires motor vehicle manufacturers to make access to onboard diagnostic and repair information, the same for owners and owner-authorized independent repair facilities as it is for motor vehicle dealers. During the second regular session, the 131st legislature enacted LD 2289, a resolve to establish an automotive right to repair working group. I, along with the chief of our Consumer Protection Division, headed up that working group. All major stakeholders were represented in the working group, including two representatives representing motor vehicle manufacturers. We had a representative of the Alliance for Automotive Innovation, which represents most of the major car manufacturers such as GM, Honda, Toyota, and Ford. And we also had a representative of Tesla, which is not a member of the Alliance. This working group was a significant endeavor for our office, and part of the reason for that was even though we had a very diverse group of stakeholders, we had independent repair facilities, we had parts manufacturers and distributors, we had dealers. Basically, every stakeholder interest was represented, and it goes without saying that not all of these stakeholders had the same interests, but it was important to our office to get to a consensus. And so we worked very hard. We met 10 times between August of 2024 and February of 2025. We had a number of meetings, a lot of work in between meetings, and ultimately we did get to consensus recommendations. So we got to a point where there were certain recommendations regarding amendments to the statute that every stakeholder on the working group agreed should be made to the statute. And LD 2211, essentially with one minor exception, it adds a definition which was not one of the recommendations of the working group, but it makes sense and we support that. Every other aspect of 2211 simply implements the recommendations of the working group. Part of the working group's work, we submitted a report to this committee that detailed all of our recommendations. And we actually attached to the report sort of draft statutory language that had the amendments to the statute that we thought were important. And so 2211, while it's been sort of put into more standardized statutory language, it essentially does reflect what we submitted as unanimous recommendations to this committee. I can walk through the bill in a second, but what I do want to say is that, again, every major stakeholder participated in this working group and every major stakeholder agreed with these recommendations. So I would expect that, at least with respect to the parties that were represented, there should not be any opposition to this bill. And if any party that did participate in the working group does oppose the bill, it really makes me wonder why we spent so much time trying to get to consensus recommendations. I can, if the committee would find it helpful, briefly walk through the bill. So the original citizen initiated bill created something called the independent entity, which had certain authorities assigned to it. One of the unanimous conclusions of the working group was that there should not be a third party that is administering the right to repair law, that rather motor vehicle manufacturers on their own should decide for themselves how they want to implement the requirements. So we recommended that we do away with this independent entity and create something called the Motor Vehicle Right to Repair Commission, which would essentially act as an advisory group. So Section 1 creates the Motor Vehicle Right to Repair Commission. Section 2 makes an amendment to Section 1810, subsection 1, to eliminate a provision relating to the independent entity. Section 3 adds a definition for owner-authorized independent repair facility. As I mentioned before, this was not a specific recommendation of the working group, but it does make good sense, and so we support adding the definition. Sections 4 and 5 really go to sort of doing away with this independent entity and replacing it with the Motor Vehicle Right to Repair Commission. Section 5 sets forth the membership of the commission and its duties. Essentially, the role of the commission is to monitor compliance with the right to repair law, to resolve any complaints that are received, to issue sort of best practice recommendations, and then also provide technical assistance to the Office of the Attorney General. And the expectation is that the commission would annually submit a report to this committee, sort of detailing its work over the past year. And also, because this is a new law and there probably are going to be some kinks to be worked out, the part of the job of the commission would be to identify any amendments that they recommended be made to the statute. Section 6 corrects what appears to be a drafting error. This again was a citizen initiated bill, so it didn't go through sort of the same rigorous process that a legislator initiated bill would go through. So there were some just aspects of the statute that the working group unanimously recommended just be fixed. Section 6 is an example of that. As it was originally drafted, it referred only to 2002 model year vehicles, but it should have been to model 2002 or later motor vehicles. So that is a cleanup of some language. Section 7 clarifies that for model year 2002 to 2017 motor vehicles, the manufacturer has to provide access to the vehicle's onboard diagnostic and repair information system to the same extent that it provides to a vehicle dealer, to owners, and to owner-authorized repair shops. Section 8 corrects what appears to be another drafting error in the citizen-initiated bill. It sets forth three ways that a manufacturer can comply with providing onboard diagnostic and repair information. The original intent, as we understand it, was the manufacturer can use any one of those three methods, but unfortunately there was an and put instead of an or, and so we are simply replacing the and with an or. So to make clear that the manufacturer can choose one of these three different ways. Again, a unanimous recommendation. Section 9 amends the provision governing telematic access to make clear that access must include the ability to both receive data and send commands. And we've also inserted a provision in there that delays effectiveness of this provision until September 1st of 2027. That's certainly something the committee could, on its own, consider whether that's enough time or too much time. Frankly, our view is that this should give the manufacturers more than enough time to come into compliance with the telematics piece. We presume that manufacturers have been working toward that goal since November of 2023, when Maine voters first approved enactment of the right to repair law. Section 10 amends the enforcement provision of the right to repair law. Again, another unanimous recommendation of the working group. It makes clear that the Attorney General is not required to bring enforcement actions upon a referral from the commission, but that it has the ability to do so. And it also clarifies that the Attorney General can seek injunctive relief and civil penalties of up to $10,000 per violation. And finally, Section 11 simply provides for staggered terms for the initial appointment of the commission's members. Again, apart from adding this definition, every amendment in LD 2211 implements a specific unanimous recommendation of the working group. Maine voters spoke very loud and clear that they and their chosen independent repair facilities should be allowed to directly access diagnostic and repair information. Manufacturers should not be allowed to restrict access to that information and force owners to use only authorized dealerships. The amendments to 2211 would make that the amendments that 2211 makes are just necessary to have a workable and enforceable right to repair law. It makes clear that manufacturers can decide for themselves how they are to provide the access. To the extent that there was concerns that this independent entity was going to have control or access to the information, these amendments make clear that that is not going to be the case. Manufacturers will have the ability to decide for themselves how they want to provide access. As long as they provide the access that's required, it's up to them to decide how they want to do that. For those reasons, the Office of the Attorney General respectfully requests that the committee vote ought to pass on this bill and implement the unanimous recommendations of the working group and effectuate the intent of Maine voters.
Thank you. Are there questions from the committee? Representative Collmore.
Thank you, Madam Chair. Thank you for walking us through the bill. Couple of questions. Obviously, the definition was not included in the working group. You've made that very clear. I'd like to know where that definition came from.
That's a good question. I think it showed up in, I don't know. I think I've seen other versions of it. I don't know whether that was something that the revisor's office thought was important, but it makes sense to have that definition.
Could we, for the working group, for the working session, have where that definition came from so that I know what to compare it to?
I can try to find that out. Yes.
Yeah, that would be great. May I? Also, when I go through what you've walked through, section 9, number 6, required equipment is crossed out. In the working group's unanimous agreements, it says telematics. You have owner authorized platform instead. So that is a change as well. I'm just curious about that one.
You're looking at section 9, owner authorization access platform?
Yes, section 9 there, but in the working group recommendations language attached to the working group stuff, it says telematics as the thing. And you've added the date, which you said wasn't part of the working group, but you've added in here and amended a couple of other sections that were not included in the original working group language.
Yeah, so are you talking about just the title of the section that has been changed from required equipment to owner authorization access platform?
No, not just that, but that is one difference between the working groups.
Yeah, there are no substantive changes to the recommendations here. Any language that differs from the recommendations, I believe are drafting decisions that were made by the revisor's office or some other entity. But I can assure the committee that there is nothing in this bill that differs substantively or in intent or spirit from the recommendations, from the unanimous recommendations of the working group.
And I just have one more, if I could. One more question as well. In this amended version that we're receiving here, there is no section that actually crosses out the independent entity. So it looks to me, or appears to me, as if we will have both the independent entity and a commission that has been created. So when I look at the recommendations from the working group one, and bills we've seen previous, that section for the membership and the independent entity was all crossed out, but this bill before us does not cross out that section.
Well, if I understand your question, I believe that this bill repeals the section that created the independent entity.
Okay, so you're repealing the entire section instead of just crossing
Yes,
it out.
it's, and again, that's the drafting convention that I believe was made by people who know more about how statutes should be drafted than we do. But the way that this was effectuated is originally it was sub 2 that created the independent entity. An entire sub 2 has been stricken and replaced with sub 2A, which creates the Right to Repair Commission.
Representative Walker.
Thank you, Representative. To what extent did the working group reference how other states have dealt with this issue?
I'm sorry, are you asking, did the working group
Yes,
reference
did
other
they,
states?
and if they did, to what extent did they refer
Very-
to other states work in this area?
Very limited extent. There was some discussion of Massachusetts, which has a similar law that was enacted before Maine's. But primarily, the working group focused on the mechanics of implementing the statute that the voters had approved. And I don't recall very much discussion about other states. I believe there are other people in the audience that are probably going to be testifying that were involved in the working group. They may have a different recollection. But as I stand here today, my memory is that we didn't really look very carefully at other states' legislation.
Other questions from the committee? Senator Bennett.
Thank you. Could you, I didn't see attached to your testimony, but do you have a list of the people who served on this, on the working?
Yes, it should be in the report that I submitted that's attached.
Was that
Let me just
before?
double check.
Page,
Page 3.
oh, okay, thank you. Thank you for that. The other question I wanted to ask is, you know, this law was enacted by Maine voters about 2.5 years ago. What is the current legal status of the law?
The law's in effect.
Has any action been taken on?
Not that I'm aware of. I mean, there is a private cause of action, so it's possible that there's some private litigation going on, although I suspect there isn't. I can say that our office has not brought any actions under the law as of yet.
And is there any litigation against the state with respect to this law?
Yes, there was a lawsuit that was filed. I have the complaint here. I can tell you I don't know if I can tell you the date, but I believe it was filed last year by the Alliance for Automotive Innovation. It was filed on January 31st of 2025. And there's a couple different claims in the complaint, but what I would consider to sort of be the heart of the complaint is the allegation that automotive manufacturers cannot comply with the law until the independent entity is created. Because according to the manufacturers, and this is just their allegation, the independent entity is in charge of deciding and creating a system for the data to be shared with consumers and with independent repair shops. And so they're claiming here is it would be impossible for them to comply with this until the independent entity has told them how they are to go about sharing the information. This bill makes clear that it's not an independent entity or a third party that's going to be doing that. It is the automobile manufacturers themselves who will decide how they are going to share the information.
What is the current posture of that litigation?
It's been stayed pending legislative action because, in my view at least, and the manufacturers may disagree, but I think that if this bill passes and goes into effect, it will moot either all or at least a substantial part of the lawsuit.
Thank you.
Other questions from the committee? Seeing none. Thank you very much.
Thank you very much.
So we'll move on to take testimony from members of the public. We'll start out with those in favor and in the room, and then move on to those opposed and neither for nor against, and then move on to those online. So first, testifying in favor is Jeffrey Groves.
Morning.
And we do run a clock for public
Sure.
testimony.
Chair Curry, Chair Gear, honorable members of the committee. My name is Jeffrey Groves. I live in Yarmouth, Maine. I was a member of the Maine Attorney General's working group regarding the 2023 referendum that 84% of Maine voters approved. I was the representative in that working group of the automotive aftermarket distributors and retailers. I retired from O'Reilly Automotive as its chief legal officer in 2023, and I am here today to testify in favor of 2211. As Assistant Attorney General Taub mentioned, the working group met 10 times from August of 2024 through final report in February of 2025, and that the group was made up of a cross-section of stakeholders representing the automobile manufacturers as well as those in the automotive aftermarket, in addition to those representing the public interest as well. While we didn't agree on all issues, we did concur on what you now see before you as LD 2211. With one exception that I note, and that is the exception for the provision pushing back the effective date of this legislation 18 months to September the 1st, 2027, for the automakers to comply with what they should have been preparing to comply with since the November 2023 election. It should be noted that the charge of the Attorney General's working group was to convene a group to develop recommendations respecting the establishment of an independent entity, as well as to otherwise implement and enforce the requirements of Section 1810, which is the right to repair law. During the 5 months of the working group, we fully explored the statute, debated not only its language, but also various hurdles to implementation raised by automakers. LD 2211 represents a change from the referendum language in that it does not establish an independent entity with rulemaking authority that the state would have to create, house, and fund. Rather, 2211 creates an unpaid commission to be appointed by the governor, made up of a cross-section of stakeholders, industry and technical experts, and a chair who is a Maine resident representing the public interest. The commission would monitor implementation of the law, informally resolve complaints regarding noncompliance, and would designate experts with technical knowledge and expertise with whom the Attorney General could consult. The commission is accountable to the legislature annually by the way of a report of its activities, compliance with the law by automakers, and to make recommendations to the legislature for proposed changes as may be needed to address issues related to implementation and compliance. In short, LD 2211 represents a fair and measured approach to vehicle right to repair issues where all voices can be heard. Additionally, this charge should also render moot certain issues related or raised by the automakers in the litigation that was talked about just a minute ago with Senator Bennett's question. I support LD 2211 because although it changes some referendum language, it does so in the spirit of compromise, and it leaves intact the provisions that protect thousands of Maine jobs by allowing independent shops the ability to continue to repair vehicles. It allows Maine consumers and car owners to have a choice about who fixes their car and what parts go on that car. And by denying automakers the ability to monopolize and monetize repair data, non-warranty repair of vehicles will take less time and be more affordable for Mainers. Thank you for your time. I'll take any questions.
Thank you. Representative Collmore.
Thank you, Madam Chair. Thank you for coming before us today. You say that there's only one exception to the unanimous agreement, but isn't adding the definition also not a unanimous agreement?
I think that certainly is. I missed that when I reviewed the statute. I only saw that the date was changed.
Okay, so
I prepared my testimony before I heard Attorney General Taub testify about that this morning.
okay, just a follow-up on that. I think I remember that during the working group, as you recall, I was at all of the meetings as well. Even if I wasn't in person, I was virtual. I feel like I remember the group decided that the commission should create all of those definitions, and that was part of the governor's opposition to a similar bill before. Is that correct? Do I remember that correctly?
I'm not sure that you do, and I'm not recalling that myself, so I'm unable to answer that question for you. I apologize. But I mean, as you know, all of those meetings of the working group are on the website and can be viewed.
Other questions? Senator Bennett.
Thank you, Madam Chair. Mr. Groves, good to see you. Just on this question of the date, in your testimony, you said that that was an exception to unanimous agreement. Was it discussed at all? And was it a divided sort of subject, or was it not discussed at all, changing the date?
My recollection of the working group discussion on the date, Senator, was that the date had come and gone and the law had gone into effect, whether or not the Attorney General would enforce the law, because the work of the working group was ongoing and because of other legislative issues, that was certainly out there, but I don't remember that at all.
So I understand the law is now in effect.
Yes.
And what is the effect of actually changing the date forward from currently where it is already in effect?
Well, in my view, what it does is it would change the effective date of the legislation. I certainly people could disagree with my opinion on that, but as I read it, I believe that this changes the effective date of the legislation to September the 1st, 2027, at least in terms of compliance. The automakers would not have to comply until that date, and presumably the Attorney General would not take any enforcement action, or there would be no litigation until that time.
So even though it looks like it's only a part of the statute that's being changed, this is a core piece of the statute, and so that date really governs the rest of the implementation of the statute?
Well, certainly it gives the automakers additional time to comply. Hopefully they have been working on compliance, but the answer to your question, I believe, is yes.
So in your view, is it required to include that date at all?
It is not. I do not believe it is.
Thank you.
Other questions from the committee? Seeing none, thanks very much
Thank
for
you.
your testimony. Next is Tom Tucker. Please go ahead. The
All
floor is
right,
yours.
thank you. Good morning, and welcome. My name is Tom Tucker. I am Vice President of Legislative Affairs for Safe Light Auto Glass, and I'm here just to lend our voice to this issue. Now, I want to start off by saying I have spent the past week trying to figure out what we could say that you haven't already heard. Thank you. Thank you, Representative Julia and Representative Walker. I didn't want to come up and regurgitate things you've already heard, but Safe Light voice has not been in this debate. We've been watching, we've been listening, we're very much a part of it, and we very much support this legislation and the working group's recommendations. Let me simply say two things that I think are different. God bless you. And then I'll take questions and sit down. First, when you change a windshield, you're no longer changing a part. It's a critical safety feature. There's a camera in the windshield. That camera is a forward-facing camera that has to be recalibrated after every repair to ensure that your safety systems on ADAS, automated driver assist systems like lane assist, park assist, crash avoidance, it's the equivalent of a recalibration is nothing more than the equivalent of resetting your phone or your computer. I think we all have the situation where you're trying to get to work and your system doesn't work, you got to recalibrate or you got to reboot it. Well, that's what a recalibration is. It's a rebooting of your systems. Without the recalibration, your safety systems don't work. That affects every main motorist, every repairer, because if you're not recalibrating, you're sending the consumer out in an unsafe vehicle. That affects all of us. And in order to do the recalibration, you have to have the appropriate tools, access to that data and information that you get from the vehicle manufacturers. Clearly, this industry is big enough that we can all work together to find common sense solutions, because if you think about it, we're all talking about the same people, customers, your constituents. They want their cars repaired. You want to provide good service. The OEMs and dealers want to provide good service. We all want that. But let me close with this. Every day, there are more than 14 million ATM transactions in the US. 14 million. Cybersecurely transmitting data so that you can get money in any ATM across the country. Clearly, with this issue, when you talk about cybersecurity, we can transmit data in a way that's cyber secure so that repairers can get the data they need to successfully repair a vehicle. I want to close with that. There's not much more to say. You've heard it all. So with that, I'll end, and I'm open to any questions you may have.
Thank you. Representative Collmore.
Thank you, Madam Chair. Thank you. I actually didn't have any questions until you talked about cybersecurity. There's nothing in this law that protects security of the consumer's data. And I'm happy if you've been able to successfully use your ATM card anywhere in the world and never have your data hacked, but I've had mine hacked. I am actually getting free monitoring of my credit reporting right now because my information was hacked for something I thought was safe. So what I'm really concerned about when we're talking about the cybersecurity side of this is what are our guardrails? What are the guardrails to ensure that my data on my vehicle, so that my lane assist, I have one of those vehicles, so that my lane assist is not going to be hacked by somebody and then my thing thinks the lane goes into the tree?
Absolutely. It's a great question. I think, let me answer it this way. The vehicle manufacturers have a obligation through federal law to provide a cyber secure vehicle. Clearly, they're able to securely deliver the data that they already have to the dealers in their franchise network. What this legislation only says is that make it available to the independents. I think they have a way to do that. Now, I'm not an expert on that, so I can't get into the details. So I'm not the expert, but I believe they can do it. And clearly, with our ingenuity, our expertise, and while cybersecurity standards are always changing, we know that because you've been hacked, other people have been hacked. A vehicle hasn't been hacked like that yet. And I think because of the vehicle manufacturers are always working on their cybersecurity, I don't want to speak for them, but clearly they deliver that information to the franchise dealerships in a safe and secure manner every day. So if they're already doing it, clearly they can do it to the independents.
Other questions from the committee? Seeing none, thanks very much for your testimony.
Thank you very much.
Next, we have Bill Bell.
Morning, Senator Curry, Representative Garrett, members of the committee. My name is Bill Bell. I'm a resident of Saco and the executive director of the Maine Auto Recyclers Association, which is a standard trade group. And we have worked with the legislature and the state government on a number of issues. One of those was years ago, we worked with the Environmental Committee on Maine being the first state to have its own program for mercury switch recycling. And our model became national. Our industry participated in what became a national training movie on this. And we also more recently worked with the Transportation Committee on having a strong law on catalytic converter recycling or marking in Maine and how we recycle them. And as you know, you probably heard Representative Walker from Ovid on this issue. And our members were not happy with it, but we understood the need to work constructively on it. And there, for a number of reasons, are a lot fewer catalytic converter thefts in Maine now. I was not a member of the working group, but I attended virtually all of the sessions. And I can say to you, as previous speakers have said, folks worked with integrity. They worked with a sense of compromise. Nobody gets everything they want, but it was a very, very serious and painstaking, and the Attorney General's office did an excellent job of leading that committee. I will deviate from my prepared testimony, which you can probably anticipate what it says, to address a couple of the questions here. And first, at risk of dating myself, I was a member of the Maine Senate staff when the bottle bill was written and went out to referendum. And a lot of the kind of, oh, do we really have to do this, was heard in the Maine legislature, which did not vote for the bottle bill until it was passed by referendum. And the Senate Minority Leader, on whose staff I was a member, got up afterwards, and when the legislature convened after the referendum, and welcomed everybody to St. Mary's Church up there for acts of contrition. My point is really that sometimes being first is not a welcome position, but it's something to do a good job on and do what Maine citizens would like. And in answer to Representative Walker's question, why are there other states which have embarked on this? And the answer is, with the exception of Massachusetts, no. So my question, and I attend some of the meetings of the National Auto Recyclers Association. Maine was chosen by the sponsors of this effort basically because of who we are in Maine. We are a rural state. People have a long way to travel if they have to go to the dealer where they purchase the vehicle, but they do have a local garage.
Mr. Bell, your time has expired, so if you could wrap up your
Okay.
comments, that would be great. Thank you.
And so that, I think, answers your question. It's why Maine is a very good state to be dealing with this, and I commend the Attorney General's office and the working group for the work they put into this, and I hope that you will follow. Thank you.
Any questions from the committee? Seeing none, thanks very much for your testimony today. Next, we have Clara McConnell.
Good morning, Senator Curry, Representative Gear, and honorable members of the Joint Standing Committee. My name is Clara McConnell. I am a government affairs consultant at Main Street Solutions, and I'm here today representing LKQ Corporation. We're testifying in support of LD 2211. LKQ Corporation has 50 employees in the state of Maine at 3 facilities in Gorham, Bangor, and Gardner. LKQ is a leading global provider of alternative and specialty parts to repair and accessorize automobiles and other vehicles. And you can read more about what the company does in our written testimony. As you all have heard many, many times since November 2023, Mainers voted for the right to repair their vehicles at a repair shop of their choice by an 84% margin. You've also heard then that in 2024, the legislature passed a bill to bring together a balanced working group led by the Attorney General's office to recommend changes to the referendum statute. LKQ didn't participate as a member on the working group, but we observed all the meetings and followed along with the entire process. As evidenced by the past 2 years in Maine, automotive right to repair is a complex and contentious policy issue. That's why it was so important that the legislature chose to pull together a balanced group of stakeholders to deliberate and arrive at consensus recommendations. While none of the stakeholders were completely satisfied with the outcome of the working group, isn't that the definition of true compromise? From our vantage point, the working group completed its task in a thoughtful and responsible manner, and the consensus recommendations will allow Maine to implement the law, monitor the implementation in the coming years, and then decide if additional adjustments are needed in the future. The working group recommended the creation, as you've heard, of an independent commission, and it also reached consensus on numerous language changes to the existing statute, all of which are designed to provide our state with guidance, implementation standards, and complaint resolution, as well as make recommendations for best practices for manufacturers in providing access to vehicle data. Importantly, the working group decided that the independent commission will not be a repository for any data, nor will it collect or transmit data itself. It's possible that in future years, as we better understand how Maine's automotive right to repair law is playing out on the ground, there may be additional questions that need to be answered. For instance, how will manufacturers choose to share diagnostic and repair data in accordance with the statute? Should there be some sort of standardization across manufacturers? The commission created by this bill will surely have additional policy issues to consider in the coming years, and their role in advising the legislature will be critical to the ongoing success of this law. For now, we feel that the passage of LD 2211 is the appropriate next step in implementing the automotive right to repair law that 84% of Mainers supported. So we urge you to support this bill, and we thank you for your ongoing thoughtful consideration of this issue.
Thank you. Are there questions from the committee? Representative Collmore.
Thank you, Madam Chair. Thanks for coming before us. One of the things that I found most interesting, especially after being at all of the working group things and their fact that they were not included as part of the original bill language, is why would we want the aftermarket parts and distributors to be part of a commission that decides the best practices for how my vehicle generated data is accessed? Because that is not the world you live in, and I'm not exactly sure what you would have, not you personally, but that industry would have to say about my data.
Since LKQ wasn't a member of the working group, I can't speak to why the decision was made on the membership of the independent commission, but I'd be happy to go back and speak with my client and bring some information back for the work session on that topic.
That would be great. Thank you.
Other questions from the committee? Seeing none, thanks very much for your testimony today.
Thank you.
Is there anyone else in the room who wishes to testify in favor of the bill and is not signed up? You could introduce yourself while they're getting the materials.
Great to see everyone again. My name is Tommy Hickey. I'm the director of the Maine Automotive Right to Repair Coalition, which represents local independent repair shops and parts stores. Chair Curry, Chair Gear, members of the committee, I'm also testifying today as a member of the Maine Right to Repair Working Group created by an act of this legislature last session, an act many of you yourself advanced. Led by the Attorney General's office, the working group included representatives for the automotive aftermarket, car manufacturers, auto dealers, consumer groups, and data privacy advocates to assemble a technical, balanced forum to evaluate the law and recommend, if necessary, practical changes while also serving as a resource for implementation. With the exception of the new effective date, those unanimous recommendations are before you now as LD 2211. This bill respects the clear will of the Maine voters who supported the initiative by 84% in 2023 and reflects the consensus we reached across all stakeholders. Here is what LD 2211 solidifies and clarifies. Consumer choice and affordability. Mainers voted for full direct access to their repair information so they can choose affordable repair options. Independent shops, parts stores, and equipment dealers are core to Maine's communities. LD 2211 keeps repair work and jobs and local revenue that comes with it right here in Maine. I've been a part of this issue since 2008. I have visited countless independent repair shops and heard stories of shops and consumers not being able to make a repair on a vehicle and being stuck at the mercy of car manufacturers. That is why folks here in Maine voted so overwhelmingly in support of the right to repair. It's their car, they bought it and they want to have access to their own repair information to fix it. With that, sure you guys are sick of looking at me and talking about this issue, but I'm happy to answer any questions.
Thank you. Questions from the committee? Representative Collmore.
Thank you, Madam Chair. Thanks for being here in Maine again from Massachusetts. I know it's a long drive for you. Can you direct me to where I can find information about the Maine Automotive Right to Repair Coalition? Because I cannot find a website for you guys. It used to exist. I don't know where it went.
I'm happy to give you information on who's a part of our coalition.
That would be great if we could have that. Thank you.
Other questions from the committee? Seeing none, thanks for your testimony today. Is there anyone else in the room who wishes to testify in favor of the bill? Okay, so we'll move on to testimony of those in opposition. And first we have Elizabeth Frazier. If you could introduce yourself, and we'll make sure we have the right person to.
Thank you. We got going to the bench here. Good morning, members of the committee. Thank you for the opportunity to present to you today. My name is Wayne Weichel. I'm here on behalf of the Alliance for Automotive Innovation. We are a DC trade association that represents the automakers, automotive suppliers, and other automotive technology companies. I will start where I started my first testimony on the first hearing on this issue back in 2023, with an apology to repairers in the state who have had lobbyists paid for by aftermarket part manufacturers and retailers in their ear for years, telling them that without the ballot question, you won't be able to fix cars. As we've discussed previously, automakers support right to repair. We want all vehicle owners to have a good repair experience. In addition to supporting LD 1228 here in Maine last year, we're also pushing a similar effort at the federal level with even more repair and consumer protections. I would also like to apologize to this committee, to Chairman Geer and Chairman Curry this year, to Chairman Curry and Representative Roberts last year, to the members of the committee both sessions, and especially to Representative Roberts and Collmore, for all the time that you have invested in this issue to wade through the misinformation and yet still find a way to put forward bills to actually help repairers in this state. I've been working on this issue for 15 years, and I really thought LD 1228 was going to be the model that permanently solved this issue once and for all. But it seems that political forces largely from outside the State House have pushed us back to square one, with a bill that is again telling automakers how to design and build technology. And with all due respect to Mr. Taub, it's telling you not just what to share, but how to share it. If you were at this hearing on this topic last April, you may remember Chairwoman Geer asking about the graphics on the back of this handout. This is what Section 6 of LD 2211 is talking about: direct access. It uses the word 4 times in one paragraph. Direct access means this bottom image, where third parties have direct access to vehicle systems, not just to receive data, but also to upload data. I won't read them to you, but on the back of that page, I've put some quotes that you have seen before from the National Highway Traffic Safety Administration, from the Department of Justice, from an MIT cybersecurity researcher, all showing what they have said about the exact direct access model used in LD 2211 and the ballot question. You all know this. This is why this committee put forward LD 1228 last year. The cybersecurity concerns didn't just go away because it became politically inexpedient. And passing LD 2211 won't make them go away either. Passing LD 2211 moves repairers in this state no closer to a functional right to repair law. All this does is seek to mirror a Massachusetts law that's been tied up in federal court for 5 years and counting. I'm sorry that this issue has taken so much of this committee's time, but LD 2211 is not the answer to make it go away. I'm happy to take any questions.
Thank you. Questions from the committee. Representative Collmore.
Thank you, Madam Chair. Thank you for making your long hike even further from DC, right? Do I
Correct.
remember that correctly? Yes. What I am curious about, you heard, I'm sure, the question I asked of the Safe Light representative that was here when the cybersecurity was compared to ATMs, and how we can transfer that data securely, and it's okay. I'm sure many of us in this room feel otherwise if we've had our data hacked. How does this model that you're showing for LD 2211 with the direct access versus the model that you show above for the OEM cloud-based service model, how do those relate potentially compared to that ATM? Because we all live in an ATM world now, unfortunately.
Sure. I'm certainly not an expert on banking law, but I can speak to the analogy of, well, they're providing it to dealers safely. They must be able to provide it to independent repairers. Yeah, that's the top issue. The only connection to the vehicle is through OEM servers. So if they want to hack your vehicle, they have to hack the OEM server first to get to it. There's no direct connection to the vehicle. The bottom image, each of these have direct access to the vehicle. That means, I've used this analogy before, but a few years ago, there was a Target hack. And how Target was hacked was because an AC contractor, air conditioning contractor, had kept an open signal into an AC unit at one store. And they hacked the AC unit contractor to get to Target. It's the same thing here. Every single one of these connections, every single repairer will now be a potential hack site, because now they can hack the repairer. If the repairer has direct access to the vehicle, they can get to the vehicle that way. That's what all this, I mean, the quotes on the back of this are as compelling as I think you could possibly come up with. It will make a substantial safety risk for American families. Like, that's it. That's what we're talking about. Everything else that you've heard about automakers wanting to provide information, not wanting to provide information, the data pathway is the whole fight. The whole thing comes down to this. Automakers are happy to find a way to provide information to independent repairers as long as they control the data pathway. And NHTSA wants it that way. NHTSA wants someone to blame. Look at that bottom image. If a car gets hacked, who do they blame? Do they blame the repairer? Do they blame, others who have access? They're not responsible for cybersecurity of the car. Who's responsible? That's why NHTSA wants automakers responsible. So they have someone to blame.
Other questions? Representative Walker.
Thank you, Madam Chair. The safety concern that you're bringing up is not created by this bill. This safety concern, tell me if I'm right.
Yep.
Already exists with existing legislation. Is it true?
Correct. It's multiplying it. One connection versus any number.
Senator Bennett.
I'm sorry, your name again is?
Wayne.
Wayne what?
Weichel.
Wayne Weichel, thank you. I'm a little confused because I guess Elizabeth Frazier was your representative.
Correct.
On the, correct? What?
Yes. She was our representative on the AC.
Are you going to anticipate all of my questions?
I would be playing the lottery if I did. Apologies.
Thanks. So she was your representative on this group, and she agreed to unanimously. Do you dispute anything except for the date maybe and the definition? She, representing your group, agreed to all of these recommendations?
Yes, because the commission was given a very tailored task to look at the entity, this independent entity, which everyone agreed was a ridiculous idea. And everyone agreed in this report that, yes, it was a ridiculous idea. What the commission was not charged with is looking at the rest of the bill. And numerous times during the 10 meetings, Elizabeth, who was our representative.
May I just interrupt?
Sure.
I'm just looking for a quick answer to that. I guess the question I have is, it seems in your testimony, you're trying to relitigate the underlying litigation, the underlying legislation, which your organization is now litigating in a separate venue. And I'm wondering, why is it that you're opposing this legislation after agreeing to it unanimously with maybe a couple of I would assume that you may not like the definition, I don't know, but maybe you like the pushing of the date out a little bit. I don't understand why you're opposing this
Great,
legislation.
I'm happy to explain it. The commission looked at one issue. This bill has multiple issues in it. If the commission was given a task of looking at the entire law, it may have come up with a different report, but the report it was blocked just to the entity.
So
And we agree
why
that the
do-
entity was a bad idea.
So why do you oppose this bill? Or is it that you're just using that as a mask to oppose the entire right to repair issue?
Sure, because the commission was not tasked at looking at section 6. Section 6 are the images there. If the commission was actually given broader language to look at the data pathway, we would have a different conversation and a different report coming out.
And if this legislation passes, what does it do to the posture of your litigation against your customers, the people of Maine?
Sure, that's a great question. I understand that the AG's office would like to see this legislation passed because it would change the arguments of the pending court case. We've allowed them to not respond to our case, waiting to see if the legislature found a solution that was sufficient. But here's the thing. It may obviate some of our arguments. And I understand Representative Collmore from the beginning has hit this one point of not want to see tax dollars spent defending a case that this legislature didn't pass, a bill that this legislature didn't pass. But in making these small changes, the existing case is real simple. It says the AG must appoint the entity must make rules, and the automakers follow the rules. So when you get rid of the entity, then all that kind of goes away. But what this bill is actually doing is making your law a lot more similar to Massachusetts, which has been in a much bigger lawsuit that's been going on for 5 years and way more expensive.
Are you suing there too?
We are.
Thank you.
Other questions from the committee? Seeing none, thanks
Great,
very much.
thank you.
Next is Bruce Garrity.
Senator Curry, Representative Gear, members of the committee, my name is
Mr. Garrity, do
Bruce
you have
Garrity.
testimony to distribute or?
No.
Go ahead, thank you.
My name is Bruce Garrity. I'm here on behalf of the Maine Automobile Dealers Association, which is all of the new car and truck dealers in the state of Maine. Let me start by saying I was kind of puzzled why the Attorney General would say, how could anyone possibly oppose this legislation, given that you have litigation in 2 different states and 2 12-to-1 reports by this committee over the last several years trying to fix parts of it. So why anyone would say, geez, this is so obvious, why would you oppose it? That escapes me. Let me directly relate to some of the provisions in the legislation. We are concerned with, on page 3, lines 31 through 35, that essentially say that the manufacturer has to provide the owner or owner-operator information to the same extent that access to a vehicle's onboard diagnostic and repair information, that's new, is provided to a new vehicle dealer. Please compare that to line 1 of page 3, which specifically says that that information is available for purchase under fair and reasonable terms. Why now suddenly do they get it for free or get it on language that at least is not clear? They are not entitled to that. If they want to get that information the same way a dealer gets it, go through the training, go through the education, go through the manufacturer protocols and requirements, get the same cybersecurity protections, get the same computer protections. But I think this is just sort of a totally different standard in terms of let's have it for free. I would reiterate the comments made by Mr. Weichel. Let me also refer you to page 3, line 8. Third word in is appropriate for, you start talking about appropriately licensing, contractual confidentiality agreements, and so forth. And it doesn't say anything about how stringent that should be in terms of protecting cybersecurity. if the committee wants to move ahead with this legislation, I would urge you to look pretty carefully about how stringent you should be. And I think appropriate licensing is both vague and opens you up to a problem. If you go to page 2, lines 22 through 24, it basically says that the commission may solicit input from stakeholders or other interested parties regarding privacy issues. I found it interesting that that was the last provision related to the commission's responsibility, and it tacks on, gee, if you get the time, look at privacy issues, as opposed to making it a highlight of what has to occur. That concerns us, and in our view, really discounts the importance of privacy. Last, and I appreciate your consideration. Let me say one more thing, Representative. If you look at page 1, line 34, it says one member representing aftermarket parts and distributors and retailers. Why are they even in this? They sell stuff. They retail stuff. They want to sell their own products. What does that have to do with being able to get your car repaired in terms of the data that has to be shared? There's no need for it, and it's yet another source of trouble. Again, Representative Gear, I appreciate your indulgence, and I'd be happy to try and answer any questions the committee might have.
Thank you. Questions from the committee. Representative Collmore.
Thank you, Madam Chair. So that part on page 3, the model year 2002-2017 vehicle year, where they've added in access to onboard diagnostic and repair information, which is different from the working group language. We heard that that is just fixing the way things are written, but as you are seeing this, it's not just fixing it, it's a substantive change from what the working group recommendations were?
Very much so.
Okay, thank you.
Other questions? Senator Bennett.
Thank you, Madam Chair. Mr. Garrity, good to see you. I just want to explore a little bit further on where Representative Collmore is going. You had a representative on the working group, yes?
Yes.
And are these objections, I see some of them are maybe just like the way that the bill ended up being drafted, are different from those conclusions, or were they things that you believe were not part of a good faith effort to come to a unanimous report? I mean, what's the issue here? Maybe there's different standards for each of your objections, so.
Let me make a couple of comments, and thank you for the question, Senator. First place, I can at least say for the Auto Deals Association and their representative, who's a fellow named Jack Quirk and owns a number of dealerships in Maine, he certainly acted completely in good faith in his participation in this program. I do think when you look at the legislation, and that's all I have focused on. I didn't try to go back laboriously through the history. I'm looking at the words on the page and the changes that are being proposed in this bill. And I think they're different from what the report came out with. I think there are add-ons to it. And I think that as a practical matter, we still end up with the problems, as Mr. Weichel said, related to what was Section 6 of the bill that got out 12-1 until it was vetoed by the governor.
So just on this specific, if I just make one thing, one of your objections is the member representing aftermarket parts manufacturers?
Yeah, distributors and retailers.
Yeah, was that something that you all agreed to in the working group, or is that new?
Well, it wasn't anything we had to agree to in the working group. There was a representative of that industry on the working group. And so, of course, they tucked themselves into the commission. I can understand why they'd want to do that. What I don't understand, Senator, is why they have a dog in this fight at all, other than they want the information to get their own parts, to get the information so that they can use it for their own purposes, which have nothing to do with repairing the vehicle.
Okay, just let me follow up a little bit. So I just want to make sure I understand this. The working group made a recommendation to create the Right to Repair Commission.
Right.
And was there not, it's not just an extension of the working group, but I'm wondering, did the working group go down to the level of actually specifying this membership of the Right to Repair Commission? And was that a unanimous recommendation?
They did tunnel down to that, and frankly, I believe that one might have been unanimous.
Okay, all right. I'm just trying to understand where the differences actually are. So thank you very much.
Yeah.
Thank you. Any other questions? Seeing none, thank you. for
Thank
your
you.
Testimony. Is there anyone else in the room who wishes to testify in opposition to the bill? Seeing no one, we have then those testifying neither for nor against. First is Dan Riley.
My phone says do not disturb.
Might want to take that one, Representative.
Please go ahead.
Thank you. Chairs and members of the committee, my name is Dan Riley. I'm an attorney with the firm in Norman Hanson, Detroit here in Maine. And I appear today as outside counsel to the Truck and Engine Manufacturers Association. Your clerk is going to give you 4 different pieces of written testimony. And you can take a look at those. I'll go over them very briefly because not all of the individuals who drafted those documents will be able to appear. Patty Hans, who is inside counsel at the Truck and Engine Manufacturers, is planning to testify remotely. So you'll hear from her. And most importantly, I do have an expert witness for you, Mr. Larry Cobb from New England Kenworth, who will testify after me. Those of you who were at the hearing last year on LD 1228 will remember his testimony. So without spending any more time on this issue, I'll just remind you that in LD 1228, the bill that was reported out of committee and then vetoed by the governor in January, you exempted the commercial trucking industry. The majority report exempted the commercial trucking industry. And I remember very clearly, Senator Curry, you were the one who made the point at the last work session that you had been convinced by the evidence that commercial trucks and that industry were very different in so far as the repair process is concerned. I'll just point out a couple of things. One of the reasons that I won't presume to know exactly why you came to that conclusion, but I'll just remind you of a couple of the distinctions. Number one, commercial trucks are purchased in business-to-business transactions. They're not individuals going in, they're businesses going in and buying the trucks from somebody like Mr. Cobb. Second, commercial trucks are not built by a vertically integrated process. So very different than light duty trucks like my Chevy pickup or a passenger car, that all the component parts come from the manufacturer. Commercial trucks might have a Cummins diesel in them or, a dump truck on the back of them, and they all come from different manufacturers, different OEMs and originating equipment manufacturers. So those two differences, I believe, are the major reasons why you should look at this industry differently and do what you did last year in LD 1228 and provide an exemption from the commercial trucking industry. With that, I'll ask you to just review the testimony and reserve the technical questions for Mr. Cobb, who knows a lot more about it than I do.
Thank you. Representative Collmore.
Thank you, Madam Chair. Was the heavy-duty vehicle industry part of the working group?
No, we did not have a representative. I did talk to Deputy AG Taub when the working group was being compiled, and he indicated that he felt like the law was, and this is not hearsay, that this is just a conversation between the two of us. He indicated that he didn't think the industry needed to be represented because the law passed by initiated referenda was focused on passenger vehicles and light duty trucks. I did testify at the final public hearing that you'll remember you were there, and pointed out that the working group really spent no time on understanding how the initiated law would apply to the commercial industry. And so the working group added representatives from the commercial industry to the commission idea, but we were not represented in the 10 meetings.
Other questions? Senator Bennett.
Thank you, Madam Chair. I don't know, sure, this is a legal or a technical question. Maybe it's better for Mr. Cobb, but is commercial truck defined in law?
Yeah.
And so it's clear that it's not like my Toyota Tundra.
Correct.
Where your light duty truck.
I promise you that
Okay.
Sophie knows how to do it because she did it last year in LD 1228.
Oh, so it's already a defined term though, commercial
Right,
truck.
correct.
Okay. Okay, and I also see, and I know that you don't represent them, but we also have testimony in here that the motorcycles want to have an exemption too. Is your understanding that this law is really, I mean, is this just a kind of a protective motion here that you're trying to get this this carve out, or I mean, is there clear coverage of commercial trucks in the automotive right to repair law in your view?
It is an open question up to a point, and the reason, and I'm not going to spend a lot of time on this, Senator, but the reason that you as a committee have had so much trouble with the initiated law is because it was terribly drafted for purposes of Maine statute. And if you remember, there literally was no definition section in the initiated legislation, the initiated law. So when you got this mess presented to you the very first time, and you know, Deputy AG Taub had a problem because the initiated law didn't make sense for purposes of Maine law. And I remember Sophie telling the committee at the first work session, there's no definition section. You know, you've been in the legislature in and out for a long time. Every bill, the section 1 is the definition section.
Yeah.
That's the problem. It just was not drafted in such a way to work within Maine statute.
All right, thanks.
Any other questions from the committee? Seeing none. Thanks very
Thank
much
you
for your
very much.
testimony today. Is there anyone else in the room who wishes to testify? Oh, I'm sorry. We have one more. Larry Cobb, please.
Good morning.
Go ahead.
My name is Larry Cobb. I'm the general manager of New England Kenworth. We're a franchise dealer for Kenworth trucks in Maine, New Hampshire, and Vermont. We employ 85 people in Maine, and I have lived in Maine all my life. I don't represent Kenworth Truck OEM. We are a dealer selling and servicing the Kenworth product. Last year, as Dan said, I testified in front of the same committee to exempt commercial vehicles from right to repair, and you folks all agreed. The right to repair is asking for an information platform that doesn't exist in the commercial truck industry to comply with the right to repair rules. As an example, showing the apple and orange differences between the consumer auto industry and the commercial truck industry, using a Ford F-150 as an example, the information to repair that F-150 can be a printed book or a downloaded file. It will cover several years of production and thousands of VIN numbers because the automobile is vertically integrated. If you look at a commercial truck, this can be a Kenworth, a Freightliner, a Mack, Western Star, whichever OEM. If you wanted a repair manual for the diagnostics to repair that truck, you can acquire the repair manual or download the file, but it's only valid for just the one VIN number you just looked up. It does not cover any other Macks or Freightliners or Western Stars. That's because the commercial truck is custom ordered from different OEMs that make up that one vehicle. A commercial truck custom designed to haul logs on the Golden Road is a completely different truck than a truck designed for Hannaford Brothers to go up and down 95 bringing groceries. Each truck is completely different than the last one that we worked on. So that shows you that the platform to receive this information to repair this truck doesn't exist. The truck purchase as well as the truck repair is a business-to-business transaction and not a consumer transaction. Right to repair already exists in the trucking industry. As an example, if you buy a Kenworth truck from me and you need your Cummins engine repaired, you don't have to come back to New England Kenworth. You can take it to Freightliner of Maine, O'Connor, Volvo, Western Star, Whited Peterbilt, or independents like Greeley's in Auburn or the Big Rig Shop in Oxford. You can have them take care of the Cummins issue, as well as the DOT inspection items, suspension and transmission problems. You don't have to come back to me. Telematics and over-the-air diagnostics will be lost if right to repair doesn't exempt commercial vehicles. The reason why, on the computer or smartphone, the telematics shows you where the truck is, the route that it has taken, how fast it's going, as well as the VIN number and important other truck-specific information. This vehicle information creates a targeted hijacking possibility and driver's endangerment. The truck OEMs want the truck owner to have this sensitive information and no one else other than the people he or she chooses. An independent repair garage can be one of the people that the owner designates for the telematics information. The truck OEMs don't want the risks of this sensitive information falling in the wrong hands and endangering the driver or the load. They'll just turn it off. To sum up, please reinstate the right to repair exemption for commercial truck industry because the truck owner already has many choices to repair their truck. We will lose telematics feature for the truck owners in Maine, and a single platform to all the information about all truck VINs doesn't exist because the truck VIN only covers the custom component OEMs that make up that one truck. I'm happy to answer any questions or give you examples of what telematics does for the customer or anything on your mind.
Thank you. Representative Collmore.
Thank you, Madam Chair. On the telematics side for the heavy-duty commercial vehicles, you said that it's very specific to each VIN number, which I seem to recall from before. Something that we've heard about with motor vehicles is that there's already options to wirelessly connect, like Tesla, for example, can do a wireless update. Is that something that also exists in the heavy-duty truck world, where that can happen and then repairs can be done through that wireless connection?
Thank you. Yes, that's exactly right. The over-the-air diagnostics can be done. Some of the parameters for the vehicle can be changed, a maximum speed or an idle time or something like that. And also a computer programming update. The engine's computer or the transmission's computer may require an update like any other computer, and that can be sent over the air. Yes, that is correct.
Thank you. Actually, I have a question.
Yes.
How does that process differ for a situation where you might have let's say a logging contractor that operates one truck versus an entity that uses some sort of fleet management system? Is that process the same no matter how many trucks are involved?
Yes, thank you. When you purchase a Kenworth or a Freightliner or a Mack, it doesn't matter. All the OEMs have their own program. You buy one truck from me, you have access to the telematics. We call it Truck Tech Plus, and you can go onto your computer or smartphone and you can see exactly where your truck is. You can also see the check engine light when it happens and what it is. And it'll also give you some recommendations as the closest facility to get that repaired. So it doesn't matter if you're buying one truck or 100, you have that as part of the truck purchase. That's not an option. You get it.
Thank you. Any other questions from the committee? Seeing none, thanks very much for your testimony today.
Thank you very much.
Is there anyone else here today who wishes to testify neither for nor against the bill? There's someone coming. And is there anyone else in the room who wishes to testify in any disposition on this bill today? Thank you. After this testimony, we'll be moving on to our online folks.
Good morning, Representative Gear, Senator Curry, members of the Committee on Housing and Economic Development. My name is Brian Park. I am the President and CEO of Maine Motor Transport Association and a resident of Brunswick. The association is comprised of over 1,900 member companies whose employees make up a large portion of the almost 34,000 people who make their living in the trucking industry in Maine. We're testifying neither for nor against, but LD 2211, but to support the notion that commercial vehicles should be excluded from Maine's right to repair laws. And in the interest of time, we would like to adopt the same positions for the same reasons as Mr. Riley and Mr. Cobb, and would offer one additional answer to Senator Bennett's question about the definition of commercial motor vehicles. I brought the law. I'm sure your analyst would be able to get it. It's certainly something that we're familiar with in Title 29A in the definitions section, subsection 17.
Any questions from the committee? Seeing none, thanks very much for your testimony. And so we're going to move to our folks. We have 2 folks online to testify, and if you could promote the first one. Please go ahead. You are at the virtual podium. If you could introduce yourself.
Very good. My name is Patricia Hands. I am with the Truck and Engine Manufacturers Association. And first, I'd like to thank you, Senator Curry, Representative Gear, and honorable members of the Joint Committee on Housing and Economic Development for this opportunity to testify. As you have heard, and you heard last year and you heard in previous testimony, the Truck and Engine Manufacturers represents the leading manufacturers of commercial and heavy-duty vehicles, internal combustion engines, and zero-emission powertrains. We design and produce vehicles and equipment with a gross vehicle weight of greater than 10,000 pounds. So to answer Senator Bennett's question, yes, commercial vehicles do have a very specific exemption definition, and that definition was used in LD 1228. We are here to request that the committee amend LD 2211 to include the commercial vehicle exemption that was passed by the committee in LD 1228 last year for the reasons stated below. The differences between the commercial and heavy-duty vehicle market are significant and can't simply be overlooked or simplified. It is a non-integrated market. Commercial vehicles are custom built. They are manufactured and serviced differently than passenger vehicles. And we do not believe that the Maine right to repair law was ever intended to apply to commercial vehicles. The discussion and focus has always been on fast passenger cars. One of the reasons for the difference in the markets is the fact that these are business-to-business transactions. This is not a consumer who goes to lots to look for and choose a vehicle. This is an individual who goes to a dealer and picks out literally hundreds of different options and builds a vehicle for their specific use, and is counting on an extended service network that already exists to be able to keep that vehicle on the road on a daily basis, because if that vehicle isn't on the road, it impinges their ability to earn a living. So it's a service network that has existed and will continue to exist without inclusion in the right to repair law. The difference between the passenger vehicle market and the commercial vehicle market is one that's recognized in the marketplace and also in state and federal government. For instance, the federal government treats commercial vehicles very differently than passenger cars for safety concerns and for operational concerns. And some of those operational concerns relate to how the vehicles are used in conducting work, and specifically concerns related to cybersecurity. We are concerned with hacking, and it is well known that commercial vehicles are often targeted for theft. And so it's very important to our operators that the security of the vehicles is maintained.
Ms. Hans, your time has expired. If you could wrap up.
So with that, I was going to conclude. If you have any questions, we'd be happy to answer those for you. If they're technical questions, obviously, Mr. Cobb is probably the best person to answer those questions, but I'll be happy to take any questions you might have.
Thank you. Are there questions? Representative Collmore.
Thank you, Madam Chair. Thank you for testifying before us. We have your printed testimony in front of us, and I have two questions on it. One is the third page at the bottom, you say we're opposed to the bill unless amended. So are you opposed? I just want to clarify the stance you're taking. You're opposed or neither for nor against on this bill?
We are requesting the amendment. We do believe we would oppose the bill unless amended. As pointed out by the Alliance, the working group was convened primarily to deal with the independent entity situation. And while the working group it did deal with that, there are a myriad of other issues associated with the law that would make it problematic. Obviously, if the commercial vehicles are exempted, it's not problematic for us, but it still continues to present an issue for the automotive market.
Okay, and then my second question. And the letterhead on here says the address is Chicago, Illinois. Is that where you are located?
It's where the trade association is located, yes.
Okay, thank you.
Other questions from the committee? Seeing none, thanks very much for your testimony today. And then we also have online Donnie Cipher. And is there anyone else after that? And then one person after that. We can see you on the screen, so please go ahead.
Good almost afternoon, and thank you.
We cannot hear you, though.
You cannot hear me. That's unfortunate. Let's see.
Still cannot hear you.
Did this improve the situation?
There you go. Now we can hear you. Welcome and please go ahead.
Lots of microphones here. Good morning. I'm Donnie Cipher. I'm the Executive Officer for the National Automotive Service Task Force. We were formed in 2000 as a solution to right to repair concerns. I'm going to paraphrase some of my testimony because I gave it to you in the interest of time and potentially answering questions, but we're a 501c6 not-for-profit. We serve professional service technicians in service repair, collision, and locksmithing. I've been involved in right to repair efforts for over 25 years, including presenting to this body and teaching technicians in your state the effective use of service information in the past. I've been a diagnostic technician, shop owner, a trainer, industry volunteer before I came to serve in this role of supporting technicians across the United States and Canada. Our mission is simply to identify and resolve gaps in service information, tool information, and the availability as well of that tool information, NOE tools, pardon me, as well as education information. For 25 years, NASTAF has resolved literally thousands of requests on behalf of technicians. Some of them were legitimate gaps in service information. Some were just situations where the tech didn't know where to look. And we're able to support both of those issues and provide assistance for our 54,000 members in the US and Canada. And that includes 238 in your state. In 2008, NASTAF and the automakers signed an agreement known as the Automotive Service Information Standards Agreement that in essence extends the EPA regulations for light-duty vehicles to all vehicle systems and further states that automakers will make all the same information and tools that they offer to their franchise dealers available to aftermarket repairers. Our process that's part of this agreement involves what we call a service information request, where a technician can come to us and say, I can't find this information, it's unavailable. Many of the things that we deal with today, if not most of them, are related to IT-related issues. Broken software systems, communication issues between them, more detail in the testimony that I provided. Mainly what is involved these days is all of this IT related stuff. We don't see a lot of service information related problems anymore. We also host this portal where the technicians can make requests and upload their information to us on a public portal, diag.net, and that's available so that you can see it. The link is in my testimony. So the mediation of these takes some pretty unique skill sets, and our team possesses all of those, but in addition to solving the technical aspects of the repair part of the process, we also have support staff on hand and on our team that we can handle software issues. We assist automakers. We actually develop software for automakers so that they can have a sort of a common platform to be able to deliver information, specifically security information. And so with that in mind, I want to talk about that just briefly. We, in 2007, began credentialing professionals who need access to security information on behalf of their customers through a patented process that's called the Secure Data Release Model. It's referred to in Section 7 of your law a little loosely. Currently, that has 11,000 participants in it, and they perform over 300,000 security transactions in a secure, monitored environment that is constantly updated and monitored for cybersecurity issues. We also have 30,000 members who participate in our diagnostic professional role, which is a lightly vetted role that automakers are currently using to provide validated access to secure vehicle gateways. This is simply to ensure that the vehicle connection is a live human and not a cyber attack. Other automakers are developing software similar to some of the things that you've talked about today, which would allow vehicle owners to provide access to their repair shop of choice to the information that they might need in diagnostics. Vehicles that push diagnostic events up to a website, they'd be able to access those, download them, and review them.
Mr.
help with
Cipher,
that.
your time has expired, so if you could wrap up and we'll see if we have any questions.
Yep, very happy to. So I'll leave it with that. You've got the rest of our testimony. We have very high success rate, 91%. I think that we could probably help you because regardless of having a law, you still have to have somebody who speaks technician and can translate that for your commission.
Thank you. Questions from the committee? Representative Collmore.
Thank you, Madam Chair. Thank you for coming before us. Two questions. One is, it doesn't state in your testimony what your position on this bill is. So for clarity purposes, what position are you taking?
We are not taking a position one way or the other. NASTAF simply supports technicians in doing their job in whatever way a state or the United States or Canada does it.
Okay, thank you. And the second question is, where are you located?
We're a spread out work group. So our team is all over the United States, but we've got our development offices in Michigan. Our corporate address is in Washington, D.C., and our actual working address is in Denver, Colorado.
Other questions from the committee? Seeing none, thanks very much for providing your testimony today.
My pleasure.
And Ms. Preeks, do we have one more person online to testify? So please promote that person. And the committee will note that Mr. Cipher's testimony is in our packet, so. Oh, go ahead. You're at the podium.
Okay, I wasn't sure. Good afternoon, Senator Curry, Representative Gear, esteemed members of the Joint Standing Committee on Housing and Economic Development. I'm Representative Tiffany Roberts, and I represent House District 149, which includes parts of North and South Berwick. I'm here today to present testimony in opposition of LD 2211. I won't read the whole name. I want to begin with the record because that's where this discussion belongs. The Attorney General's Working Group was convened under the resolve that we have spoken about to develop recommendations establishing the entity referenced in 29/1810 and to clarify its authority. The working group focused on the entity. It reached a unanimous agreement. The entity should not control or gatekeep vehicle data. It should serve in an advisory capacity and not have rulemaking or enforcement authority. Any enforcement would remain with the Attorney General. That was the framework. I support that framework. LD 1228, which this committee put substantial work into, was drafted to implement that structure while also addressing definitional clarity and sequencing concerns that had surfaced through litigation and stakeholder engagement. The governor vetoed LD 1228, stating it included a telematics provision that was viewed as outside of the working group's unanimous recommendations and suggested another path forward. LD 2211 is being presented as that path forward. It is not. LD 2211 replaces the independent entity with the Right to Repair Commission. I agree that the entity needed to change, but this bill goes further than the working group's charge. It alters enforcement posture by shifting the AG's authority from directive to discretionary type language. At the same time, it leaves the private right of action fully intact, including treble damages or $10,000 per denial, whichever is greater. When a statute already includes private enforcement, every change to substantive obligations directly affects litigation exposure. Modifying enforcement posture while maintaining private litigation leverage increases uncertainty. It does not reduce it. The statute remains under federal constitutional challenge. The complaint raises concerns about ambiguity in platform language, inconsistent terminology, and conflicts with federal vehicle safety law. Replacing the entity does not resolve those issues. LD 2211 adjusts timelines and structures, but it does not harmonize or define the litigated terms at the heart of the lawsuit. The bill adds a definition for owner-authorized independent repair facility, which is helpful, But other contested terms remain undefined, like simply what is an independent repair shop? In a statute with a private right of action and active federal litigation, definitional precision is not cosmetic, it's protective. There is also tension in the economic framework. Section 3 retains the fair and reasonable terms for subscription-based access, while another section seems to require direct telematics access upon the owner's authorizations without reconciling compensation standards. Two economic standards under the same statute without reconciliation invite pricing disputes, arbitrary enforcement claims, constitutional challenges, including potential takings, and strengthening preemption arguments. Those risks grow, not shrink, when private litigation remains available.
Representative Roberts, your time has expired, so you could wrap up.
Okay. The reference between LD 1228 and LD 2211 is not whether the entity should change. I would just wrap up with the last line being, I trust this committee to choose durability over pressure for those reasons. I respectfully urge the committee ought not to pass or to choose the law that they already have worked on. My testimony is on file.
Thank you. You submitted your testimony electronically?
Absolutely.
Thank you. Are there questions from the committee? Seeing none, thanks very much for your testimony today. Do we have anyone else online? Anyone else in the room who wishes to testify on 2211? Seeing no one. With that, I will close the public hearing on LD 2211. Pass the gavel back.
I testified in favor of their medicine across the hall.
We'll now open up the public hearing for LD 2164, and that is an act to assist communities with converting vacant school buildings into housing. And we'll ask the bill sponsor, my co-chair, Representative Gear, Chair Gear, to the podium.
Thank you, Senator Curry. We're doing a back and forth leapfrog today. Good morning, everyone. Senator Curry, fellow members of the Joint Standing Committee on Housing and Economic Development. I am Representative Tracy Gear, representing House District 134, which encompasses Kennebunkport and Coastal Biddeford and Kennebunk. I am before you today to present LD 2164, which establishes the Vacant School Housing Conversion Program within the Maine Redevelopment Land Bank Authority. The program will provide technical and financial assistance to municipalities seeking to redevelop vacant school buildings into residential housing, including units dedicated as affordable housing. The bill also establishes the Maine School Conversion Fund, which will be used to support the development of vacant school buildings. Converting vacant schools into housing is a common sense approach to creating affordable and attainable housing in many communities. In one of my own towns of Kennebunk, we have a great example where years ago, 3 former school buildings were converted into affordable apartments that have provided much needed affordable housing for decades. For communities looking to create needed housing in the current economic environment, vacant schools offer important benefits. They are often well located with infrastructure connections and easy access by road, and they occupy a warm place in community members' hearts as a place where they and/or their children and grandchildren spent happy times learning and growing with friends. That said, some vacant schools are easier to redevelop than others, at times due to structural issues, size, site location, and internal configuration, and despite valiant local efforts, vacant school redevelopment projects don't prove financially feasible, so they hit a wall, leaving communities with few options for moving forward. Especially for small municipalities with limited resources, the complexities and the hurdles can prove daunting and can prevent good projects from happening. Over the past 2 years, the Maine Redevelopment Land Bank Authority has been meeting with communities all over the state to understand their needs and challenges, especially around economic development and housing. The Land Bank has the tools and expertise to help communities overcome the hurdles of vacant school redevelopment, including navigating complex environmental, regulatory, and financial requirements, and facilitating negotiations and packaging of projects to improve the feasibility of conversions. The Land Bank has the authority to take title to property to move projects forward. It is important to note that the Land Bank will engage in this work only with express agreement of a municipality, with a memorandum of understanding with the municipality being required as a condition of participation. LD 2164 also establishes a fund to support vacant school redevelopment by assisting with planning, design, engineering studies, hazardous material abatement, support in navigating affordable housing programs, and capital investment to leverage other funding. There are a number of people to testify today, or you have testimony in your folders, on LD 2164 who have been working with Maine communities, along with dedicated community members, working hard to move toward a future vision for their own communities. I sponsored this bill on their behalf, and I enthusiastically support their work on vacant school redevelopment. As many Maine communities are in the process of making important decisions on next steps for these publicly owned assets, this bill is timely and important. Thank you for your consideration, and I ask your support for LD 2164.
Thank you very much. Are there any committee questions? Representative Cullimore.
Thank you, Mr. Chair. I have a couple of questions. Thank you for bringing this bill to us and presenting it. First question, is this something the Land Bank Authority has asked you to put in, and do they support it?
They'll be testifying afterwards, but yes.
Okay. And
Please
thank
do.
you. And with the Land Bank Authority, do they not already have the ability to help communities do this under their current statutory abilities, authority?
Yeah, they can certainly provide more detail. My understanding is that they have the ability to do these kinds of projects, but they're confronting projects that have real challenges, that they're facing more difficulty in assisting with those projects, and would like some additional powers to do that. And that's what they'll be.
And then one final
providing.
question. Okay, thank you. And then you said that this has, and I see here in the bill, a fund that would be created. It's $5 million. Have you suggested where that $5 million should come from, or is there somebody suggesting where that should come from?
Not at this point. I think that'll be part of the ongoing discussions around the budget and funding in the Appropriations Committee.
Okay, thank you.
Representative Walker.
Thank you, Mr. Chair. For $5 million, have you any idea how many schools would
I'm going to
be
defer that question
eligible?
to some of the experts who will be coming after me.
We'll excitedly wait to hear that.
Thank you.
Thank you.
Chair Curry, I had a question for the sponsor.
I'm sorry. Thank you. I did see that hand raised and didn't recognize the importance of it. Representative Lookner.
Thank you, Chair Curry, and thank you, Representative Guerra, for bringing this bill. It's an exciting prospect. You did acknowledge at the end of your testimony that these are public assets, and would there be in these memorandum of understandings that that these public assets remain in a structure that would still benefit the public, in long term, or is that are we talking about sort of facilitating the sale of these buildings into private ownership, I guess is my question.
Again, I'll defer most of that question to the land bank folks. But if you recall, Representative Lichter, when we chartered the land bank, the purpose of the land bank is to facilitate the process of repurposing many different kinds of assets in collaboration with Maine communities. So they really look to the community for a definition of the needs and what they're trying to accomplish. And then they work through all of the complexities with that community to get to the end to benefit the community. My understanding is that sometimes that moves some things to private ownership and repurposing for economic development reasons or for housing reasons. And other times there might be a different kind of entity or a nonprofit or a housing authority kind of group that would be taking charge of developing the housing pieces. So it really varies. But again, I would defer to them on the specifics of all the different kinds of projects they've been working on and dealing with communities, working with communities on.
Okay, thank you.
Thank you. Next, call up Elizabeth Frazier.
Good morning. Just 1 second. There we go. Good morning. I think it's still morning. Chair Curry, Chair Gear, and honorable members of the Housing and Economic Development Committee. My name is Elizabeth Frazier, and I'm pleased to be before you this morning on behalf of the Maine Real Estate and Development Association in support of LT 2164. You'll see I did submit testimony just now, so that's coming around to all of you. But I think, Representative Gear sort of touched on the purpose of this bill, so I won't repeat that. I will actually just say one thing that I think is really exciting about this bill. It has the unique opportunity to touch all parts of the state. And I actually meant to include this in my testimony. I forgot. I'll try to do it for the work session, but there's a very helpful list online of all the vacant schools in the state. And a lot of them obviously are privately held. They might have been private institutions of some kind, but there are a significant number that were public schools. And of course, they're located everywhere geographically. And I think there is an opportunity here for members of both sides of the aisle to find something that they like in this bill and to come together to really create some housing. And also just to say that this is a model that has been done before. So it's not, we're not sort of like reinventing the wheel here. There have been plenty of schools, both in Maine and across the nation, that have been converted into housing. This morning I was talking to someone, I compared it to like the mall model, which I feel like everyone is a little bit more cautious about, can malls really be housing? What does that look like? But there are certainly plenty of great examples of schools. And of course, we will all ask you to support on the appropriations table as well, the historic tax credit, which does very nicely with some of these things and which the land bank would be able to take advantage of if the property were historic as well. So that's another potential supporting funding for this. And Marita will be asking the Appropriations Committee to roll this into the supplemental budget to accommodate for that funding mechanism. With that said, I'd be happy to answer any questions.
Thank you. Thank you very much. Representative Cullimore.
Thank you, Mr. Chair, and thank you, Ms. Frazier, for being in front of us today. Do you know of other states that have this kind of program already? And is this modeled after that, or is that something you could provide for the work session?
Yes, I don't know the answer, but I will find out.
Thank you.
Thank you.
Gabe Govin. Welcome.
Good afternoon, everybody. Senator Curry, Representative Gear, and distinguished members of the committee, my name is Gabe Govin. I am testifying on behalf of the Maine Redevelopment Land Bank Authority in support of LD 2164. Over the past several years, Maine Redevelopment has conducted listening sessions with communities across the state. A consistent message has emerged. Municipalities are struggling to reposition their vacant school buildings once they close. Many communities must navigate redevelopment largely on their own, often without staff capacity, technical expertise, or clarity regarding resources and best practices. These properties are typically recognizable community anchors, yet their scale and configuration create complexity and sometimes significant reuse challenges. To better understand those challenges, Maine Redevelopment partnered with the Mid-Coast Council of Governments to pilot school reuse planning and develop a toolkit of replicable best practices to be implemented statewide. We observed that communities strongly desire productive reuse for their school facilities, yet the longer a building remains vacant, the less likely successful reuse becomes. Barriers exist at two levels. Communities are often under-resourced and require assistance with consensus building, scenario planning, due diligence, and feasibility. They also face funding gaps when transitioning from planning to implementation phases, particularly in rural regions and especially where housing production is concerned. LD 2164 provides a pragmatic response to these challenges. The proposed school reuse program includes two integrated elements. First, technical assistance is delivered through Maine Redevelopment, regional councils, and planning organizations utilizing a best practices toolkit. Second, the establishment of the Maine School Conversion Fund to close capital expenditure gaps for communities who choose to pursue housing reuse in their former school facilities. The fund is intentionally flexible. Resources may be used at multiple stages of the redevelopment life cycle. The housing product outcomes will be decided and designed through local partnership to reflect community need rather than uniform mandate. Eligible projects may include senior housing, missing middle housing, or other residential products across attainable price ranges, and administration of the fund will fall within Maine Redevelopment's existing operational capacity so that programmatic funding remains focused on project outcomes. Communities will engage with an MOU process and become eligible for capital support upon completion of the planning phase when identification of housing as a viable reuse scenario. The timing of LD 2164 is important. Approximately 24 former school properties are currently vacant statewide. Demographic trends indicate closures will continue. This list stands to grow dramatically over the next 3 to 5 years. Providing planning tools and resources now allows municipalities to respond proactively and deliver housing more efficiently. Maine Redevelopment exists to help communities return obsolete properties to productive use. Our statewide scope, technical expertise, and legislative mandate position us to administer this program consistently and effectively. Thank you for your consideration. I'm happy to answer any questions. And I'd also like to extend a thanks out to all the folks that showed up last week to provide support and have now, I believe, submitted digitally their testimony.
Thank you. Representative Cullimore.
Thank you, Mr. Chair. Thank you for being before us today. I didn't realize that you were part of the Land Bank Authority, so I scanned the room, didn't see Tuck, and went, oh, where are they? I have two questions. One, since you at the Land Bank Authority already have the authority to do this work as you have done it now, is the purpose for this ask specifically so that you can create a fund?
So yes, so we would like to, so yes, we provide technical assistance to municipalities all across the state. We've been working on this pilot project with Mid-Coast Council of Governments. We're developing a toolkit and we're going to move forward providing this technical assistance regardless of the outcome of this bill in this cycle. One of the things that keeps coming up is the capital expenditure gaps that arise when these projects do move forward, even when we go through all those right steps and prepare the communities as best as possible. Those infrastructure gaps or environmental abatement costs still are there and require some additional capital support to get them over the finish line. So this would be creating that fund. However, tying the technical assistance piece of the program to the available funding is a model that we're copying over other successful state programs of the past, to make sure that the reuse outcomes and the success rates are much higher when you pair technical assistance with funding rather than just creating a fund or a grant program.
And second? Okay, thank you. Now, I know that the Land Bank Authority has these outcome models when it comes to picking where they're going and what they're doing with that support because you have limited resources. When you're looking at, because the fund that's being requested right now is only $5 million. I say only because I know some of these schools have asbestos in them.
Yep.
And when you're talking about remediating these schools to make it affordable for, make it so that you can turn it into living, how are you prioritizing the cost of potential remediation with that and any chemical things that could happen from old schools with your priority outcomes?
So one of the things that we are always striving to do is make sure that we're providing technical assistance in stacking the available resources and programs that exist that under-resourced communities may not be aware of or have the capacity to go after on their own. So EPA brownfields funding and other forms of public finance tools and incentives that can support some of those costs. We're going to be going through all of those and making sure that we make the community aware and go after all of those potential resources to support the project. So that'll allow us to shrink the gap as much as possible. But even still, the remaining gap is, average is probably anywhere from $50,000 to $300,000 or $400,000 or $500,000 per school, depending on the size and scale. Through providing technical assistance and just doing that side of the project, we do hope to accelerate the reuse of these school buildings. But with the additional support from this fund, that increases the amount of impact we're able to have and pushes some of those more long-standing vacancies where schools have been left vacant for 10 or more years and are languishing. I help get those elevated and back to functional use.
Yeah. Representative Julia.
Thank you. Nice to see you, Gabe. How are you doing?
Great.
Okay. Just would like to compartmentalize a little bit of this, especially in the context of Representative Collmore's question. Recently, not recently, like 10 years ago, Waterville, a developer developed Waterville's old Gilman Street School into a ton of housing. It's been awesome. Like it really has been a huge boon to our town. We do have another, as you know, coming from Waterville in your past job, have a couple of other schools that could definitely be converted into housing, and maybe a couple of hospitals and things like that. Do you think that developers, would you say that it's reasonable to assume that developers have an extra challenge and partnering with the redevelopment land bank will allow these types of developments to happen more efficiently and more quickly than if towns manage this all by themselves?
Sure. Thank you. Yes, I do think that a program like this is necessary to help get these projects moving, and having it as a model that serves the whole state holistically is important, especially when from the land bank's perspective, where we're looking to always create efficiency through economies of scale. And if there is an opportunity for us to, or a need, I should say, for us to take title to any of these properties, the grouping or creating cohorts of property types is one way that we can use to market sites that on their own would not be attractive to developers. And I'll also say that in the testimony packet, you should also have testimony from the town of Union, as well as the Developers Collaborative. That Union school case model is one of the earlier conversations we had that inspired the thinking behind our pilot project and this bill. Where a project was for affordable housing, had subsidy, had some other public finance tools and incentives in there, but was unable to pencil out for the private developer due to infrastructure extension and improvement costs.
Representative Lookner.
Thank you, Mr. Chair, and thank you, Mr. Govin. I'm aware of at least one municipality that had a school, and it was interested in, the school district was interested in maintaining ownership of the building, but converting it into housing specifically for teachers or other municipal employees, other school district employees. And they ran into a number of issues because well, I think primarily there are a lot of especially with getting like federal grants and things, there are issues relating to you can't like necessarily have a specific population of people if you're getting federal assistance. So would the land bank be prepared in those instances, maybe rare instances at this point, but perhaps more common in the future, where a school district wanted to maintain ownership for a very specific reason, and then in long term that school district or municipality would be able to directly benefit from the conversion of these public assets into housing?
Yeah, thank you for the question. So first and foremost, I want to make sure that it's clear that the municipalities are our constituents for these programs that we create, and supporting them in whatever their selected, shared community vision and consensus is how we want to be collaborative and capacity building, and not ever competitive with the needs of the local residents and business owners. On the form and function of how these projects may be successful or continue on with different ownership models, that's a way that we want to make sure we're providing assistance to the municipalities to navigate any of those complex public-private partnership models, either with the RSU or school district, with a private or nonprofit development group, or with us if there's a role for us to play in the ownership of the site. There is not currently any prioritization given to those different models, where the needs and particulars of every community and the school buildings they have are going to be unique.
Great, thank you.
Senator Bennett.
Thank you, Mr. Gowen. At $5 million a year, how many housing units will you be participating in developing? What's the goal?
We don't have a specific housing unit number goal right now. Especially where the size of every school is going to be so different, and the adaptation cost is also varies so greatly. As far as numbers of schools, I could say that for the amount outlaid here in this bill, we would estimate with the range of capital expenditure gaps that we've seen so far, anywhere from 10 to 15 or more schools we'd like to support through from planning and reuse through the actual implementation process. So as far as specific housing unit numbers, I wouldn't be able to say, because the schools are also different.
So how much of this $5 million will be used in the planning side, and how much on the financial, this technical and financial support? What is the breakdown between that?
So no funding from this bill will be used for us to provide technical assistance. That is something that we're providing out of our own operational budget. And as I said earlier, this is using the toolkit and implementing this school reuse program statewide is something that we're going to be moving forward with anyways. But the $5 million is intended to go towards planning and soft costs, as well as more real construction costs included in the redevelopment, like abatement if there is no other funding available for abatement at the time, or infrastructure improvements or life safety improvements.
I think it's a great idea. Just commentary. I think for work session, if you can put a finer
absolutely.
point on what the goal is on an ongoing $5 million appropriation in terms of units of housing, not holding you to it, but what is the goal?
Yep.
Thank you.
No, thank you for that feedback. Absolutely. We'll get that together for work session.
Thank you. Representative Walker.
I'm assuming that you have a toolkit which is based on experience with this kind of project. How many schools have you rehabbed in this way?
So the toolkit is built off of 3 different schools that are in different phases right now of redevelopment in Brooks, Liberty, and Union, Maine. Maine Redevelopment is currently engaged with those 3 communities for their school reuse, and there's approximately a dozen others that we've spoken with and are looking at engaging more in taking a more active role in the next year. where we've only been staffed and and operational for a little over a year and a half. We haven't seen any of these projects through to completion yet because they're so costly and time consuming. But that information is what informed the content of this bill and this program, as well as conversations and interviews with developers and municipalities who have completed these projects and have been successful with them.
Of the 3 projects that are ongoing, what's the ownership model for each of these? Are there any of them where essentially government becomes the landlord?
So for all 3 of those schools at this point, the municipality is taking on ownership, if at least for a temporary capacity, if not for long term. In one of the cases, the reuse scenario that was selected by the community was not housing. And so they're going to be moving forward with some using the property for town office space as well as for childcare facility creation, with, I believe, a public-private partnership model between the community and those private business owners. The other 2, housing is the identified reuse outcome, and they're currently owned by the municipality. Whether that is something that continues on for the planning and permitting, or not permitting, but the planning and development phase as it gets closer to actual groundbreaking and activating of housing units, or if they get conveyed to a private developer or nonprofit developer is something that we're going through right now.
So I'm imagining you have a community with a school, they come to you, there's an initial conversation going on. There are a number of different models for pathways with this property. Is one of those considerations using the funds that you anticipate might be spent on this, just providing those funds to bulldoze this property and put it on the market for private developers? Is that even an option?
So our mission and our statute and our ethos as an organization is always to find the best case for reuse and adaptation of buildings as far as it is possible with the site. If buildings pose a potential hazard and they're dangerous, or if the environmental impacts of the site are so great that it is not able to be adapted in its current function and form and does require demolition, that is something that we'll provide support for. And then if their outcome that they've identified through the planning process is housing units, and demolition is the needed outcome for the building, then we would support them in that demo initiative, and then identifying development partners to help create a housing scenario on that site. And that might include us helping to bring in architects and engineers.
Representative Cullimore.
Thank you, Mr. Chair. So you talked about one of the schools that's part of your toolkit creation has decided not to do housing.
Yep.
Would this bill prevent you or restrict you from being able to help communities do different use cases, like a community center, for example?
No, not intended to restrict us from providing any of that support. Our goal is to, in the technical assistance side, is to understand the current conditions, understand any of the issues on the site, and help with completing due diligence, and then go through the community visioning process and come to a shared consensus for what the best case scenario is and the highest and best use of the building is. If that is not housing, then they just aren't eligible for that funding. But we'll still provide them assistance in identifying all the other public finance tools and incentives that are available, and help them get their project going. They just wouldn't be accessing that specific fund because it's only for housing. Yes.
Representative Julia.
For the work session, do you think that you can provide maybe a one sheet of what happens to old buildings like these if they aren't developed eventually, and the type of maybe a condensed, easy to reference bullet points about what kind of a burden it ends up being on a town if an old school just stays vacant in perpetuity and nothing ever happens to it? And I love this packet that you provided, but do you have any more examples of what you're actually currently working on that you can provide to us in its current stages, just so that we can have a more visual representation about what you're talking about for the work session.
Yes, yeah, happy to provide more detail on all
Thank you.
those items.
Seeing no other questions. Thank you very much.
Thank you all.
Is there anyone else here who's signed up or wishes to give testimony on LD 2164? Is there anyone online? Oh, there's, great, thank you.
Again, I have to make sure I get the one with the 16-point font. Or nobody will know what I'm talking about.
I'm up to 20.
Up to 20, wow.
Whenever you're ready.
All right. Good afternoon, Senator Curry, Representative Gear, and esteemed members of the committee. My name is Marge Kelly. I'm here today on behalf of Legal Services for Maine Elders. LSE provides free legal help statewide for Mainers age 60 and older when their basic needs are at stake. Housing is a majority of the work. I'm speaking today in strong support of LD 2164. Schools are the heart of a community. As school consolidation has moved students to other communities, and as student populations have decreased, school buildings are empty. At the same time, housing availability is a critical issue. LD 2164 seeks to create opportunities for those vacant schools to be converted to housing with a percentage available for affordable housing. This is desperately needed by older Mainers. It's estimated that 20% of people 50 and over lack retirement savings, and there's a 3 to 5 year wait list for most affordable housing. Older Mainers want to age in place. Many want to stay in their own homes. But if and when that becomes impossible, the next best option is to stay in their communities. The community they built with their work, their volunteerism, and their family. Being in your community means being near your place of worship, your family, your friends, healthcare, familiar shopping, and social groups. Socially engaged older people often experience better physical health, increased mobility, and a stronger sense of purpose and belonging. Converting vacant school buildings into housing serves to retain the culture and heritage of a community, often reduces opposition to the project, and reduces waste compared to demolition. Additionally, multi-generational communities create interactions between older and younger members, which reduces ageism, increases communication, and encourages understanding across generations. LD 2164 addresses the needs of the community to utilize buildings, residents' need for safe, affordable housing, and supports the creation of vibrant, diverse communities. We urge your passage of this bill. Happy to answer questions.
Are there any questions from committee members? Seeing none, thank you
Thank
very
you.
much. Is there anyone else who's wishing to give testimony? Anyone online? Great. With that, we will close the work session for LD 2164. We are looking at the clock. We are going to take a break before LD 2173, and we will reconvene at 1:15. Right here.
Blue eyes.
Oh, good. I'm glad that could help. Yeah. I asked him to be a question.
Peace prophecy around the world.
But this doesn't go far enough.
That's basically.
I don't have that.
One big law does not go hard. Half the law. They wouldn't be able to go on to the side. Anyway. But yeah.
I'm just wondering whose mic is on. We need to turn the mics off.
So.
Welcome back, everybody. We're going to get started here.
There's one guy. I'm not in.
Let me call you up.
I know.
We'll now open up the public hearing for LD 2173, and we'll invite the bill sponsor to the podium. Welcome, Representative Collmore.
Representative Peter.
Oh, and while Representative Collmore is making her way to the podium, I'll ask Representative Eder to introduce himself.
Hi, I'm Representative John Eder, representing District 136, Alfred, Lyman, and Waterboro.
Good afternoon, Senator Curry, Representative Gear, and members of the Joint Standing Committee on Housing and Economic Development. My name is Amanda Collmore, and I have the great pleasure of representing House District 68, Pittsfield, Clinton, Burnham, and Troy. I stand before you today to introduce LD 2173, an act to update the laws regarding housing developments and accessory dwelling units. This bill is about making sure the housing laws that we passed last session work the way they were intended to work. LD 2173 does not change the policy direction set by this committee. Instead, it makes practical fixes to the law based on what towns, property owners, and professionals are experiencing now that the laws are being implemented. Over the past year, communities across Maine have shared where the law has been unclear, where it has created unintended consequences, and where small fixes are needed to keep projects moving while maintaining safety and local planning. This bill reflects that feedback. Because these issues are already affecting housing development across the state, the Legislative Council approved LD 2173 as an emergency measure. A significant portion of this bill focuses on making important corrections and clarifications to LD 1829 passed last session. For example, it places a clear cap of 55 feet to the affordable housing height bonus and ensures that these developments are reviewed by fire officials. This keeps safety at the center of the process while still allowing needed housing to move forward. The bill also standardized subsurface wastewater requirements for accessory dwelling units, affordable housing, and small multifamily housing statewide. This consistency matters. Property owners and municipalities should not face different rules depending on where they live when the goal is the same kind of housing. LD 2173 also corrects errors and adds clarity to the core of last session's law that limits a municipality's ability to block small-scale development on private property. These provisions are designed to protect the rights of property owners to contribute to Maine's housing supply, and this bill ensures that intent is clearly reflected in law. At the same time, the bill recognizes the very real impacts of rapid growth. It provides towns with a circuit breaker to manage those impacts while keeping limits on the use of growth caps in designated growth areas. It also exempts affordable housing from local growth permit requirements so that projects needed are not delayed by processes that were never intended to apply to them. Finally, LD 2173 cleans up technical errors and clarifies language from the enactment of LD 1829, ensuring that statute reads as it was intended and is clear for all. As we talk about housing, it's important to be honest about the role of funding. There will never be enough public dollars to subsidize the full amount of Maine's housing needs to meet its goals. Most of our housing must be created without subsidy. That means we need laws that allow housing to be built in practical, small-scale ways. These changes rebalance how housing gets built in Maine. They support accessory dwelling unit duplexes and small multifamily homes, and they recognize that individual property owners who want to build on their own land are a major part of the solution. For me, this bill is fundamentally about property owner rights. It respects the ability of people to responsibly use their own property to create housing while still honoring safety standards and reasonable local planning. LD 2173 keeps the intent of last session's housing laws intact and makes sure that it works in the real world. I respectfully ask the committee to support this bill. I'm happy to answer any questions. That said, there are content experts who are testifying after me that may be better suited to answer the more technical questions you might have.
Are there any questions by committee members? Seeing none. Thank you.
Thank you.
So we're going to start with a plan of, our plan is to go through those in the room, in proponents, opponents, then neither, and then we'll go online in the same order, proponents, opponents, and neither. And so first up, and then if someone hasn't signed up, there is another sheet over there. I'll go to that sheet at the very end. Or I'll also call for if we've missed anybody. Is it Jenny Franceschi? Thank you. And I apologize. I think I butchered your last name.
You did just
Oh.
right.
Welcome.
Thank you. Senator Curry, Representative Gear, and members of the Housing and Economic Development Committee. My name is Jenny Franceschi, and I'm the president of the Maine Association of Planners, and I'm here to provide our LPC's recommendation to support LD 2173 and offer the attached recommended amendments to improve the bill's effectiveness and implementation. The state's housing goal of 84,000 units requires significant action. Nearly 50% of all Maine renters are paying more than they can afford in rent, while 65% of Mainers cannot afford to purchase the median priced home. Solutions include funding, state-local partnerships, building and permitting initiatives, and leveling the playing field to equalize housing opportunities across the state. Striking the balance between state mandates and retaining local control is challenging. Striking the balance between housing development and natural resources is challenging. But the greatest challenge right now is addressing the vast number of Mainers who cannot afford their housing. The legislature has taken a leading role in addressing the affordable housing crisis, representing a transformative shift in how our state approaches housing development, consistent with state reforms occurring across the country. Recent state laws have laid a strong foundation for increasing housing supply by reducing regulatory barriers and promoting density where appropriate. This bill provides practical modifications to several housing laws adopted last session. It maintains the committee's policy direction and intent, but improves operational effectiveness and clarifies technical inconsistencies and errata. We thank Representative Collmore for advancing this important bill. The MAP Legislative Policy Committee is made up of municipal planners, regional planners at state regional planning organizations, and planning consultants working across the state. We recognize that zoning, subdivision, and growth management are the focus of planners almost exclusively, and as such are recommending the following amendments to 2173. Red line of the bill is attached to this testimony. One is to extend the implementation deadline of 1829 by at least 6 months for council forms of government to allow for an appropriate amount of time for ordinance development and adoption. Extending town meeting deadlines may have less value, as town meetings generally occur prior to July 1. To exempt areas prone to flooding or other natural hazards from the lot size and density limitations to allow municipalities more tools to manage risk in these areas. And to clarify that housing development within a growth area that is not served by water and sewer, that the minimum lot size should be 20,000 square feet, because it is otherwise unclear in the DHHS rules. We would extend the implementation deadline for last session's parking minimums, LD 427 and LD 1428, which was the daycare and residential zones, to be consistent with LD 1829. Thank you for your time. I'm here for questions, and members of the LPC can be made available for work session to assist with any proposed amendments.
Thank you. I think I'll lead with my first question. with the first question. Can you restate, I think I heard 4 proposed amendments.
Yes.
And where would we see them in the red line bill? So is that starting on page 1?
So the actual amendments to the base bill. So the base bill being all of the black underlines are the base bill.
Mhm.
It's not till you get to page 2, under number 2, where you have the first minor amendments that the LPC is asking for additional amendments to the base bill, which is to add in and designated in growth areas. Under 2, to change in section 5, the date of implementation under 3464, and changing the date in section 10 to 2027. Under 2A, this was the area of lot size and density. This is where the committee has recommended to put in the exception on if there are flooding hazards or other natural hazards, that these provisions should not be applicable. They have clarified under C related to the density on septic systems. And 15 was a complete strikeout, as the area is just not applicable anymore. It was a 2003 vintage item, so they felt that that area is not even applicable. And then really referring everything back to a consistent date is where the majority of the edits remain in the document.
Thank you. Thank you very much. Representative Pellemore.
Thanks. Just a quick clarifying question on the risk of flooding and other natural hazards. So that I'm clear on the ask, if we put that exemption in there, does that mean a town that has a growth area around, let's say, a river, for example, like Skowhegan has a huge river going through it, that area would be exempted because they flood every year?
It would say that these additional provisions in this section 2A would not be applicable. And so it's to not exacerbate a situation where you have a natural hazard issue.
Thank you. No, Chair Gear.
Thank you, Mr. Chair. And thanks for being here, Ms. Franceschi. Just curious about the flood hazard. Would that be, what would be your recommendation? Would that be the floodplain, the flood hazard maps? What would determine the boundaries of that flood zone?
That is something I think that we should come back to you in work session to put a finer point on, just so to make sure that there is no misunderstanding as to what the line is.
Please.
And with regard to, say, a municipality that has a floodplain management ordinance in place, again, it would be helpful to hear your recommendations about, exemption versus municipal authority to set zone, because I think there are many different kinds of communities that have different things happening currently in their floodplains. And as those floodplains have changed dramatically with sea level rise and other flooding issues, really important to just get your sense of what's the best way to define that and then govern that as we in the law. Thank you.
Yes.
Thank you. I see you wrote your name down twice here. Are you seeking to give separate testimony for the city of Westbrook?
Yes.
Okay. And the first one was on behalf of the LPC?
Yes, the first
Okay.
one was on behalf of MAPS LPC.
So we'll go ahead with that then.
Again, Senator Curry, Representative Gear, and members of the committee. My name is Jenny Poulin Franceschi, and I am the Director of Planning and Code Enforcement for the City of Westbrook. I am providing testimony in support of LD 2173 with the attached changes as attached to this testimony. I thank Representative Collimore for bringing this amendment forward to address significant wording adjustments to support Maine's communities. LD 1829 was a very robust bill that contained a considerable number of alterations to municipal zoning to facilitate an increase in housing production. This testimony only requests a few points of adjustment to 2173 that municipalities strongly feel conflict with our zoning and comprehensive plans. The proposed text is attached. We further support your edits, we further support the edits of the Maine Association of Planners Legislative Policy Committee, but are requesting the following 3 points be included as well. 1, to clarify that the density and lot provisions in growth areas only mandate lot size and density provisions where public water and public sewer is present. 2, to remove the mandated lot size and density outside of a designated growth area where water and sewer is present. And 3, to adjust the implementation date for LD 1829 by 1 year to allow for rulemaking to occur and provide municipalities with the time they need to work through comprehensive plan amendments to avoid legal challenges. To explain our rationale for the amendments, within the growth areas, municipalities feel a loophole has been created by allowing any comparable sewer system to be the trigger for density. This would mandate a community to increase their densities if an engineered septic system was to be installed as part of a project, resulting in a rate of growth that smaller communities never intended in their comprehensive plans. When we're talking about growth outside of a designated growth area, the presence of sewer on its own does not mean a community has planned for the level of density that this law mandates. Sewer can be installed for all kinds of reasons, such as to reduce environmental impacts on natural resources, on islands, or around our lakes and streams. Also, small lot development along major DOT collectors and arterials creates an incompatible situation where there are too many driveway openings, creating transportation safety conflicts along our major corridors. If the mandate of density and lot size outside of a growth area where sewer and water remains in the law, the unintended consequences could be public and water sewer systems will be halted from expansion. This is already a conversation going on outside of Cumberland County. We could also see impacts to natural resources created by the increase of impervious cover, which would cause the impairment of our streams, which the state could potentially be liable because they are mandating these densities and could be financially responsible. Again, 1829 was a large bill that contained many zoning changes. Our comments are only asking for consideration on 3 points. The rest of the bill remains. We ask for your consideration to incorporate the attached amendments along with MAP's LPC recommended edits into your committee recommendation. I'm available for questions that the committee may have, and I'm willing to participate in future workshops. Thank you.
Thank you. And if you can reiterate the City of Westbrook's 3 recommended amendments.
Yes. So on the 3rd page of my testimony, I have outlined essentially the base bill remaining as is. Our edits are listed in red, where we would be removing the wording in A, which talks about location within a designated growth area, to remove the special district or other centrally managed water system, and then the special district or other comparable sewer system from the law. So it would strictly speak to public sewer systems and public water. It is proposing to remove the section B, which talks about growth outside of a growth area in its entirety. And then again, making that same distinction about only public sewer systems in section C, and asking for in section 25 at the bottom of the page to have the dates pushed to 27 for municipality, municipality with municipal officers, and all the municipalities being 2028. So those are the only amendments that we are asking for consideration.
Great. Thank you very much. But the City of Westbrook wanted inclusive of the LPC.
Correct.
Okay.
Yes. Yes.
Representative
And
Comer.
all bills.
Thank you, Mr. Chair. Just for clarity on 2 points that's being asked here. One, you're asking for the removal of 2-A point B. And I'm curious how that might work with the 20,000 square foot minimum lot size recommendation from MAP LCPs.
So the the 20,000 square foot amendment would end up falling into if you're on my page, it'd fall into that paragraph C. So that is the paragraph that the LPC is recommending. I didn't want to make this overly confusing and incorporate the LPC in mind, so I was like, I'm just going to stick with the base bill. But the LPC's recommendations would edit that paragraph as well to your 20,000 square foot clarification, so that it's very clear what areas that are on septic would be.
And then the second clarifying point is, I seem to remember, and I could be remembering incorrectly, when we included the special district or centrally managed water system or comparable system, that it was because there are water districts that are run by private companies, and there was concern that they might end up accidentally being like the town of Pittsfield no longer runs their own water department. It's run by a private company. Would this cause that to be exempted from this?
So the provisions as they are laid out in state law are, for lack of a better term, a mandate. So if you have these elements, then these provisions of density are required for your community to comply with. If you have a situation where you have a private system, but you as a community want to, and you've put into your comp plan, those elements to increase the density in your community, you have that ability. You don't need the ability for the state law to give you that flexibility. As municipalities, we have that already. If we want to increase the density within our communities, we have the right to do so. But this law is the mandate. So it's more saying that if a community wasn't expected or wasn't planning on this level of development in their community, and somebody comes in and puts in an engineered system, that all of a sudden now that developer goes to the community and says, you must comply with this level of density because it says it in state law. And so that's the concern that has been brought to us by our city attorney, and they represent a lot of smaller communities in the state. And so it was, that's not what their comp plans have laid out for them. But if a community wants to put this level of density, they have that flexibility right now, and they could allow for additional density in their community.
Chair Gear.
Thank you, Mr. Chair. With regard to removing section 11B there, do you have any concern that a community that has water and sewer infrastructure, and some or all of it, usually some, right, would just not designate a growth area and therefore be completely not required to have any of the provisions of 1829 apply?
So again, if you are looking to exempt your community from a growth area, you have to comply with the standards that are laid out in the growth management law. So you'd have to first be able to jump over that hurdle of being able to say, like, we're not having a growth area because we meet the parameters and fall underneath a level of density or a level of growth in your community. The concern we see with tying just a sewer element to a level of growth is that we don't necessarily, or I guess in Westbrook, we want to see our sewer expand. We'd rather have more sewer than more septic. We'd rather not have septic going into our grounds and polluting our waterways. We'd rather have all of that collected and go into a centralized system. What we don't want to see is we don't want to see that because our decision to go in that direction is going to mandate a level of density in our outer areas of Westbrook that we never intended. I really think that the intention behind paragraph B was more of an infill component, the way that it's written, that it really was meant to allow for in established neighborhoods on local roads where you're not going to have the issues of frontage requirements of, we're looking at 302 being impacted. And if we had a bunch of 5,000 square foot lots along 302 in Westbrook, that's really going to be a problem from an access management standpoint and a safety standpoint. We want to consolidate those lots and have better developments off of 302, not have a bunch of small lots. So looking at how this is written, it really seems like this would be targeted towards existing established neighborhoods, local roads where the speeds would be slow, so that you could create that infill development. We have recognized in Westbrook lots of record, which were like 1900 subdivisions that were 50 by 100 lots. And if you have three or a bunch of them as part of your existing lot, we recognize those lot lines, and you can now go back and cut those lots into 50 by 100 lots. And you go through a process with the city, and we now allow for that level of infill development, which has been a great way to get more development in these old established neighborhoods. And I really think that probably was the intention behind paragraph B, but the wording of that is so broad that you can have now basically a daisy chaining of sewer systems could just, be extended. And the only way you can exercise this is by a lot. So it's a bunch of subdivisions coming off of roads with little 50 by 100 lots that I don't think was really the intention behind the writing of this. I really do feel like this should have been more of an infill, a way to get more density closer to your core.
Sure.
So we've been talking about this challenge for many years now. And I just would, for the work session, if you could provide, because the thing that I'm keep trying to get at is that's great. If you're a community and you're meeting your housing needs and you're developing new housing and you're developing affordable and attainable housing, that's great. I continue to hear from many people in many communities who are business owners who are employees that have to drive an hour to work because they can't find anything near where in their community where they are. So what would be, in thinking about that demonstration, rather than saying just historical growth, how can you tell whether a community is meeting its housing needs, both from the people that exist there and live there currently, as well as for the prospect of, any kind of economic development or anything that you want to do, sustain your existing companies or your existing, municipal workers. What is the right way to demonstrate that? Because I hear what you're saying. I think that it keeps coming up against, for me, how do you actually qualify for that, and how do you manage that risk here? So that would be helpful.
Okay, I think that there's also I guess there could be a possibility of maybe taking that one piece, like this area outside of a designated growth area piece. Would there be any possibility of maybe like having a working group so that we could come up with some really good language as to how we can make this functional, and work with municipalities so that so the language isn't so broad, but it is tailored to the problem that you're trying to get at, which is getting more housing closer to a community where you have your work centers. Is how do we get that housing to be created and infill our areas, but not induce sprawl. I guess that's where we want to try to avoid the sprawl situation, but let's see how we could try to get more units in our core areas.
Just one final point on that. If you could also provide any insight on, what is a metric? So for example, if a community has created 10% of its housing that is affordable and attainable to, the median income or below, I'm just making that up off the top of my head, but there needs to be some sort of metric for that to me, and any insights you could provide for a work session would be helpful. Thank you.
Thank you. I think that's it.
Thank you.
So, and we'll next go to Andy Cashman. Welcome.
Thank you, Senator Curry, Representative Gear, distinguished members of the Joint Standing Committee on Housing and Economic Development. My name is Andy Cashman, the founder of Resolve Government Relations, here today on behalf of our client, the Maine Association of Realtors. I'll be very brief. You have my written comments dated for your prior hearing scheduled, but You have those, and I'll just be very quick and say that we strongly support LD 2173. Written comments make all of our points, but we did want to be here in person just to re-emphasize how strongly we want to support this. We believe it reduces restrictions, regulatory barriers on housing development, as you've heard us testify on a number of other bills. This is definitely in that category. And we view this really as technical improvements and updates to last year's LD 1829. This incentivizes private investment. It provides regulatory improvements where development may be limited, while also providing municipalities with the guidance that they need regarding growth ordinances, minimum standards, and providing a grace period. So with that, I will wrap up my testimony, and I'm happy to answer any questions you may have.
Questions? Seeing none. Thank you.
Thank you very much.
I'll ask for Greg Payne.
Good afternoon, Senator Curry and Representative Gear and distinguished members of the Joint Standing Committee on Housing and Economic Development. My name is Greg Payne, and I serve as the Senior Advisor on Housing Policy in the Governor's Office of Policy Innovation and the Future. I'm here today to offer testimony in support of LD 2173. The administration remains strongly supportive of recent zoning and land use reforms enacted by the legislature and signed into law by the governor, including LD 2003 in the 130th legislature and LD 1829 last year. We see those laws as critical to addressing the local codes that for too long unnecessarily restricted the creation of the homes that Maine people need and our economy requires, allowing homeowners to make further use of their own property by adding accessory dwelling units, incentivizing development in designated growth areas and where water and sewer infrastructure exist, and making the local approval process more efficient are all common sense elements of an improved housing development system. At the same time, we recognize that these laws are complex and detailed. The clarifications included in this bill will help to ensure that stakeholders can implement them as intended. We appreciate the bipartisan work undertaken by its sponsor, by Speaker Fecteau and others to identify the issues that have been called out and clarified in this proposal. We also recognize that the State Fire Marshal's Office has further recommendations for consideration regarding certain aspects of the bill and look forward to talking those through with members of the committee. We appreciate all the work that so many people have undertaken over the past 5 years in furtherance of increasing Maine's housing supply through needed zoning and land use reforms. Thank you for consideration of our testimony, and I'd be happy to answer any questions.
Thank you. Are there any questions? Seeing none. Thank you very
Thanks.
much. We'll now go to those speaking in opposition, and I will start with Roger Kraus.
Good afternoon, Senator Curry, Representative Gear, and members of the Committee on Housing and Economic Development. My name is Roger Kraus. I am the General Manager of the Kennebec Water District in Waterville, and I'm here today representing the Maine Water Utilities Association in respectful opposition to LD 2173, specifically the provisions that removes existing municipal authority to create subsurface wastewater disposal ordinances that are more restrictive than statewide standards. Maine Water Utilities Association is a supportive of housing development, and we deliver water, and water more development means more customers, and so we're certainly supportive of more development. But we are concerned by any efforts to reduce the protection of public water system sources of supply. Water utilities in Maine, many water utilities in Maine have been protecting sources of supply for more than 100 years through local ordinances and land use restrictions. Public water systems use groundwater, surface water, or a combination of both as sources of supply. Universally, protecting a source of water from contamination is better than attempting to purify the water after the contamination has entered the supply. Maine law currently allows municipalities and some quasi-municipal entities to create subsurface wastewater disposal standards that are more stringent than state minimum standards. Adopting more stringent standards can reduce the risk of contamination from a subsurface wastewater disposal system entering the groundwater and nearby surface water. While all groundwater and surface water should be afforded protections from contamination, the protection of sources of drinking water should remain paramount in importance to Maine's policymakers. So we encourage you to consider amending the language in 2173 to remove language that prohibits municipalities from creating more stringent ordinances or limit the prohibition to areas that are outside of source water protection areas. And I'd be happy to answer any questions.
Could you restate that last part of it? So either to eliminate it or to
Take it out completely or amend that so it only applies to areas that are outside of source water protection areas. So the area that influences the water quality of a public water supply, we would like to have the municipality continue to have authority to create municipal ordinances that are more stringent than the state code. Outside of that, if the legislative policy is to allow to restrict municipal authority, we don't have an opinion on that. But we want to make sure that whatever policy is put forward to increase housing doesn't put at risk public water system sources of supply.
Gotcha. And can you give me an example of municipal ordinance around wastewater that exceeds the state standard that you feel is really important?
Sure.
Or if not now, for the work session, that's fine.
Yeah, I mean, I may not give you in the Kennebec Water District. We use China Lake as our source of supply. The town of China has some modifications, slight modifications to the state subsurface disposal requirements that are intended to protect the lake.
Mm-hmm.
But whether it be a groundwater or surface water supply, there are municipalities that have local ordinances that restrict require a larger septic system, disposal fields for treatment of wastewater, and so that again reducing the risk of contamination. Our goal, the ideal public water system source would be one that has no human activity near that source. Now that's not reasonable, but in most cases, but most public water system sources of supply are outside the developed area of a municipality. So oftentimes there's no public sewer available. And so these areas where public water system sources are developed, we'd like to make sure that we're doing whatever we can, have the local authority to do what we need to do to protect those sources of supply, rather than increased human activity increases risk of contamination. So where there's public water system sources of supply under that source water protection area, as we call it, we'd like to not restrict municipal ordinances that could that related to subsurface disposal systems.
That's clear. Thank you.
Yes.
Chair Gear, did you? Representative Cullimore. Representative Cullimore.
Thank you. Just to clarify on here, the concern for you is that the language is stating that you can't go more restrictive than DHHS's
Correct.
current. And is that because DHHS's current rules are not stringent enough to protect those sources? Or I'm just curious, where's the problem and why does the municipality need to be more restrictive than that?
Yeah. So as I said, human activity creates contamination. The more human activity you have near a source of supply, whether it's groundwater or surface water, increases the risk of contamination getting to that source of supply. So subsurface ordinances are one tool that municipalities have to ensure that a source of public water supply is protected, has greater protections than other groundwater or surface water sources. So it's not necessarily that we think the state plumbing code is faulty. We look to reduce the amount of human activity in in the zone of influence for our public water system sources. And so if there's more activity, human activity, housing density in this specific case, then there's an increased risk of contamination in that source of supply. So we're just we don't want to see the municipal authority removed that can make local decisions about how to protect a source of supply.
Thank you very much. Are there any other questions? Seeing none. Thank you for coming. Love the tie. Let's see, Stephen Weems.
Thank you. Senator Curry, Representative Gear, and members of the Committee on Housing and Economic Development. My name is Steve Weems, a member of the Brunswick Town Council. I am submitting this testimony as an individual, elected official. I am not speaking officially on behalf of the town, although I think my testimony is generally congruent with the town's thinking. In this context, I arise in reluctant opposition to LD 2173 with a request for language changes that would change this to support. In section 2, pertaining to the rate of growth ordinance, in subsection 3B, it is not clear how the mathematical calculations would be applied in a community where a rate of growth ordinance covers only a defined geographic portion of the town, say its rural area only. If there is a rate of growth ordinance for the whole town consistent with subsection 3, it appears a municipality could have different limits for different sections of town, as long as the aggregate minimum number of units allowed meets or exceeds the number required for the whole town. However, if there was no limit on the rate of growth in some areas of town, compliance with a required percentage in a rural area cannot be calculated. Therefore, I recommend exempting a town from the rate of growth provisions if the town restricts its rate of growth ordinance to only a section of the town, e.g. its rural area. Second, in section 2, subsection 3B still, the minimum percentage required should be left unchanged or possibly eliminated. The overall intent of this provision may be to level the playing field, but any percentage level seems punitive to towns like Brunswick, and there are others certainly in southern Maine, that have recently experienced rapid growth in housing. These towns will be required to accommodate more and more growth as a, quote, reward, end quote, for their good performance, which is unfair. I am sure other towns will be making this point. Third, I support extending the compliance dates as discussed earlier by others. Lastly, and importantly, I think the density provisions applicable in areas of a municipality with public water and sewer, but that are not in the designated growth area. This, I think, is what's being referred to as section B in the underlying legislation, should be amended to reflect the goal of creating affordable housing more directly. Specifically, these areas are primarily existing residential areas. I suggest you decrease or eliminate the density requirements for market rate housing in these areas, which is the way it's now written. The projects being developed are market rate projects in many communities in this specific part of towns, and keep the existing density requirements in these areas as bonus units available only for the creation of affordable and workforce housing. Thank you for your time and consideration.
Thank you very much. Chair Gear.
Thank you, Mr. Chair. So if I can understand your proposal correctly, I'm trying to get at the question of if a town can demonstrate that it has, for example, provided 10% of its housing as affordable to people with median incomes or lower. if that demonstration is made, would you support that? And how does that fit in with the way that you have proposed this?
I definitely would support personally. Again, I'm not speaking on behalf of the town now, or with my other caveat that I think I know what they're thinking. We're definitely interested in supporting affordable housing and have done in an objective evaluation of it, a pretty good job, but not a great job so far. So we need more of it, for sure. There's no doubt about that. So a metric would be good, but that wasn't the point that I was trying to get at with my rate of growth commentary.
I'm just trying to understand the rate of growth, because you can have growth that is all high-end development, or you can have growth that meets the needs of the community for workers and regular folks to live there. And for me, those two things are very different. One can present different challenges than the other. And I guess I'm just asking you to respond, or if you have any thoughts for the work session.
Yeah, I'd be happy to respond. Thank you for the invitation to do so. Let me give you an example of exactly what's going on in Brunswick now. We've had rapid growth everywhere. We had close to Naval Air Station closed. There's been a ton of growth there, particularly in rental housing. There's been rapid growth and cascading volume of applications for market rate housing throughout the town in both the growth areas and in the rural areas. So we're concerned about supporting the general goals for housing, yes. Definitely trying to get more affordable housing, but not wanting to lose control of the overall rate of growth in our town. So in the comprehensive plan, which we just adopted 2 months ago, we have 3 areas, mapped areas. We have a high growth area, which is the designated growth area. We have a medium growth area, which we call medium density, which is on water and sewer, but not in the growth area. So there's your category B, and it's primarily existing residential neighborhoods. And we have C, all other, which is not on water and sewer or the rural area. Mm-hmm. We are currently having we have a moratorium on further applications in the rural area only because we want to direct growth into the other 2 areas. And while we have a moratorium on the rural area, which had a great number of applications, which caused the moratorium to be enacted, we're working on a rate of growth ordinance just for the rural area. And we think that makes sense from a smart growth point of view. It's definitely congruent with our comprehensive plan. It doesn't have anything to do really with the overall general policy direction to create more housing of all types and affordable housing, because most of that housing should be in the more developed areas. And we don't know whether we can do that and how the mathematics that apply to rate of growth would apply. So my suggestion is to just take out the areas that are not serviced by water and sewer from any of the restrictions on a rate of growth ordinance provision.
So just to be clear, you want to make sure that in areas that are not growth areas or have water and sewer, that you have the ability to have a rate of growth
Yes.
Ordinance. Okay. Representative Cullimore.
Thank you. Also for clarification, so I saw the press thing that came from Brunswick about the concerns that you're bringing forward. And one of the things I was thinking, and I'm curious to hear your input and maybe for the work session, what the official input would be from the town. If we had, because I like metrics too, if we had like the rate of growth is from a set date, like let's say 2015, to throw a number out there, and you've hit 130% of your growth, then you're already there because Brunswick has been growing so much. Same thing for Portland and South Portland and all of those southern areas. Would that be something that would help alleviate some of those concerns and issues?
I would be
'Cause
very
then it's not a
happy to
moving
bring back
target.
the official town position to a work session about that.
Thank you.
Representative Julia.
Thank you. Hi there.
Hi there.
I would sort of just like to also request like more information about more detailed information about the issues that you see regarding the rate of growth and the minimum development requirements for the work session, if that's, if you want to elaborate a little here, that's up to the chair.
No,
would
I
like
think,
to
I think
definitely see it.
that I'm happy with the opportunity that I've had to explain things.
Thank
And
you.
in the interest of time, I'll bring more back to the work session and a ticket that says I'm actually representing the town.
Well, I will remind committee members, we can always reach out to people and say, let's have a conversation and educate me on an issue. So
Thank you very much.
thank you. I think next we have David Parent. Welcome.
Good afternoon, Senator Curry, Representative Gear. Am I pronouncing that right? Gear, I'm sorry. And members of the committee. My name is David Parent. I'm the superintendent of the Sanford Water District, and I'm here testifying in opposition, but I want to say it's just on a handful of very specific sections in the bill. I have no issue with the remainder of the bill, take no position on it, and support affordable housing, like many other people have come up here to testify. You should have a copy of my written testimony, and that'll provide further details on my position. I'm going to try not to be redundant to what Roger has already testified to. So Sections 7, 10C, 12, and 18 prohibit local subsurface wastewater disposal ordinances that would be more stringent than state regulations. Sanford's public water supply consists of multiple gravel pack wells that are located in various areas of the community. So we have a wellhead protection ordinance that prohibits septic systems in those portions of the wellhead where they negatively impact the public water supply. It does allow septic systems in other areas outside of the sanitary zone and under certain restrictions. Our ordinance is really tailored to each specific site, each specific well, which has been delineated, and the land uses around them. So there is no one size fits all that works for groundwater public water supply. Ours has struck a good balance of allowing development where we can still effectively safeguard the public water supply and in preventing things such as septic systems that are too close to the wells. Eliminating these protections would be detrimental to our public water supply in Sanford. While I recognize and support the urgent need for additional housing opportunities in Maine, certainly we're having those issues in Sanford, it's critical that such efforts not undermine longstanding protections for public water supplies such as ours. Reliable public water and public water infrastructure actually is essential for affordable housing because it allows a lot more density and sustainable housing development where there may not be water resources. So preserving the municipal authority to protect these water sources is supportive of growth rather than hindering growth, even though on the surface it looks like it may. So I'd like to urge the committee to carve out public water supplies in these four areas that I talked about, and I'd be happy to work with the committee on language to do that. I think there's a couple different ways to approach it. So thank you for your time and consideration, and I'd be happy to attempt to answer any questions.
Representative Cullimore.
Thank you, Mr. Chair. Thank you for coming before us today. I'll ask a similar question.
Yep.
Do you feel DHHS's standards are not sufficient, and should that be where we're addressing the issues?
No, so they're not sufficient, but the reason they're not sufficient is DHS, not necessarily in that section that you've quoted, elsewhere, tells public water supplies that have a groundwater source of supply that they must do their own wellhead protection ordinance. So in our case, if you look at our wells, actually I was just talking to Roger about this before I came up on one of our sources. Some sources are deep sources with a deep aquifer, And what we call the sanitary zone, the 200-day travel zone, which is where we don't want the septic systems because of bacteria and viruses can survive in the ground for that long. They might be kind of tight in those areas, but in other areas where it's a shallow aquifer, they reach out a little bit further. And then in the next zone, which for us is a 2,500-day zone, we're fine with residential septic systems, but we don't want industrial subsurface wastewater discharges because they do different things to your water than residential ones. So there's no real one size fits all. DHHS, I think if you look at their regulations, says it has to be, I may get this wrong, I think it's 100 feet from a drilled well, 200 feet from a dug well. That wouldn't work for us at all. I think our smallest one is probably 400 or 500 feet away. These are high capacity, high yield wells, gravel pack wells, which is basically a dug well, fancy dug well. And we scientifically delineate them, figure out how long it's going to take for the water to travel underground to that source. So there's no state regulation. Trying not to be negative, but if the state tried to fix that one, they'd mess it up pretty bad. So it's really site specific. A lot of science involved.
One second. I just want to double check. You mentioned 10C. I think it's 11C in the.
Oh, that could be right.
Yeah. I think it's 11C, but
You are right. I
Okay.
skipped over one. I apologize.
All right. Just making sure because I don't see a 10C.
There is not a 10C. It
Okay,
is
thank you.
11C. Yeah.
Chair Gear.
Thank you, Mr. Chair. And this might be a question for work session. One of the things that I remain concerned about is the fact that we continue to permit 14-unit subdivisions out rural roads, all on septic in so many places around the state for reasons that we delve into in this committee. Is there any place that is constantly evaluating the risk of that? Because I know when I talk to folks who are in your world and in the world of installing and managing the systems, they are very, very, sure that they're doing all the right things. I worry about the cumulative effect of that. And is that the water district's responsibility to say, we seem to be getting some bacterial infiltration over here. Where could that be coming from? How do we monitor that when all of these systems are, basically associated primarily with single family homes?
Yeah, that's a very good point. So in Sanford, we're a little different because we're in the glacial outwash plain of southern Maine, many sands and gravels. Where you have more bedrock that will travel over bedrock, it may be an issue. With a housing development, they are required normally, especially if there's wells involved, to get a hydrogeologist on board. They calculate the plume to make sure that that's not happening. But it's certainly an issue. And in Sanford, I was on the comprehensive planning committee a couple of times, and we're right now updating the comp plan. The old one called for public and water sewer in certain areas, and that was 20 years ago. And the problem now is that the cost of extending the sewer has escalated so high that it's resulting in properties not being developed rather than creating the densities that they had hoped for. So it's certainly a concern in some areas with the nitrate polluting water supplies, whether it's public or private. Certainly.
Just to follow on from that, just for the work session, again, just trying to figure out if the monitoring, is there a way that that's being monitored, and what should we be looking for? For example, with the rate of growth ordinance, right? In the rural area, it would seem to me that if that wasn't a growing concern because of testing you had done, that would be a reason why the municipal authority would say, we've permitted a lot of development out here, but now we're not going to anymore. Like that, is there a mechanism in place where that can happen now? And if not, where would you recommend that be?
So with a public water supply, that happens. We test continuously. The larger we are, the more we test. But with a private supply, you test when you sell the house. That's it. Then it's up to the private homeowner to test the well. Nitrate's not an expensive one to test for, but it'd be on the homeowner. So you need not only, and it's not even just a funding thing. You'd have to get somebody to test their well to find out if there was an issue. And if there is an issue, nitrate is not something that's easy to take care of.
And just to clarify, there's no way that, say, the municipality would be testing nearby areas. Again, that's fine if you're the property owner, but if this is sort of infiltrating the water supply more generally, there's really no way to know that
There
until
isn't.
someone else does a test somewhere else and says, oh, look, we've got this problem over here.
That's exactly it. So if it's public water supply, as I said, we're testing monitoring wells. Private water wouldn't be. There are some other areas that they have to test water quality. Gravel pits come to mind. They have monitoring wells all around them, but in general, no, it's a private well. It's test it once, test it when you need to sell it. And if you find an issue, you put in a system. Hard to track.
Want to just check in and see do those three sections, 7, 11C and 18, do those get resolved if they have an exemption for required, if the municipality has a requirement to have a wellhead protection ordinance?
There'll be wellhead protection and also some surface water supplies.
Yeah,
Yeah.
in addition to, what the previous gentleman brought up.
Yeah, I think that'd be one of the two ways to do it, with one exemption within the bill somewhere.
Mhm.
Or, I mean, that's really up to your analysts, or they may tell you to fix
But
it
if
in
you had
every
those two
section.
things, the source of supply and
Yeah.
the wellhead protection ordinance requirement.
And,
something
and you may even be able to bring it up a level, just call it public water supply, and that would cover everybody and keep it simple.
Okay, thank you very much.
Thank you.
Rich, is it Kindlen? Kindlen, welcome.
Good afternoon. Senator Curry, Representative Gear, and the esteemed members of the Committee on Housing and Economic Development. My name is Rich Kindlen, and I have the privilege of serving the community of Scarborough as their fire chief. I'm here today, though, speaking on behalf of the Maine Fire Chiefs Association and the Maine Fire Chiefs Association Code Committee. And we're writing to express our collective opposition to LD 2173, an act to update the laws regarding housing development and accessory dwelling units. Municipal fire departments across the Maine share the goal of supporting safe and sustainable housing development that strengthens our communities. However, LD 2173 imposes broad statewide mandates that significantly alter local land use, density, and fire protection considerations without adequately accounting for municipal capacity, emergency response realities, and community-specific risks. The impact on fire protection and emergency response. LD 2173 expands residential density, increases allowable dwelling units per lot, and permits additional building height and limits municipal review authority, all of which directly affect fire department operations. Higher density and taller residential structures increase response times, response demands, increases the complexity on the fire ground, the staffing requirements to fight those fires, and the equipment needed, including ladder trucks and other types of specialized equipment for taller buildings. Yet the bill does not provide additional funding, staffing, or infrastructure support to fire departments tasked with protecting these developments. Reduction of local oversight and risk management. This bill significantly restricts municipal authority by eliminating planning board review for up to 4 dwelling units, prohibiting municipalities from enforcing stricter wastewater and density standards, and mandating minimum unit counts regardless of a neighborhood context. These changes remove essential checkpoints where fire access, apparatus turning radius, water supply, and evacuation considerations are traditionally considered or evaluated. For departments with limited staffing, like most of rural Maine, these reviews are not bureaucratic hurdles, they are critical safeguards that prevent unsafe development patterns from becoming permanent public safety liabilities. One size does not fit all. Our Maine municipalities vary widely in geography, population density, infrastructure, and emergency service capacity. A rural town with a volunteer fire department and no public water system faces vastly different risks than an urban municipality with a staffed engine company and hydrant locations and hydrant coverage. LD 2173 applies uniform mandates across all municipalities regardless of the fire department staffing levels, availability of mutual aid, and distance between stations and access to roads. In our conclusion, municipal fire departments support thoughtful housing solutions that balance growth, with safety. However, LD 2173 overreaches by imposing a one-size-fits-all approach that disregards local capacity, diminishes municipal authority, and creates new public safety risks. We respectfully urge the legislature and this committee to reconsider this legislation, preserve local control, and ensure that any housing policy changes are paired with meaningful support for emergency services, local municipalities, and are not just blanket mandates. We thank you for your time and consideration. The Maine Fire Chiefs Association Code Committee.
Thank you. I'm a little confused, and so I'll just ask the question because this bill is LD 1829 passed a lot of this. This is putting limits on that. So we don't pass this, you're going to have higher limits.
Yeah.
You're going to have higher, you know, you could get like now we're at 70 feet.
Yeah.
You know, or things like that. So my concern is that to do the things that you just argued for, we've got to pass something. That will.
I think our hope is
if we do nothing, then we're at the state where you just argued against. So are there, you know, if you're going to argue to repeal 1829, you can argue for that, but if we're not arguing for that, what in this, and maybe that's for the work session, I'm not going to ask you to try to do that, but what, you know, if we need a bill to pass, what does the fire, the code committee?
I think that's what we're really looking at, Senator, is really an opportunity to have those conversations where we feel we did not have those, that opportunity to weigh in and be the subject matter experts in 1829 or in 2173. We understand the process and how that's all working.
Okay.
But we would not support, the Maine Chiefs would not support any legislation that limits us are using the National Fire Protection Association Life Safety Code, which we've been using for a very long time.
Okay, great. Thank you. Representative Collmore.
Thank you, Mr. Chair, and thank you for coming before here. I don't know how much you watched of 1829, but I fought a lot about the fire stuff.
Thank you.
My town does not allow 3-story buildings because we don't have a ladder truck to support that. So I really pushed hard for that. What I'm concerned with, because I agree with what our chair is saying, is that we pass nothing. It's making it worse because 1829 is in effect. What I am wondering is when we made some of these adjustments to specifically like section 6, 2A, to be eligible for additional height allowance pursuant to this subsection, the development must be reviewed by a fire official or designee during the development process. Does that, and it continues on that the fire official provides those recommendations and those things. Does that not cover the concern that you have? And how can we make it more clear that fire needs to say that this is safe and we're not going to kill a bunch of people living in a 5-story home?
Yeah. I think to your point for that specific instance, I think you're right. That probably would help solve that particular issue. I think that in some of the other issues though, that's 2173 and 1829 have brought forth is the concept that our codes, our life safety codes are stifling growth. And those are some of the reasons why we're trying to oppose anything that has anything to do with the life safety changes from what we're currently doing that we've been doing for decades and has worked for a long time. The Maine Fire Service has fought extremely hard over the years to get what we have, and to have any changes to that is a concern to all of us. So.
Okay. Thank you. Chair Gear.
Thank you, Mr. Chair. And can you just explain to me, when you talk about response time demands, I'm thinking about encouraging greater density and again, allowing greater height in places where the correct equipment exists. How would that increase response time demands as opposed to, you know, sprawl development out far?
And maybe that was a mischaracterization about increasing the response. The response demands are going to be different. When we show up to a building that's not sprinkled or has a single stairway, that additional time that some of us, you know, Scarborough, we have full-time staff. We get out pretty quickly, but most of the state of Maine is fairly rural and has volunteers, and that response time, all that time adds up to getting to a building or to a situation where they're already going to be behind if there's been codes that have been reduced, whether it's sprinklers, stairwells, different things like that. Those are all parts of 1829. I understand that, but any limitation on the codes is going to create issues with our response time.
Senator Bennett.
Thank you, Chief, for being here. this may be unfair, but I had received some communication from the town of Scarborough about concerns with LD 1829, and apparently there was a public meeting on January 21st.
That's correct.
Which I did not attend, but I was invited to along with, I guess, every member of the legislature. And that workshop, there was going to be discussed the town's concerns with 1829 and proposed revisions. I then look in our file here and I have and I don't know if he's going to be testifying or not, but I have a note from Jonathan Anderson. Do you know if he plans to testify?
I don't believe, he may have been online. I know he was going to try and be online,
okay,
but I do have
Is
another.
he? Okay, he's online, I'm told, so I'll just wait for that. But did you participate in those meetings on January 21st?
I did view them. I was not at there personally. I did view them remotely, yes.
You did, okay. And does your testimony, I guess I'll wait for him on the broader picture, but your testimony on public safety concerns, is that consonant with what we're going to hear from him regarding the overall town? Or is there, what kind of coordination has there been?
So I'm speaking on behalf of the Maine Fire Chiefs. I did not make the position on the town of Scarborough. While I believe that we're in the same, similar to the council that spoke from Brunswick, we have the same thinking.
Okay.
But my stuff was public safety based from the Maine Fire Chiefs Association. I was asked to
all
speak
right.
today.
Thank you very much. Appreciate it.
Thank you very much. That concludes all the folks who have signed up to give testimony in opposition in the room. We'll now shift into those who wish to give testimony in neither for nor against. We'll start with Jamie Garvin.
Good afternoon, Senator Curry, Representative Gear, and members of the Joint Standing Committee on Housing and Economic Development. My name is Jamie Garvin, and I'm the Director of Community Affairs for the Greater Portland Council of Governments. GPCOG represents 25 southern Maine communities, and I'm here today to provide testimony neither for nor against on LD 2173. Let me first start by saying our member communities share the legislature's commitment to addressing Maine's housing shortage. We want to be part of the solution, and many of our communities today are actively being part of that solution. LD 2173 makes some helpful technical corrections to LD 1829, and we appreciate Representative Collimore's work on this bill. We do think, though, that more reforms need to be included either in this bill or supplemental legislation. Fundamental implementation challenges facing our communities need to be more comprehensively addressed. First, infrastructure capacity. Communities like Wyndham, for example, are processing over 900 dwelling units in the next 2 to 3 years, on top of averaging more than 112 units annually for the past decade. Water, sewer, stormwater, transportation systems, and schools simply cannot accommodate this growth without capital investment that exceeds local budget capacity. LD 2173 contains no infrastructure funding, no prioritization of state resources for growth areas, and no relief from impact fee restrictions that prevent municipalities from planning for regional infrastructure needs. Second, growth management tools. LD 2173 does not restore the ability of fast-growing municipalities to manage growth responsibly. In fact, the changes to the rate of growth ordinances requiring 130% of a 5-year mean instead of 105% of a 10-year mean make these tools even harder to use. Communities that have been regional leaders in housing production now have fewer tools to align development with infrastructure capacity and comprehensive plans. In fact, we're hearing from some communities that they're actually looking to reduce their growth areas in response to LD 1829, which is, an obvious negative incentive. Third, comprehensive planning. LD 2173 does not remove density mandates outside designated growth areas. Municipalities have spent years developing comprehensive plans that identify where growth should and shouldn't occur. Yet the law still requires density along water and sewer lines that may traverse rural areas, farmland, or natural resource areas we've deliberately chosen to preserve. This creates, again, a perverse incentive that undermines smart growth principles. Fourth, implementation timelines. The July 1, 2026 deadline remains unrealistic. This fixed bill will require additional rulemaking on top of the just completed LD 1829 rules finalized last month. Other housing legislation is still pending, such as LD 1375's Regulatory Barriers Working Group, LD 1926, and others. Many municipal charters require months-long processes that don't allow midstream changes. We need to get the time to get this right. LD 97 and subdivision threshold changes don't take effect until July 1, 2027. That's the deadline that we think LD 1829 should have had and would better harmonize these multiple work streams. Finally, affordability outcomes. We all want this law to produce housing people can actually afford. But LD 2003's density increases have produced $600,000 condos and multi-million-dollar homes in our southern Maine region. LD 2173 contains no mechanisms to track affordability covenants or support municipalities in administering them. Our communities are not asking for an opt-out. They're asking for the tools and resources to implement this law successfully in ways that produce the housing Maine needs while maintaining the infrastructure, natural areas, and comprehensive planning frameworks our communities have developed through years of deliberate public engagement. We urge the committee to further strengthen LD 2173 by extending implementation deadlines and removing density mandates that conflict with those comprehensive planning principles. Furthermore, additional provisions of supplemental legislation are needed to address the issues of insufficient infrastructure necessary to support the growth envisioned with LD 2003 and 1829, along with measures to ensure the affordable homes each is intended to produce actually come to fruition. Thank you for your time, and I'm happy to answer any questions.
Chair Gear.
Thank you, Mr. Chair. And Mr. Garvin, you can choose to answer this or bring something back for the work session. But I'm curious from your membership's perspective, would there be support for some measure of affordability, percentage of affordable housing that exists in a particular municipality, for example, being used as some sort of a gating factor? Because this is the tension still exists. I totally get the points that you raise here. By the same token, some communities are doing making a much bigger push in that direction than others, and actually taking action on the ground. So would there be an appetite for that? Would you have something different that you would suggest?
I'll be happy to come back with a more broadly reflective answer of the membership, but I would say, generally speaking, our members strongly favor affordability. It's one of the things that was highlighted in the testimony that I just prepared, which is that the previous measures under LD 2003 and LD 1829, a lot of our members feel like don't do enough to actually focus on the deliverable, the outcome of affordable housing production versus just allowing for more housing. So, as I know you're well aware, adding more supply is critical up and down the spectrum, but nothing in either of those pieces of legislation has yet resulted in, I think, the significant delivery of actual affordable outcomes versus just additional production. And I'm happy to come back with further suggestions on how that might be achieved.
Senator Bennett.
Thank you, Mr. Chair. Mr. Garvin, thanks for being here. So just again, sorry to kind of lay on to Chair Gear's question, but your last penultimate sentence here kind of begs us to consider something. And I'm wondering if you could provide something more specific relating to additional provisions needed to address the issues of insufficient infrastructure necessary to support the growth envision, along with measures to ensure the affordable homes each is intended. Those two pieces, I think we need something specific. And I know you've given a lot of thought. You've got members who've given this a lot of thought. I've read a whole folder here of testimony, a lot from your area. And I just would really benefit, probably the committee will, and certainly the whole issue would benefit from more specificity as to what exactly you're asking for.
Sure. And I don't want to take up too much of your time with this public hearing, because in specific, in answer to your question, infrastructure concerns are some of the largest issues that have been brought up by our members. And I know that this bill in particular is not designed to, specifically address funding for infrastructure. But the point being that all of the legislation that has, made changes to land use regulations without providing concurrent and sufficient infrastructure funding to be able to actually
create the housing that's needed, is really putting our members and our communities in a bind where the land use provisions might be changing, but the reality of what it takes to actually produce that housing has not.
Yeah, I would just simply say, it's okay to move beyond the provisions of this. I think too often we get stuck with the legislative instrument. Your points kind of connect this bill with other things that need to be connected with. And, if you come back and say, well, this will be okay when there is sufficient infrastructure help in this way, that kind of thing is really helpful for us. But I think we everybody in this room, both sides of this piece of oak or whatever it is, I think really want to build more affordable housing in as efficient a way as possible and as quickly as possible, because that's really the key here. So I just want to get to specifics as soon as possible. I just invite you and your members to lay that out for us.
Thank you.
Thanks.
Chair Gear.
And thank you. I hate to, Senator Bennett and I are riffing back and forth. The additional question I would ask is, for your region, you as the regional planning organization, to me, you're the ones that are best equipped to say, when we look across this region as a whole, how should we be thinking about our housing needs, both for economic development, sustaining our most vulnerable population, our seniors, et cetera? How should this look, and how should this be deployed, and how should that need be met across these communities? And I think that's where there's this constant tension for me, because we're down at the municipal level, we're up at the state level. What we really need is a plan that a region can come and say, to get to the level of economic development we want to see, and to continue to sustain Maine's economy as a whole, here's what we need. And then here's the housing that we need to support that for people, so they don't have to drive an hour and a half each way to work, as we all know people are doing in many parts of our part of the state. So it really does require, it's an opportunity. It would be a missed opportunity for us not to tease that out during the hearings and the work sessions on this bill, to really get to how do we do that. It's a great opportunity. So come and tell us.
We would love to be an active partner in that. You obviously don't need to convince me of the benefits of regional planning. So we'd be happy to come back and be part of that discussion with you. So
thank you. Thank you very much. Larry Keane.
Senator Curry, Representative Gear, thank you very much, and the whole committee. I am Larry Kane, the Vice Chair of the Scarborough Town Council. And one of the benefits of going late in the process is that you've heard lots of what I'm speaking about. I think I'm talking more about impacts to local communities, maybe, is more than the technical side of either the legal part or the planning part. Throughout this public process, you're going to hear from many stakeholders about the current version of 1829 and the corrective proposed LD 2173. They may not effectively address all the housing needs, but they will add undue burdens and unintended consequences to communities in Maine. I agree with that 100%. Please listen closely to these facts and the logic that support these speakers. You'll hear from a number of Scarborough elected officials, public safety, and our residents, both in written testimony and live. Not because we're against this law or these two laws' intent, but because the components of the laws so drastically affect our town. If you choose to move forward without a more thorough review of the goals, intent, and impacts, I want to offer suggestions that should be the bare minimum of improvements to 1829 through 2173. I've included a red line version of the act that our planner prepared, just for reference after the fact. As some of you know, Scarborough has been very active and invested in following the progress of this law. I want to express my appreciation to Speaker Fecteau, the sponsoring Representative Collmore, for recognizing the need and participating in the process of improving 1829 from its enacted version and with the proposed changes under 2173. We also appreciate that along with the speaker, we had Representatives Warren, Gatine, and Murphy attend a public forum hosted in Scarborough that was very productive for everyone. Scarborough has a decades-long commitment to residential growth. We have a significant amount of land that has been available for development. We have outstanding schools, beaches, healthcare, and community services that are attractive considerations for home buyers. However, we also have the largest saltwater marsh in the state, a working waterfront, and a long tradition of rural farming. All of those need to be actively preserved, and those competing factors have led our town to already be excellent stewards of planned growth, along with welcoming new residents. I can also proudly report that our town recognizes the need for affordable housing, and it should be a top priority for both state and local governments. I want to stress we're already doing our part. Our housing initiatives include a commitment to affordable housing, and we have demonstrated that with approved projects, direct grant funding, and development subsidies through credit enhancement agreements. My first topic, I know we're going to have to be quick now. My first topic is.
I will ask you, so our time is elapsed, but I will ask you about, I want to know about your growth ordinances, which is the next paragraph. So
Right,
keep
that's
going.
why I was going to skip
Yeah.
right to that one.
So that was
so-
my first question. So just go ahead to.
So
growth ordinances.
the current growth ordinance is 105% increase over a 10-year look back period. The corrective legislation changes that to 130% increase and a look back period of 5 years, which obviously then accelerates the compounding of that 30% over years. And so here were some facts, was what I was trying to get to. Over the last 5 years, we've averaged 226 housing permits per year, and there's years prior to that it's been even higher. With 130% increase over the next 5 years, would be required to offer 331, or in the next 5 years, we'd offer 331 permits in that fifth year. And over that period, a total of almost 1,500 permits. If we base that on an average land use of less than a quarter of an acre, that's over 345 acres of land. So that's saying the real impacts. I'm going to pass over my comments on the unfunded burden for traffic, public safety and infrastructure. But my point there is that Scarborough is already doing this. We've hired 10 new firefighters. We've bought a new ambulance. We've just approved $140 million school project that covers 5 different schools in town. And even with the tax burden and debt burden of that, our town approved that ordinance. That referendum. So other towns, I think, as you bring this on, will need to take into account those infrastructure impacts. The point been made before with some of the density provisions you're making without having an affordability or a workforce requirement, you have the possibility, which we've seen in town, of just having more market rate growth, which isn't the intent of the law, and it isn't good for the town.
If you could summarize, and then you have questions, and I bet we will get to everything you're looking to.
Actually, I'll just close kind of with the summary of where I am. I'm not here to argue the need or the intent of this law. I'm not here to propose changes that weaken the law. I'm here asking for consideration to make this law work better and take into account the unique details of various Maine communities. And you've heard kind of this one-size-fits-all objection that would lead to better outcomes for housing affordability and availability.
Can you educate me on, clearly you're getting added impacts and costs to the municipality, but you're also getting a lot more taxes. How is that in property values? How is that playing out in terms of, like, is your city budget going higher, or your municipal, are people paying more in their property taxes because of the rate of your city budget? I come from a very different district, and so that would be educational for me.
it's somewhat in parallel that are certainly our tax revenue is going up, but our infrastructure costs, like I described, are outpacing that. And for instance, I won't get this exactly right, but it's roughly $20,000 a year to educate a child in town. And there's no way, even with the largest, most valuable homes, that they're contributing anywhere close to being able to cover that additional cost of the growth of the population, the school population in town. So that's one example, but I'd say generally it does not keep pace.
Okay. Thank you. Chair Gear.
Thank you, Mr. Chair. And to get at the heart of the matter, when you talk about those 226 permits per year over some period of time, what is the proportion of those that are affordable to those making median incomes?
I don't know that off the top of my head, but I can certainly get back to you on it. And actually, Councilor Anderson, who's going to speak, he may know that exact number.
Okay, and then my follow-on question from that is, based on the acreages you just provided, my sense is that this is not, the development that you're seeing is not town center, maybe outside of Scarborough Downs, town center kinds of higher density development that produces a greater concentration of tax revenues, right? That we all know about that equation, right? How much of the development is sort of town or village center development in Scarborough versus large single family homes?
Much larger percentage of multifamily and in the dense zones of where our growth is. The acreage reference was just based on a average less than a quarter of an acre, because there is still single family development and all, to try to get kind of an average, and it was a metric that was easily to understand.
Okay, I'm just going to say a quick thank you for all the housing. Yay.
Senator Bennett.
Thank you, Mr. King. Thanks for being here. Like Chair Curry, I live in a slightly differing kind of environment than you do. I live in rural Maine, but just about 45 minutes north of Portland, and I think we're next. I just really wanted to just confirm, I mean, are you embracing the changes that you said were the red line changes that is your planner who did the red line?
But sorry, go ahead.
Yeah, are you in support of those changes?
Yes, and our town council issued a proclamation unanimously supporting that.
So the changes actually look fairly modest in terms of, now I see there's a knot on, crossed out, which can be a huge change, but but a lot of it is just moving date out by a year or two.
Yes.
To comply. And the other one is to change that 130% number down to 105 and extending the look back period over 10 years. Is that right?
That's right.
And then there's another section here where you, on page 4 at the bottom, where there's a section crossed out, part of section 11. Can you just talk to that? It's under section.
I think that's the public water and sewer.
Yeah, it's
page 5, sorry.
Page 4, at the bottom, there's a red line crossed out. It lines 34 through 42. It does have to do with lots outside designated growth areas. I just trying to understand what you're.
I'm reading that. It's pretty dense.
Yeah, that's mostly, I don't want to put you on the spot. I really appreciate your coming with something very specific, and I appreciate your public process informing legislators. And as I said earlier, great to be invited to the 21st and all of that. It's really good. This is important stuff. So, and then I did see a knot here crossed out somewhere. Oh, a municipality may enact or enforce rate of growth ordinances that limit residential. On the top of page 2.
Right.
What does that do? Do you know?
Off the top of my head here again, I'm saying the original intent was a municipality may not enact or enforce a rate of growth or ordinance that limits residential development in growth areas as authorized. So it's saying now that we can enact that. Yeah.
Yeah. Okay. Again, many thanks to you.
Thanks. And I'll say, obviously, I'm not the town planner. And we're, like others, we're very happy to contribute to the ongoing process and would really look forward to that input before this gets done. It's one of the pieces I think a lot of the people that have objected were felt left out of the process on the original law.
Thank you.
Thank you.
Thanks.
Elizabeth Fraser. Welcome.
Good afternoon. Chair Curry, Chair Gear, and honorable members of the Housing and Economic Development Committee. My name is Elizabeth Fraser still, and I'm here on behalf of the Maine Real Estate and Development Association, neither for nor against LD 2173, but with significant concerns about the direction it represents. I just want to quickly say that I did submit my written testimony already, so you should already have that in your files, and that goes into more detail. Last session, this committee passed LD 1829 to reduce regulatory friction and create clearer pathways to housing production. Less than a year later, we are discussing scaling portions of that framework back. That kind of regulatory whiplash undermines the predictability the housing market requires to respond at scale. Housing production depends on long-term capital decisions. When the rules change quickly and frequently, investment slows. If we want lower per unit costs for Mainers, we must reduce uncertainty, not add to it. And there are 3 areas of concern that we had. I'll just mention them briefly. First is the proposed change to the growth ordinance provisions, because they risk artificially phasing housing in areas where municipalities have already designated that and indicated that they want growth. Phasing does not reduce demand, it simply raises costs by constraining supply. Second, we encourage the committee to consider a rebuttable presumption on height allowances, subject to legitimate fire and safety concerns. Each time a housing creator must seek discretionary approval, it creates delay and invites project-killing opposition. Predictability does not eliminate local control, it clarifies expectations. Third, references to DHHS subsurface wastewater standards raise practical concerns. 80% of Maine is not served by public sewer and water. If we inadvertently discourage housing that relies on septic systems, we exclude large portions of the state from meaningful creation of housing and concentrate growth only where infrastructure already exists. That will not lower costs. It will intensify pressure in a handful of communities. More broadly, regulations are restrictions on property rights. They remove sticks from the bundle. While regulation serves important purposes, it also increases costs and reduces flexibility. If our goal is to attainable housing, to reach attainable housing in the state of Maine, we must be disciplined about when we add restrictions and cautious about reinstating them after we have just provided relief. We cannot manage scarcity and expect abundance. If Maine is serious about workforce growth, affordability, and generational stability, we must provide predictable, practical pathways to build. For these reasons, Marita urges caution and thoughtful consideration before moving forward with this bill. And again, I'd be happy to answer any questions and did go into more detail on some of our specific requested changes in the written testimony as well.
Representative Callamore.
Thank you, Mr. Chair. Specifically with the subsurface wastewater disposal section.
Yep.
Do you feel that the language does the opposite of what was intended? The intention, of course, being that it allows for more growth, where you're saying it looks like that this could actually inhibit growth in those areas. I'm not quite sure I'm understanding the full scope of what it might be doing unintentionally.
That's totally fair. And I don't think I have a copy of the bill with me, which I should, so that's on me. Of course I do. Yes, it's right in front of me. Hang on a second. Yes, because this was a specific section of that section, and I want to make sure that I'm getting it right. If anyone happens to know where it is, just point me to it. I think it's here. Yeah, okay. So what we were referring to is the section here, and it may be that the intent was to allow more, but the section 7, 30A MRSA 4364 lines 31 to 34 provide that a municipality may not require minimum standards for subsurface water, essentially beyond that which is allowed under DHHS's sort of survey rules, which is a 20,000 square foot, basically 20,000 square feet lot size limit. So you've, or minimum, got to have a minimum 20,000 square foot lot size if you're going to have a septic system. I just very much oversimplified that. And actually what I just said is the concern of our members who are land surveyors, because, and I will get more clarity on this. It's a little complicated, but their position is essentially that the DHHS rules are designed for the engineering of a septic system, right? And those rules look at a lot of complex and varied areas of what the design of the system will look like in the land parcel. They do set a 20,000 foot floor, but it is not intended to be a land use policy. So if this committee is interested in setting a floor for properties that would use subsurface wastewater, I think that you should just put it right in the 20,000 square feet. But I think for our members, not tying the DHHS regulations in as land use provisions was important, because they feel like those are separate and those are for design professionals as opposed to land use regulations, which set, you know, basic limitations and maximums.
See no other questions. Thank
Okay.
you very much.
Thank you very much.
Greg Day with the Maine Fire Marshal's Office.
Good afternoon, Senator Curry, Representative Greer, and honorable members of the Housing and Economic Development Committee. My name is Greg Day, and I'm the Assistant State Fire Marshal. I am offering testimony on behalf of Fire Marshal Sean Eschler, neither for nor against LD 2173. The Office of State Fire Marshal recognizes and appreciates legislature's continued efforts to address Maine housing challenges, and we understand that this bill is intended to make technical adjustments to prior housing legislation to improve clarity and implementation. Our comments today are offered in the same cooperative spirit. We do not question the policy goals of LD 2173, but we respectfully highlight several provisions where additional clarification may help ensure life safety considerations remain aligned with existing law and legislative intent. In Section 1, Title 25, Section 2463B addresses, excuse me, fire suppression sprinkler requirements for accessory dwelling units. As written, the section limits sprinklers requirements based on the number of dwelling units within a structure, which generally aligns with existing life safety rules, as the state has long exempted 1 and 2 family dwellings from sprinkler requirements. Our office concern is not with accessory dwelling units themselves, but with how this provision could be applied in mixed use or non-residential due to the absence of statutory definition of multi-unit structure. Without clarification, this language may be interpreted to base sprinkler requirements solely on dwelling unit count rather than on occupancy type or hazard level. Taken as a standalone provision, the language could exempt an accessory dwelling unit located within or attached to a high hazard occupancy, such as a fireworks retail store, from sprinkler protection, provided the structure contains two or fewer dwelling units. By definition, such a building would meet the statutory threshold, yet this outcome would not meaningfully enhance public safety for occupants. We believe this is an unintended consequence. To address this concern, we respectfully request consideration of the following clarifying language. This subsection may not be construed to exempt an accessory dwelling from fire protection requirements when the unit is located within or attached to a mixed-use non-residential building, or when sprinkler protection is otherwise required based on occupancy classification, building use, or hazardous level from the National Fire Protection Association codes adopted under Title 25, Sections 2452 and 2465. We also note for the committee that approximately 22 municipalities currently have local ordinances requiring sprinklers in 1 and 2 family dwellings. As such, this legislation or any revision may directly conflict with existing local ordinances and raise home consideration. In Section 6, Title 30, 4364 allows additional building height for certain affordable housing developments and appropriately requires fire official review. We appreciate that recognition, as increased building height clearly represents additional life safety considerations. In reviewing the Section 6, we respectfully raise 2 more concerns. First, while the main Uniform Building and Energy Code appropriately governs structural height limits, the bill language may be read to limit fire official review exclusively to MUBEC by omitting reference to the nationally recognized fire and life safety standards adopted under current Maine law, including those enforced pursuant to Title 25. Although National Fire Protection Association codes do not establish height limits themselves, they address critical life safety considerations and are directly affected by increased building height, including means of egress, fire alarms, fire suppressant systems, fire department access, and occupancy safety. Fire officials rely on these standards and their professional expertise to evaluate the full range of risks associated with taller buildings. For this reason, we respectfully recommend clarifying Section 6 to reference rules adopted by the Commissioner of Public Safety or applicable NFPA standards in addition to MUBEC. Second, Section 6 provides that additional height allowance must be reviewed by a municipal fire official or designee, while also stating that the subsection may not be construed to grant additional authority or establish new standards for review. In practice, a requirement that a project may be reviewed may itself function as a new standard to review for municipalities that lack the personnel capacity, technical expertise, or training to conduct plan review, larger or more complex residential. These concerns are consistent with the findings of Legislature's LD 1005 Working Group, which identifies gaps in statutory authority and statewide consistency for large-scale residential projects. The working group noted that Title 25, Section 2448 currently authorizes fire and life safety plan review for projects or public buildings, leaving no clear, defined review authority for complex residential construction. The group also observed variations in how fire and life safety review is conducted at the municipal level, often reflecting differences in local resources, staffing, and technical capacity, which can lead to inconsistent application for requirements in differing outcome communities. Finally, to address this challenge, the Office of State Fire Marshal recommends consideration of future legislation amendments, Title 25, 2448, to authorize state level and life safety plan review for large-scale residential buildings, such as residential construction of 4 or more stories or greater, or buildings containing 16 more dwelling units, to promote consistency, technical expertise, and uniform public safety outcomes statewide. Implementation of such an approach would require the staffing resources identified in LD 1005 process to ensure review be conducted effectively and without delay. In this context, the requirement of Section 6 that a project must be reviewed, coupled with limits in fire official authority to MUBEC alone, risk creating an unfunded and inconsistent municipal review obligation that does not align with jurisdictional and capacity issues through LD 1005. Thank you for your time and for your continued commitment to public safety. We stand ready to assist the committee with these necessary amendments.
Thank you very much.
That was a lot.
Particularly appreciate, it was, but important. I particularly appreciate the specific language that you're recommending it in the various sections. On the last recommendation, did I hear it right? What you're recommending is for complex projects or tall projects or of a certain size, that they would have like a state fire marshal office
Correct.
review,
Correct.
which would require staffing and which would require,
Correct.
but to deal with the challenge of the municipality lack of capacity
True.
to do that effectively.
If you're less
Can you
than a
speak to
town of
that?
4,000 and you put a 16-unit apartment building out there, nobody's reviewing it. There's no requirement, a planning board may look at it, but there's usually not much fire safety or anything else.
And that is our recommendation, to give us the authority to look at these complex buildings. We only do public buildings, places of assembly, restaurants, hospital, nursing homes. But to give us a chance to review these 16 or more large residential places.
Thank you. Representative Callamore.
Thank you, Mr. Chair. So even though a 16 unit building would be considered commercial, you don't have authority there currently?
Many 16 units, if you just build an apartment building, it's not commercial. The fire marshal does not review residential properties. If it's licensed under Department of Human Services as an assisted living, we would do it. But if you build a 16 unit apartment building in Pittsfield, the fire marshal has no review over that at all. And that causes some inconsistency that we all try to get statewide. You could go build in a town of 500 people and not have any review. You go to Portland, Southport, Westboro, probably in Pittsfield, they have a good code enforcement there. You're going to get that full review. And that inconsistency is all over the state.
Other questions? Seeing none, thank you very much. We'll look forward to a robust work session.
Can I just ask, for work session, I'm curious what your idea of a perfect solution, what is your idea of the solution for that? I would just like to see, not for any other reason than to know what you think would be a solution to that.
For what part?
The last, when you said that there's inconsistency all over. Whoops, sorry.
Go ahead.
So we all know one of the problems in Maine is, right, lack
No,
of,
just for the work session, right? You
Oh,
don't have to tell me now.
I'll bring it in very good.
All right, great.
Yep.
Thank you so much.
And Representative Kuhn.
I'm in person in support. Is that where you are?
Oh, I had you neither for nor against,
I'm here in support, but if you,
but you're, yeah, we'll jump over.
okay, well, thank you for that. I give, oh, 1 second.
Yeah.
I'm also including Senator Perce's testimony and some model language.
Someone
that was
signed you up
submitted.
as neither.
Okay, well, I'll just say thank you. I'm glad to be here. And thank you for your endurance this afternoon. Senator Curry, Representative Gear, and distinguished members of the committee. I'm Amy Kuhn. I proudly represent House District 111 in the town of Falmouth. And it's a pleasure to be here to testify in support. 1829 from last year advanced a number of really important reforms, which my community and I support. I'm here today to ask the committee to consider 2 amendments to those reforms that would support the legislation's underlying goals while addressing the concerns of some municipalities. So first, as you know, 1829 allowed a density bonus in both designated growth areas and where there is sewer and water. I'm aware that a number of municipalities, including possibly my own, may be asking today for that provision to be repealed because they believe it undermines communities' comprehensive planning process by allowing dense development outside areas that a community has identified for growth. In the event the committee does not want to do that, I wanted to offer a compromise that the provision be changed to allow for the application of housing density bonuses to either growth areas identified in a state-approved comprehensive plan or where there is sewer and water if the municipality does not have a state-adopted comprehensive plan. In my community, for example, we have 2 growth areas with wastewater infrastructure, one on each side of town, with connectivity between them that traverses a low-density area that's valued for its rural character. This area includes a number of antique homes that were original homesteads in the area, with surrounding lands that serve as important wildlife and recreation corridors. These areas were deliberately kept separate from the growth corridors and reserved for low-density development in our most recent comprehensive plan. A comprehensive plan that also committed to boosting dense developments in other parts of town that do offer water and sewer, but also have sidewalks, access to transit, and other and amenities that make them really suitable for that kind of density. As you know, comprehensive planning is an expensive and time-consuming process. I co-chaired Falmouth's Comprehensive Planning Committee just a couple of years ago, and I can speak to both the financial investment and also the human capital that goes into achieving community consensus around growth that works for everyone, or at least most people. This process involved countless hours of community dialogue at workshops, neighborhood meetings, council meetings, in order to collectively get over the difficult hurdle of change and move on to the kind of productive planning that leads to a successful comprehensive plan. To be clear, this request is not a NIMBY-based type of effort to avoid building housing or even dense housing. Rather, it recognizes a community's interest in planning where the growth will occur. I'll add that in my own town, we are meeting the vision of our housing goals. Right now, we're building 48 energy efficient homes that are priced specifically for buyers earning up to 120% of the greater Portland area median income, specifically to address the needs of workforce individuals so that they're not driving an hour to get to work. Second, I would request an extension to the deadline. Although Falmouth has a town manager government, our charter requires 3 months' notice for council work on this type of ordinance. So for Falmouth to meet the deadline, they would have to bring a fully developed proposal to the council by April 1st, which is before this body even adjourns. It seems unreasonable to ask them to do that work when we won't even know what the law will be at that point. That kind of rush will almost certainly result in errors and unintended consequences. So I urge you to give our towns the ability to comply with the law successfully. So thank you very much. And I guess my testimony sort of was neither for nor against. So perhaps you called me at the right time after all.
Thank you very much. Representative Cullimore.
Thank you, Mr. Chair, and thank you for coming in support-ish. So I'm looking at the compromise part here. Is the intention of this, other than the fact that you're not the only one to ask for a repeal of that specific section, but would this be to take into consideration, which we've talked about so many growth management plans, I can't remember what thing is under what, but I feel like I remember at some point we talked about the reason B was needed was because you have municipalities without those comprehensive plans, and that would help protect those areas, those property owners, so that they could have an ADU for their grandmother or whatever built on there. So this would be a way of saying, well, if you have a comprehensive plan, you're covered because you have a designated, but if you don't, then you have to cover it. Am I understanding that correctly so that
Yeah.
we know what language we would need?
Yeah, thank you for that. I would just indicate attached to Senator Purse's is some suggested language. This is a markup of 1829, not a markup of the bill you're hearing today. So there might need to be some adjustment there because I don't think it's addressed in there. But you're exactly right. It would be if you're a community that has a state approved comprehensive plan. And I think that's really important because they're not going to approve a comprehensive plan that makes a growth area that's like 1 block large, right, to avoid building. If it's state approved, then the growth areas that are eligible for density are in that comp plan. If a community doesn't have a comprehensive plan, then it makes perfect sense to leverage that investment in water and sewer. And so that would be the fallback in the condition that you do not have a state approved comp plan. So thank you for clarifying that.
I notice sometimes, so we've heard
Mhm.
in our various bills on comprehensive plans is there'll be comprehensive plans that say we're going to pass these ordinances to promote growth. And sometimes those ordinances don't get passed. And so it's a plan for growth, but then the ordinances on the books are still preventing growth. Is there, and that's, I will just be transparent with my wondering of, is the plan enough? You know, is there some other test beyond the existence of a plan that's consistent with the Growth Act? Or is there some other, yes, you have a plan that's consistent and then something else of demonstration, oh, we passed those things, or is it conditional until I don't know. And some metric. I'll be transparent with my question, and if you have any recommendations, clearly you recommended just having the plan, and I have a wonder if that's enough.
Yeah.
So I'll leave it at that.
I think that's a really interesting question. In my community, we passed that comp plan and we started immediately digging in and doing that. But I can understand in towns who are differently situated, different staffing levels, that could play out differently. So I'm happy to look into that. Like, what is the enforcement authority or the enforcement mechanism when there's a comp plan in place and yet the ordinances aren't updated? So I'm happy to provide that.
Thank you. Chair Gear.
Thank you, Mr. Chair. And following on from that question, and has to do with a little bit of our former line of questioning, I think, on this. If that comprehensive plan had an outcome of delivering X% of affordable housing, however we want to define that, and it was being implemented on schedule, would that be a train of events that would support, kind of the approach that you're recommending that we take?
Yeah, so just the addition of a minimum, a metric to show progress.
Yeah, it's sort of some sort of gating factor that says, yes, we're going to do this, and it is going to result, what's the outcome? It's going to result in us, in our community, having a sufficient amount of affordable housing.
Yeah, I guess I would have to think about that a little bit because the municipalities are also different and they're all differently situated with respect to their own housing stock. I mean, in my community, I can tell you, we just need housing. It's like at every level. And so I also wonder if that's the right threshold. So I would love to just give that a little bit of thought. And I will follow up in an email.
Follow-on comment. I appreciate it because as we heard kind of from Scarborough, I think that there are parts of our state where market rate housing will get built in many situations, but the challenges that confront the goal of creating more affordable and middle income, missing middle type housing are Herculean, primarily because of all the costs and land and that sort of thing that we know about. So it's sort of like, how do we, create the gates that once you pass through, you're good. And then the law applies accordingly. Any thoughts on that would be very welcome.
Okay, thank you. I appreciate that. One of my last votes on the town council was for our workforce housing development. So I recall what that process is like.
And I hope folks that are participating in the very active participation of the regional planning agencies and the municipalities will hear those questions and chime in as well. Senator Bennett.
Thank you, Mr. Chair. Representative Kuhn, the folks from Scarborough suggested a 1-year extension. You said an extension here. Is 1 year what you'd like to see in this bill?
1 year would be ideal because then it syncs with other legislation so that the staff is going in and working on the ordinance at one time. So that to me seems ideal, but 6 months seems like a minimum.
Okay, thank you.
Thank you.
Representative Callamore.
Thank you, Mr. Chair. On the lines of the state approved comp plan thing where Chair Curry was going, I wonder if it's something, as you're thinking this through for the work session, if it's something along the lines of state approved comp plan that has ordinances in place that reflect the approved comp plan or something of that nature, then we're getting really to the point of not only do they have the approved comp plan, but they've actually had the opportunity to take those steps. And if they aren't in that world, maybe they have the approved comp plan, but it's expensive to change your ordinances. And not every town can go up to that. So if the compromise, if they have public sewer and water, until that is all implemented, it falls under this other category. If you understand what I
do. Let me think about that. It seems to me that I'll think about that.
Are there any other questions from the committee? Thank you so much, Representative Kuhn.
All right, thank you very much.
Oh, sorry, just gonna slip through here. So is there anyone else in the room who wishes to testify in any disposition on this bill? Seeing none, I think we can move to folks online. And I'm going to just call them out in the order they appear on our sheet. The first is Jonathan Anderson. Oh, I'm sorry. Wait, sorry. Let me take a step back. We're going to start out, do the same thing, in favor, against, and then neither. So the first is Thomas Poirier.
Good afternoon, Senator Curry, Representative Gier, and members of the committee. My name is Tom Poirier. I'm the Director of Community Development for the town of Gorham. And I'd like to say, well, one, thank you for picking up this bill to look at Act 2173 to correct some of or clarify some of the language that was done previously. We're in support of the bill with the changes made by the Maine Maine Association of Planners. And then a couple other things that we'd like to address is one of them is the lot sizes in the rural or your non-growth areas. As a municipality, that's one of the fastest growing in the state. Trying to preserve those rural areas, especially in Gorham, where we have a lot of farmland and historic farmland. We're trying to preserve farmland. Putting another detriment or to promote growth in a rural area, we don't think is the best practices. We're trying to reduce sprawl and target growth. We have done a lot of work in Gorham to target growth, to do transit-oriented development, and we are doing large-scale sewer extensions as part of Gorham to target growth. We just awarded a Main Street sewer project. We got federal funding to extend sewer in the Gorham Little Falls area, and we're looking at extending sewer to another transit-oriented development, South Gorham Crossroads, where they're redeveloping the golf course. These are tremendously expensive, and we're working to do these large-scale infrastructure projects, but we need to preserve that area in the rural as best we can. So the more tools we have to preserve the rural district, the better. And any incentive to develop in the rural district, we just think hurts really our agricultural heritage in the municipalities across the state. So if we could just strike out that language regarding identifying an area in the non-growth area, we think is beneficial as we move forward with the bill. Having seen a lot of the comments previously from all the other municipalities, I'll leave it there, but I'd be happy to answer any questions you have.
Thank you, Mr. Poirier. Questions from the committee. Representative Collmore.
Thank you, Madam Chair. Thank you for being here with us. So I just want to make sure I understand. You're in support of the bill when we include the redlining of the Maine Planners Association recommendation. Is that correct?
That's correct.
Okay, thank you.
Other questions from the committee? Seeing none, thank you very much for your testimony today.
Thank you.
So I believe the next is Jonathan Anderson.
Not there.
Robert Burns. Nancy Smith. And is there anyone else after? Okay, thank you.
Let's go. I'll check in with our clerk. Is she being promoted? She has to accept it. There she go. Welcome, Ms. Smith. You are at the podium.
I apologize. I did not hear my name.
Oh,
but I will dive right in. I am Nancy Smith at Grow Smart, Maine. My testimony, I handed out paper copies when I was in the building last week for the public hearing. You should have it in your folders. I've been listening all along and will add content that I think is helpful without repeating what you've heard already. I want to begin by thanking Representative Collmore for sponsoring the needed changes to last session's housing bill. Your attention to rural communities through this process is commendable. I love this new category we have of I would like to actually testify in support-ish. I'm neither for nor against. You can see if you have my testimony, there are 4 points we actively support, but others of concern. Let me highlight too, primarily I'm looking at section 11. We agree with the testimony of Jenny Franceschi for Westbrook when it comes to paragraph A of section 11 with the problem of being overly broad in the definition of private septic systems. There's more detail, but I think that needs to be corrected by eliminating that language. I have something for consideration when it comes to subparagraph B, which you've heard from MAP, City of Westbrook, City of Brunswick, and others have talked about this requiring additional density where there is water and sewer, but outside of designated growth areas. This is a real issue. If there are places that are adjacent to growth areas, and it might make sense, it's something, but I support MAP had an exemption for places with a risk of flooding and other natural hazards as one exemption. I would suggest there are other areas that fall into this category that could also be exempted. These might include critical wildlife habitat areas and those with significant rural features such as prime farmland, having just listened to Gorham talk about trying to preserve farming, as well as farmland of statewide and local significance. Happy to work with others. If the committee is interested, if you want to eliminate paragraph B, that would be great. If you're looking for a center ground that acknowledges the concerns that you've heard, I would support that as well. I can't really see the clock, so I'm going to just point out there are 4 areas that we do support in the bill in particular. And then in closing, we understand and appreciate that you all are keenly and appropriately focused on addressing the housing crisis and the affordability of housing. But I want to point out that the cost of housing is one piece of affordability in the cost of living. And this can include the cost of higher transportation costs for family living far outside of designated growth areas, as well as increased property taxes for overall costs of municipal budgets when these additional services have to be provided over a greater portion of the town. This requirement does Mainers no favors. Thank you.
I think testifying in support-ish fairly defines what I just heard.
I would love to have added that. There is no box for, I like some, but there are changes that need to happen.
Thank you. We are obviously noting and collecting all recommended amendments. So thank you. Chair Gear.
Thank you, Mr. Chair, and thank you for being here, Ms. Smith. I'm just curious if there is, in thinking about that sort of compromise section, potentially, is there some description that you or Grow Smart would suggest about that kind of sort of growth area adjacent kind of neighborhood or area? I'm just curious. It's a really interesting concept to be thinking about, which is not way out there, but kind of nearby. And should we be thinking about that in the ish?
We're talking designated growth area ish.
Ish, exactly. There you go. Yeah. And if you have anything on that or can provide it for the work session, that would be great.
I'll give that some thought. Something separate from defining the exemptions is maybe where it would actually make sense as well.
Representative Collmore.
Thank you, Mr. Chair. Also really excited that I just created a new section of testimony support-ish. If I've done nothing in my 6 years of service, I've done that.
Hang your hat on
One of the things, I think you bring up an interesting point that hasn't been brought up yet, that would kind of make more of a support for that paragraph B either being removed or heavily amended, and it's that higher transportation costs, the higher property taxes that would come along with having to extend bus lines or other forms of public transit that I think maybe weren't considered when we were first doing the discussions around this. And I'd love to hear more on if you have any examples of where that has happened because of growth and sprawl that would reinforce why we should walk that back.
Absolutely. I'll come up with something for you for work session. And there is the municipal cost of transit, but also the way that we talk about it, if people have to live, there's drive till you qualify to afford a house. And then if you end up with a family with 2 working members or more, when everybody has to own a car because there is no transit, because you're outside of the bus lines, the last calculation I knew of was $600 a month to own a car. And that's the payment, the insurance, the tires, the gas. So when you're adding to the household expenses, when every worker or person with family responsibilities needs to own their car, that has a huge impact on their cost of living. So I will, I'll find some examples or some language with you to clarify or further dive into that issue.
I really appreciate that, and also am very jealous if somebody's paying only $600 a month for gas, insurance, and their car payment.
I did say that was an old figure. I will try to find a new one, but I know yeah, I have to watch that as well. Thanks.
Thank you very much.
Appreciate it.
Is there anyone else online who's seeking to give testimony on 2173? Is there anyone else in the room who was seeking to give testimony on 2173? With that, we will close the public hearing on LD 2173. We'll now open up the public hearing on LD 916. LD 916 and Representative Gear. We'll invite the bill sponsor to the podium. And thank you.
I'm back now.
Welcome back.
It's getting to that time of the afternoon, right? Good afternoon, Senator Curry and fellow members of the Joint Standing Committee on Housing and Economic Development. I am still Representative Tracy Gear, and I represent House District 134, which encompasses Kennebunkport and Coastal Biddeford and Kennebunk. I am before you today to present LD 916, an act to promote investment in housing by establishing the Middle Income Housing Support Program and Fund. The housing crisis has shown that we need more housing, not only for those with low incomes, but also those with middle incomes. The quote unquote missing middle housing is considered missing because it has become increasingly difficult to build housing that is affordable to people with middle incomes. As a result, many people working in our communities struggle to find places that they can afford to live. This is especially difficult challenge facing municipalities and small businesses, with employees often having to drive long distances or simply having to leave jobs due to their inability to afford housing. We have taken important steps over the past several years to improve the ability to build housing, including updating zoning and land use policies to reduce the cost of development, supporting innovative development and construction methods, and providing flexible funding for projects that provide some units that touch on the low end of the middle income strata. As we all know, Maine Housing manages our housing finance programs and has historically focused on housing development that serves our lowest income people. Maine Housing's programs, through their financing mechanisms, provide state subsidy that stays with each project over time, assuring maintenance of long-term affordability. We now have the opportunity to put Maine Housing to work, determining the best way to support the creation of middle-income housing. LD 916 extends Maine Housing statutory authority to allow them to develop a program to support rental housing for individuals and families whose income is at or below 120% of the area median income, and home ownership options for individuals and families whose income is at or below 150% of the area median income. The intent of the bill is to take the experience that Maine Housing has gained and apply it to the missing middle challenge. The fund will be authorized to provide loans or grants to cover the capital costs to construct new dwellings or rehabilitate existing dwelling units. Combined with the other steps we've taken and are considering, this legislation will allow Maine Housing to investigate and develop a program, products, and partnerships potentially to support the creation of more middle-income housing. Thank you for your consideration, and I ask for your support for LD 916.
Thank you, Mr. Chair, and thank you for bringing us your amended bill here. I have two questions. One, does Maine Housing support this?
Yes, so I developed this bill in collaboration with Maine Housing, both the Maine Housing director as well as Adam Cray, who we all know who is their finance head. So really looking at what exists in their statute in terms of what they have the ability to do and how to explicitly empower them to investigate this next challenge. And when you think about some of the other bills that we've heard this session, really thinking about other things that would be very helpful for them to be able to do. This would be, kind of combining with those other things to give them some tools and some ability to do that program design and get into the details of how to make it work and how to assure, again, long-term middle income affordability for anything developed.
Okay, and the second question? Are they saying, since they are in support of it, how much that they need to have in order for us to place in a fund and where that money might come from? Are they doing this from existing resources? Are we creating a new fund that we then have to put taxpayer dollars into?
So this would be a
not
fund
included.
Well, this would be a fund that would be created. And I think, again, as we would be looking at the mechanisms as we work the budget and as we work through the appropriations process, be thinking about the funding for where this might come. This would be a state program.
With that, though, you haven't suggested an amount with your amendment that you were looking for. Do you have a suggested amount that it needs in order to get off the ground, or that's still something you're waiting for Maine Housing to come to
I
you with?
will defer to Maine Housing on the details for that.
Okay, thank you.
No other questions? Thank you very much. I'll ask Dan Brennan. Come up. Is your official title director?
I'm sorry?
Is your official title director?
Yeah.
Run it through all the different titles of the year.
I've been called a lot of things. Good afternoon, Senator Curry, Representative Gear, members of the Joint Standing Committee on Housing and Economic Development. My name is Dan Brennan. I am the Director of Maine State Housing Authority. I wear many hats over time, and today I get to wear the hat of Mr. Eric Jorgensen, who I am subbing for. His fine testimony is working its way around to you. I'm not going to read it. I thought I would just spend a little time touching on a few points that I think are relevant. And Eric's testimony goes into a bit more detail. But yes, I am here today to testify in support of LD 916 and very much appreciate Representative Gear for bringing it forward. As Representative Gear mentioned, it sets up a vehicle within our statute to receive funds to provide capital
to developers of rental housing and homeownership opportunities for people at a higher income level than we traditionally have served. The dilemma of not being able to serve those people that are just outside of our income guidelines is real, and it's always been something that has been of concern to me. And this bill speaks to that concern. Ideally, we would plan to use one of our existing programs as opposed to standing up a new program. These are some of the thoughts that have been going on in our head in working with Representative Gear and talking about the possibility of seeing this bill. One could argue that our existing 4% program, when used as mixed in a mixed income project, which is basically a combination of rent restricted and income restricted units and what we would traditionally call market rate units. That is a form of doing housing production in the tax credit program. So one could argue that that has actually, for many years, served people above the income limits that we're restricted to. It's just that we've never captured the income levels of those individuals moving into the market rate units. Just anecdotally, in talking to people in the industry, they would say, you know, just based on the nature of the people living in there, in those units, that those are the middle income, but we don't have any data to ever prove that. And I thank Representative Gear for touching on this too. We respectfully ask for maximum flexibility with the program design. It would likely need to potentially be offered geographically to those areas of the state that have greatest gap between income and affordability. We and our data crunchers would take a very careful look at that because we would want to make sure that we use these funds wisely and address those areas of the states that are having the most difficult issue of affordability. That's the piece that will take some time for us to think through, and we want to do it carefully. And with that, I will answer any questions.
I'll start with a question. Do you see any, I mean, your history has been and mission has been focused entirely on affordability as defined by a certain percent of AMI. This has you moving into a higher percent, which I'm excited by because this is a population that we have not had any program or any entity really focused on serving folks, you know, this missing middle or this higher income level. Do you see any structural challenges for Maine Housing to be moving serving this population?
No, I don't. It's you know, a lot of what the basic foundation of providing production programs for housing is already in place. It's already set up. So what has restricted us before in serving people of higher income is simply the authority to do so. Most of our funding sources are on the rental side are 60% and below on the federal side. The rural affordable rental program goes up to 80% that you have funded. On the home ownership side, the tax exempt bonds that we use prevent us only going up to about 115% of area median income. So I think we have the basic fundamental structure to be able to deliver the programs. Now it becomes, and to answer Representative Collmore's question of a second ago, Maine Housing doesn't have funding that we could use of our own to support this. We would need funding from the state. We note that the governor in a supplemental budget has put a $10 million line item next to middle income. And there's no, I don't know what went into that number. There's no magic to it. That's a sufficient number to get something up off the ground. But there's a lot to learn. And if this is what you would like us to do, we'll be willing to take a look at it.
Excellent. Representative Collmore.
Thank you, Mr. Chair. Nice to see you again. You too, Mr. Chair. So the $10 million in the governor's budget, is that meant for this program, or was that something that is just in there because of something else she has in mind, or?
Yeah, I don't want to speak for the governor. I just saw the middle income and I see this bill as middle income, and I personally am kind of equating the two, but I don't know that for sure.
Okay, so we're not exactly sure where the funding might come from at this point,
Correct. I mean,
but you're hoping for 10 million.
I would, yeah, sure.
Okay, one last follow-up. When you're looking at the makeup of the program and the design, and I understand the importance of keeping things flexible, but I also understand that far too often these programs end up in southern Maine. And how do we ensure that places like my area, which really is a hub for service center, Pittsfield itself is a service center, and that we're not ignored?
Yeah, well, we have really three primary production programs that we've been operating. I mentioned the 4% program, and you're right. That particular program might have difficulty in your particular area because investors just don't like to go there. But our affordable homeownership program and our rural affordable rental program, we have seen a much broader geographic diversity. And we could take this concept and figure out how to blend it into those existing programs as well. And we're also working with a lot of new developers that we haven't traditionally worked with that are throughout the state. So that would be what we would look to. We want to make sure that there's geographic diversity in the areas where the middle income is having the hardest time. So that's sort of where I qualify how we put this together.
Representative Lookner.
Thank you, Mr. Chair. Thank you, Director Brennan. This is an exciting development here. I've been around the legislature long enough to, I've been told for consecutive sessions that we're facing a budget shortfall, we're facing a budget shortfall, we're facing a budget shortfall, and we need to prepare for that. And yet here we are with yet another surplus, but anticipating that we will have, one of these hypothetical budget shortfalls at some point. With this X number allocation for this program, do you see that we could set up maybe some kind of a revolving fund where Maine Housing is able to recoup some of the investment and without ongoing allocations from the general fund, able to continually reinvest into this strata housing? Is that something you're considering, or have you not even quite, outlined the program yet?
Yeah, I appreciate the question, Representative. The way that we design our financing is we try and stretch our subsidy dollars as far as possible. And the way we do that is typically by offering interest-only financing. The loans that we give out don't amortize and pay back on a regular basis. They just stay out there, and that allows us to lend more money and use less subsidy, and that's been our strategy. So there really hasn't been a mechanism to create the type of revolving fund that you're speaking of. I do appreciate you thinking in those terms because it's somewhat logical to see, but the payoff would be having to use more subsidy in the short term, and to revolve the amount of money that you would need to help the next project, I think would take an awfully long time. So those are the things. I'll certainly go back to my team if there's anything I'm missing. But those have been the thoughts off the top of my head.
So do you see this this fund pretty much, we're just, it's money out the door, we're going to get these units built, and that'll be the end of it?
Yeah, unless the future legislature has been as generous as the previous ones and continue to fund the work that we do. We do a very good job of getting money out the door, and we're very proud of that. But I think that's that's how it works with our agency.
Thanks.
Bless you.
Senator Bennett.
Thank you, Mr. Chair. Director Brennan, thanks for being here. So this proposal in the governor's budget is $10 million one time?
It's my understanding. I don't know the details of it.
Well, usually it says in the budget whether it's
Yeah.
one-time or ongoing. I haven't looked at it myself. And there's no language surrounding it that she's proposed?
There is language around middle income. I'd have to look at
There's
it,
no
but I know
separate
there
part
was
of the proposal that links to it that would have as much detail as in the sponsor's amendment to this concept draft?
Yeah, I'm not aware of a linkage there.
How many houses will you build with $10 million?
That's a good question. I guess it would all depend on where we would set the subsidy limit. So I don't know off the top of my head. We do several hundred. But the way we would put this program together that we haven't designed yet is determining where that subsidy level is per unit. On our deep subsidy programs, the lower income programs, that subsidy number is very high. This would be obviously a lower number. And because the individuals living in these units would be able to pay a certain amount of rent. And so I don't know until the program's designed, I don't have a quick answer.
All right, I don't, it's late in the day and I don't want to get into it here, but it seems to me that this kind of hours late on this. We've got the governor's budget coming up here. We've got $10 million is being proposed. You say several hundred houses. We need to build something like 84,000. We're 30,000 in. I mean, we can't do it this way in a sustainable fashion with public funding. So that means we end up picking winners and losers, people who benefit from this program and people that don't. I'm really concerned about that. And standing up a new program with one shot of money seems to me there's some real equity issues there. And I just want you to think about that because I'd like to engage with you further. This bill goes forward or the governor's proposal goes forward because it's a huge issue. We need to build a sustainable system where people can afford houses going forward and not just continue to think that by dribbling out other people's money that we can get where we need to go. Do you have any response?
Yeah, the 10 million is part of a $70 million investment. So it'd be, probably more than several hundred units in total with the package. I hear you. The monies that we get from the legislature to put into our programs get out the door very quickly to do what we can do. The 84,000 number is a global number of all income, both market and affordable. So I'm pretty proud of how Maine Housing has been able to contribute to the part of the world that we live in. But you're right, it is the need is much greater. And we're just doing our part with your help.
Yeah, I know you're a bank and you're focused on finance. I think that we can be more creative on financing options when we're giving money here that we can use it in a way to help people where they really need the help, which is mortgage subsidies and down payments too, which, as you know, we just had a bill in here that we talked about both of those pieces. But I really want to explore this further when we have time. Thanks.
Yeah, I would welcome that.
Thanks.
Thank you very much.
Okay, thank you.
Elizabeth Frazier. Oh, I'm sorry, Elizabeth. I'm staying on the proponents. Peter Cannell. I mispronounced your name the first time and I'm always doubting it.
Well, the first line of my testimony addresses that.
Okay, good. Let's get going with it.
Senator Curry, Representative Geer, and distinguished members of the Joint Standing Committee on Housing and Economic Development. My name, as most of you know, is Peter Connell. And I reside in South Portland, Maine. I represent the Manufactured Housing Association of Maine, and I'm here to testify in support of LD 916. The Manufactured Housing Association of Maine is a nonprofit trade and professional association that is comprised of members that build, develop home sites, develop manufactured housing communities, along with selling and financing HUD code manufactured homes and Maine certified modular homes. Established in 1986, the Manufactured Housing Association of Maine is dedicated to the protection and promotion of Maine's manufactured housing industry through legislative representation, continuing industry education, public relations, and communications efforts. I am originally from the Oxford Hills and have been proudly involved in the industry for over 40 years in retail sales and manufacturing. as well as proudly serving on the Manufactured Housing Board of Maine, representing manufacturers for nearly 20 years. That's another bill. We feel that supporting this legislation will help with solving the Maine housing crisis and will allow us to provide well-built, energy-efficient, and quality homes to offer Maine people the highest value and affordable homes as possible. We will be happy to answer any questions now, and we'll provide information requested for the work session. Thank you so much for the opportunity.
Representative Calamo.
Thank you, Mr. Chair. I knew your name. Just gonna say.
Just saying.
Just saying.
Yeah.
No, so one of the things in this bill, I think for me, that is of most concern is what we're considering the middle income. 120% of the area median income as published by the U.S. Department of Housing and Urban Development, and then 150% of the area median. With your members, what is the typical percentage of, and I know you won't have it right now, and that's okay for the work session, the people purchasing homes from your members, what is their typical AMI when purchasing these homes? Because I can tell you, I make more than this and I can't afford their houses. And so I'm just curious about what that looks like.
Okay. I would point out that one of the things that is appealing about this is that over the decades of Maine Housing Authority, there have been some really good programs for first-time home buyers and that sort of thing, which generates activity throughout the housing segment. And that's one thing that's relatively exciting. Not relative, it is exciting that there's an opportunity there. Back in the old days when I was involved directly in the industry, first-time home buyers for housing to really swing in Maine, first-time home buyers had to be approximately 40% of the new sales, and now it's under 30. And so whatever segment that this helps, when there is sales activity, and I would have some ideas as to what the product ought to be offered specifically from manufactured housing, that could stabilize maybe some of those prices that you're referring to. We'll have to have some details naturally and all of that, but I think there's a way to skin the cat-ish.
Thank you. Thank you. Any other
Thanks.
questions? Seeing none.
Yep, and would be happy to provide any information
Great.
Additionally to that, if you so inclined.
Thank you.
Thanks.
Now Elizabeth Frazier.
Good afternoon, Chair Curry, Chair Gear, Leader Collmore, and honorable members of the Housing and Economic Development Committee. I am still Elizabeth Frazier. I apologize that I have written testimony, but I'm not going to hand it out because I just found an error and I want to correct the error, and then I will send it in to you shortly after. I am here today on behalf of Marita in opposition to LD 916. Marita does not support the proposal in LD 916, which is before the committee today. While Marita members will always appreciate support in the form of a financial subsidy, Marita feels strongly that endorsing this program would send the wrong message, that we believe this is the right way to tackle the missing middle. We do not. This bill takes the wrong approach to solving Maine's missing middle problem. Less than a month ago, this committee voted down Marita's proposal to unlock housing production statewide at no cost. Instead of removing barriers and allowing private capital to build housing at scale, this amendment creates a discretionary subsidy program with no identified funding source and a narrowed income band. It leans into an administratively heavy, state-managed solution that will cost money to operate, create inefficiencies, and drive up the cost per unit. This bill does also not meaningfully address the missing middle in terms of the AMI. Marita feels strongly that any true missing middle program should extend to at least 220% of AMI. It is not unreasonable for a dual income family, say a firefighter who can make upwards of sometimes $140,000 a year with overtime inclusion, and a wife, maybe a nurse who's making $70,000 or $80,000 a year, to very quickly break over the $217,000 AMI that represents the average 220% AMI in Maine. And I can tell you that home prices right now are roughly $1 million for anyone in the greater Portland area. And if you think you can afford $1 million home on $217,000 salary, you are wrong. This bill also creates a new fund within Maine Housing without identifying a stable funding source. And I should say, I won't go into all of this because it was mentioned earlier. We were also not sure if this was tied into the proposal in the budget. So we made mention of it and where it deviated and where it wasn't, just to sort of note that we weren't sure what was going on there. But certainly, obviously, we will say something similar about the proposal when it is in the budget. And lastly, to say that the program lacks critical structural guardrails. It does not specify how long units must remain income restricted. It does not identify who verifies beneficiary income. It does not address equity buildup for income restricted home buyers. These are not minor technicalities. They are foundational design elements of any serious housing program. And I'll conclude by just saying that creating a new fund without supply reform does not solve a housing shortage. At best, this will end up on the special appropriations table and potentially become symbolic. If it is funded, it becomes a short-term temporary Band-Aid to a serious long-term statewide crisis. And with that, I'd be happy to answer any questions.
Seeing none. Thank you very much. Oh, 1 second, Representative Lookner.
Thank you, Mr. Chair, and thank you for your testimony, Ms. Frazier. So you called, I think you said in your testimony that this was the problems that you have with the bill are structural and foundational, and yet what I heard was a list of potential amendments, tweaking the AMI, making some other adjustments that I think could very easily be, included in an amendment. What do you think if Maine Housing created a way of having really affordable middle income housing in the long term? Do you think that would pose an issue for your members in the real estate industry? Would that be a problem for you folks?
I want to be clear that we are not afraid that Maine Housing is going to steal our business. That is not why I'm up here today. We love our friends at Maine Housing. They serve on our board. We're incredibly supportive of them. And I'm sorry to be up here today opposing a bill that they support. And we will certainly support them in many other ways, as we always do. What we are saying is that subsidy of any kind is not the way to solve the missing middle problem. It is such a huge market segment that it absolutely needs market-based solutions. And this will inject some cash into a couple of deals. I'm not saying it won't have positive outcomes. Certainly, some housing is better than no housing. But the amendments that we've proposed, Representative Lookner, are sort of intended to get this bill a little bit closer to the proposal that we put forward, which we feel is the right solution for missing middle policy in Maine.
Thank you.
Thanks.
Thank you. Representative Callamore.
Thank you, Mr. Chair. It does not identify who verifies beneficiary income line. I find that one very interesting. Are there, for the work session, examples that you can provide us of programs that do show that in statute to ensure that, I know what that model language looks like?
Yes, and I should just say, thank you, I will do that. And I should just say too, I meant to mention this in my testimony, that it is conceivable, the bill is lingers back at my desk, that this had Maine housing issuing rules on that subject. So I will also look at rules because it's possible it's not in statute, but rather in rule. I did think it was worth mentioning because those were things that we were asked to add on to a very similar type of program in statute. So I thought it might be appropriate to add those in statute, but I'll check to see if they're already in rule.
Thank you.
Thank you.
Patrick Whitcock.
Good afternoon. My name is Patrick Woodcock. I'm President and CEO of the Maine State Chamber of Commerce. We are testifying neither for nor against LD 916. I will say that was hard for us to not come out and support. We completely support the intent, and there is merit behind addressing this. I guess I would reinforce Elizabeth's points that the scale of this challenge is very hard to address with resources alone. I will say that, when we look at this challenge, we think that what would be the highest and best use of $10 million in the governor's budget. And we think that there would be more effective ways at trying to unlock housing production. Most specifically, we've heard that tension today that there's state and municipal, state law, municipal application of where that decision making is occurring. And there's this natural tension that we're hearing in 2173 and 1829 that keeps on popping up. And I would encourage the committee that one model that I think we have not touched upon is actually something that Congress passed last week. The House of Representatives passed the bipartisan vote of 390 to 9, the Housing for the 21st Century Act. And actually, I think the House of Representatives was listening to a lot of the discussions here. If you look at what is included in there, they have streamlining certain federal environmental reviews, promoting modular construction, enabling single stair best practices, expanding HUD loan eligibility, and also creating incentives for municipal housing reforms. Specifically, Section 202 of the House bill makes federal community development block grants that are currently unavailable for housing development to be eligible for housing projects. In addition, applicants must include and report on their municipal efforts to increase residential density, streamline permitting timelines, limit impact fees, offer density bonuses on tax abatements, and make vacant land available for development. In short, the legislation encourages municipalities to adopt housing supportive best practices by requiring disclosure of those efforts as part of the grant process. The Maine State Chamber of Commerce proposes a similar incentive-based model to unlock middle-income housing development here in Maine. We would recommend designating the Governor's Office of Policy Innovation in the future to establish clear best practices for municipal housing policy. Municipalities that adopt these practices would be eligible for targeted state grant funding and earn a designation as a municipal housing leader. This approach rewards communities that reduce regulatory and cost barriers, encourages voluntary reform rather than imposing state mandates, and leverages limited state resources to generate the greatest possible number of housing units per dollar. This is consistent with recommendation 2.3 of the H&R report that was previously presented to this committee. I see my time has expired. Happy to answer any questions. Thank you.
Is there anyone, so we're going to shift online, then we'll come back to the room if there's anyone else. If, I'll ask the clerk to promote the online person. Christine Bennett. Yeah.
Hi, my apologies. I signed up in the hopes that I would be able to raise my hand at the end of the testimony for 2173. I wasn't able to. I can follow up with someone, I suppose, to find out when the working session is going to be for LD 2173. But
you're not here
this
to give
legislation
testimony on
sounds
this.
great.
Thank you. Thank you. But you're not here to give testimony on this bill. Appreciate
No, I apologize. I've just been listening and working.
it.
I'll go back.
Thank you very much. Is there anyone else who wishes to give testimony that is in the room on LD 916? Having heard all public testimony, we will close the public hearing for LD 916. And with that, we will just take a few minute break to change the room over, and we'll open up in a moment, we'll open up the work session for LD 2097.
Did you plan to do all the work sessions today?
Welcome back, everybody. We're going to open up the work session for LD 2097. LD 2097 is an act to modify the law governing revocation of a code enforcement officer's certification. And our committee list is here, Ms. Westfall.
Thank you, Mr. Chair.
I understand there is an amendment. What is is your analysis based on an amendment, or is it?
It is not. The
It is
amendment, I think, came out around noon, so I haven't even really had an opportunity to look at it.
Oh, the amendment came out around noon. Okay.
Yes.
So I would say walk through the analysis, and then we'll shift over to the amendment.
Yep. So this is a bill to modify the law governing the revocation of code enforcement officer certificates, and this is Representative Gear's bill. Under current law, the district court has the authority to revoke a certificate or certification for a code enforcement officer. And there are specific conditions or situations when the certification can be revoked under statute that's practiced fraud or deception, failed to use reasonable care, judgment, or apply knowledge and training, or is incompetent or unable to perform the duties properly. This bill repeals that provision and sets up a method within the Maine Office of Community Affairs. It allows the director to establish a complaint review committee within MOCA that has 5 members who are appointed by the director of MOCA. And that complaint review committee has the authority. Under the language of the bill, they have staff and they receive complaints. And the director can either request the committee to investigate a complaint, or the committee can investigate a complaint on their own motion. Under the bill, the director and the committee may also contract out the investigatory activities. The bill does list the basis upon which the director can take an action in response to a complaint. And those are on the 4th page of the bill, lines 24 to 37. They're broader. Well, there's more of them than in the original or the current law. It includes failure to meet certification or recertification requirements, falsifying or misrepresenting material facts, engaging in contact that violates generally accepted standards in the code enforcement, engaging in conduct that violates rules of the Maine Office of Community Affairs. So that's the basis upon which the director can act. When a complaint comes in, the committee or the director or the staff can hold an informal conference, which the code enforcement officer may or may not attend. They are not required to attend an informal conference, but that's the first step that the director can use, is an informal conference, to figure out whether there is sufficient gravity to warrant further investigation. If they determine that there is sufficient gravity to warrant further investigation, they can then complete the investigation, and if they find a factual basis of the complaint is true and is of sufficient gravity, they can take a variety of action. They can issue a letter of guidance or concern. They can negotiate a consent agreement with the code enforcement officer. The code enforcement officer can voluntarily surrender the certificate. They can modify the certificate. They can impose conditions, or they can suspend or revoke, or go to court for injunctive relief or seek civil penalties. So a bit broader and more specific in what the director can do in response to a complaint. The individual who has sanctions imposed upon them can ask within 10 days the director to hold an adjudicatory hearing, which would be held in front of 3 of the 5 review board members. And the hearing would be held in accordance with the state APA. And if that committee, that adjudicatory hearing would then make a recommendation to the director on whether, yes, you should continue with what your original enforcement action was, or should be perhaps amended or changed, and the director has final say. At that point, it becomes final agency action, and the code enforcement officer can then appeal to Superior Court if they don't like the action. During this whole process, there is notice that is required under the statute or the bill. It's provided to different people at different times. And I'm going to kind of raise later on some of the technical or substantive issues, as I'm not entirely sure that the notice is providing reasonable notice to the right group of people, but that's part of the potential substantive or policy questions that I think you may want to consider. So that's kind of a rundown of what the bill does. It basically changes the responsibility of oversight of a code enforcement officer. Code enforcement officers are largely employed by municipalities, and the municipality, as the employer, has frontline responsibility if that code enforcement officer is engaged in some fraudulent or misbehavior. It doesn't do their job appropriately. So that currently exists. What this does is set up another avenue for a different level of review. So the municipality can't revoke or suspend the certification. They can, that's an employee-employer relationship. They can fire, they can suspend in employment, they can have a performance evaluation plan. They can do a lot with that code enforcement officer, but they can't touch the certification. That is only something that's allowed to be done by the state agency. But there is that overlap in enforcement of good behavior on the code enforcement officer. And so I kind of wanted to raise that to the committee first, because I think there's some, and there was some testimony where there may be some overlap that you may want to think about. So you heard some testimony about this is not a complaint to the director of MOCA that they've misinterpreted the code. There was testimony that that is an appeal that should go to the review board in a municipality. If you can't get a permit from a code enforcement officer because of their interpretation of the code or the requirements, that usually goes to an appeal board on the municipal level and then goes through the court systems. What I think MOCA is trying to capture is not that. They're trying to capture when the code enforcement officer lies, cheats, embezzles, doesn't do their job, engages in misconduct, and making sure, so there's two types of kind of review, and there's two types of bad acts. And you may want to think about if the distinction and the line between those two is placed in the right, is it clear who's responsible for which part of that, and in a way that the committee is comfortable with. And also that leads to the question is, what if the complaint has both? How does MOCA handle that? You're going to want to make sure that the complaining party understands that if they want to appeal the decision of no permit, they need to go directly to the review board. And if they don't go to the review board within a certain time frame, they've lost their legal rights. So there may be some additional language you want to think about that requires MOCA when they get a complaint to make sure that the person complaining understands there's this other avenue so they don't lose some of their rights. Some of the other kind of issues are there's grounds for action and then there's penalties. And I've looked at this law, compared it to other, I looked at, I don't know, engineers, I looked at chiropractors, and I looked at another random kind of profession that has a certification process. And a lot of this is very similar to how that is drafted. So I'm not trying to say it's anything unusual. But in some situations, the type of discipline is tied a little bit more closely to the type of offense. And I think that has been attempted here. But I think the question is, has it been tied in a way that the committee thinks is appropriate? Let's see. Two other just kind of questions. One is about the notice. I did not see in here, for example, that the person that the complaint is filed against, this code enforcement officer, if MOCA decides they're not going to go forward with this, I think they tell the municipality, but I'm not sure they have an obligation to tell the person the complaint was filed against. I'm thinking that's an oversight, but it's something that you might want to find out if that was intentional on MOCA's part. Another kind of common talks about the agency that employs the code enforcement officer, and it talks about the chief administrative officer. Are we talking about something other than a municipality? Are we talking about private entities that are employing code enforcement officers? Because the phrase agency and chief administrative officer doesn't line up with employment on a municipal level. So I think that may be clarifying language you might want to confirm, so that we get the language correct. And then the other thing I think you might want to follow up on is confidentiality. What part of the investigation is confidential? And under this bill, the municipality is asked to conduct their own investigation. They don't have to do it. But if they do, the way I read this is they have to turn that over to MOCA. And I'm concerned that that somehow infringes on that employee-employer relationship. There is a statute out there that talks about municipal employment and when things are confidential. So I just want to make sure that what's in here about when it's confidential and when it's not conforms to what existing law is.
So we have an amendment in front of us, and I'm wondering, before we go down a rabbit hole of things that might be already adjusted in an amendment. Yeah, go ahead.
The factual question to refresh my memory. I see it here on the proposed amendment, maybe in the bill too, under section 3. It lists a bunch of agencies that issue certificates. It lists the former state planning office, DCD, Office of Community Development, Department of Public Safety, State Fire's Office, MOCA. Are they all, is a code enforcement officer certificate dependent upon all of those, or can one of those agencies certify?
I think that that is telling you the history of who used to certify.
And so is it now MOCA only?
It is now MOCA, but I'm also going
Okay.
to ask the clerk if I could have a copy of the amendment.
Okay, thank you.
And I will ask the director of MOCA to come up.
It's on page, section 3 bill.
Are you ready for me?
Yes, please. And so questions to both will be fine. And go ahead.
Well, I'll just say that Greg Gilbert, the state building official, is here as well. And so if we get into anything remotely weedy, I will be looking to Greg for help.
Great. If you can introduce yourself.
Sure. I'm Samantha Horn. I'm the director of the Maine Office of Community Affairs and the Division of Building Codes and Standards landed with us as of September 24th.
Excellent. And so we have the analysis that you just heard, and I think you have a copy of, having just gotten that. Was there any reaction that you had to the analysis that you wanted to respond to?
I think that the question that Ms. Westfall raised last of the confidentiality is something that I have not thought a lot about, the town report. And so I do think that would be worth looking at for sure. I appreciate you raising that. Some of the other ones I feel like were maybe dealt with either in the amendment or otherwise. I will say that would it be helpful if I just give you a little history of this amendment?
Yeah, please do.
Okay. So we put this bill in sort of at the last minute in the early fall because we heard from the fire marshal's office that they were getting an increasing number of complaints and the level of complexity of those complaints was going up quickly, and they wanted to give us a fiscal heads up that they thought that we might be facing substantial costs for investigators to do investigations at the level that would be required to hold up in court. I think we can all appreciate that things have become more contentious generally in recent years, and so what maybe was true a decade or two ago isn't necessarily true today. In reacting to that and looking at the current system, I really felt like we could improve upon it. The idea that you would start at the only remedy being taking someone to court seemed inconsistent with other certification kinds of activities, other licensing procedures, and it was also just not conducive to having good outcomes generally. And it was going to be a financial drain on the office if we needed to frequently hire investigators. So, and we really would like to create an atmosphere where code enforcement is supported. In Maine, they're an incredibly important part of implementing a lot of what you all are discussing in terms of, especially in terms of housing. And they have a very difficult job and we want to be able to support them. So we put this in relatively late in the game. I was just getting up to speed on bringing them on board. And we had help from the Attorney General's office drafting the bill. It came to light after it was printed, which I tremendously appreciate the input, that there were some substantial revisions that the folks that are on the ground doing this work thought were warranted. And so we've had several rounds of negotiation over how we could change the bill to be more in line with what code enforcement officers were looking for in terms of their own licensing process. So we've been working with the Maine building officials and Inspectors Association on that. And Mr. Brown, a representative from that organization, is here today. We've also been working with the Maine Municipal Association. I understand MMA still has some concerns about the bill, but I hope we've addressed a lot of what they raised. And so where we're at today is an amendment that does some key things, like gets rid of the really terrible name of Complaint Review Committee and changes it to something more helpful. It changes the authority, the decision-making point of authority from the director of MoCA, which is a political appointed position, to the division director. So right now that would effectively be the state building official, so that there's a less, it's not a political appointee making those decisions. And it also shares that responsibility with the folks on the committee. So if a action goes to hearing, it is a committee of peers that makes the decision about what the outcome should be. So that if a code enforcement officer or LPI or TPI is concerned, doesn't agree with whatever the division director's thought is regarding what the outcome should be of a case, then it goes to a committee of their peers, which is sort of a middle ground between some of the licensing boards that everything's decided by committee, which I felt like was too much process for this circumstance. And we wanted to be able to dismiss meritless cases quickly and also have an efficient process. But it does give anyone who wants it a hearing before their peers, which I think was very important to the MBOIA. It also clarifies the criteria so that it's more in line with what Ms. Westfall was talking about earlier, to make sure we're not explicitly not taking on code interpretations and we're only dealing with things that are more conduct oriented. And it tries to make clear the difference between employment issues versus certification issues. We've also added language so that it was in there before, but added additional language to make it clear that this also applies to licensed plumbing inspectors and third-party inspectors. There's a number of other changes in there, but those are some of the highlights. And so I'd be happy to sort of walk through what the substantive or policy issues were. I think I've addressed the first one, which is we feel like,
We could pause for a second, Representative Fellamore.
Thank you, Mr. Chair. Just one question specifically on trying to delineate from the certification versus the interpretation, because oftentimes I think the issue is with the interpretation. You've got one code enforcement officer in Pittsfield, for example, who's shared with 5 other, 6 other, 7 other towns. They have one interpretation. They go on vacation. You're now using this other one who has a different interpretation. They deny it. And then there's the infraction. So how are we looking at delineating that within the statute to prevent that from being the thing? Or to ensure that because that's the thing, we clarify the area where the interpretation is incorrect.
Yep. I think that's really important to the MBOIA because it's a tough enough job already. And a lot of times people are upset because the answer doesn't fit their plans, even if the answer is correct according to the code. And so we worked on page 4 in section 5, grounds for action. We tried to be very specific. So A is just literally didn't meet the certification requirements. B is falsifying or misrepresenting material facts. And then C is really about being dishonest or deviating from a standard of conduct. And we'll put more in rule about referencing specific documents that are how someone would know what the standard of conduct is for the profession, but that a reasonable and prudent certificate holder would observe in the same or similar situation. And then D is about just repeatedly failed to effectively perform the duties authorized by the certificates. And so, that would be like not inspecting or allowing dangerous conditions to exist and still signing off on the project. That is not whether it's the right number of studs per dimension or like whatever. So the things that are called out in here are not code interpretations, and they were written very deliberately that way with the MBOIA's input.
Great, thank you. You were going to say.
Sure.
I think you're going through the substantive issues that were brought up by our analyst.
So I hope that that answers bullet 1, complaints about interpretation or enforcement of law. We also, one of the reasons that the first step is to both notify the CEO and notify the town. And the reason that might not have been clear is because they're in 2 separate paragraphs of the bill. And we can talk about where that exists, but is because we understand that in probably the majority of cases, we're going to just say this is an issue for the town. This is not a certification issue, or it's a code interpretation issue, and it's either an employment issue or a code interpretation issue. The times when we actually get to the point where someone is showing misconduct should be a relatively small percentage of all the times that someone gets irritated with their code enforcement officer. So we want to get the town's perspective to make sure the town has a chance to say the code enforcement officer did exactly what we asked them to do. Like, this is not an issue. Or the town can say, we understand there's an issue with maybe, timeliness or something. That's an employment issue. We are addressing it. And then it just we'll say it's not an issue for MOCA to deal with. So we expect that most times when someone contacts us, it's likely going to be one of those 2 circumstances. And the reason that we have this split system where the division director takes the first crack at this is so that a whole committee doesn't have to look at every single one of those complaints that come in and slow it down. And we want CEOs to have it cleared off the docket as quickly as possible if it's not something that's truly a certification issue. And then going down to the third question about sequencing, what if a complaint includes both an interpretation, enforcement dispute, and misconduct allegations? Should one be processed before the other? I mean, I think, again, that's why we're asking the town to go first, to look at what pieces of it they feel are employment issues, and then would advise MOCA about that fact that they were going to follow up on those. And then MOCA wouldn't act until assuming the town replies and has something to say, MOCA would only deal with the things that were left after the municipality was dealing with their issues. Should types of discipline and penalties be tied? Oh, that's another major thing we took out of here, is we took out the civil penalty, the monetary civil penalty. So really if you look at page 4 on discipline, number 6, we could deny an application for a certificate. We could issue a warning, suspend a certificate, revoke a certificate, or impose a probation. We are no longer suggesting that we would be imposing a monetary fine. And I think that that's important as we continue as we build more capacity in our code enforcement support program, that maybe in the future, if we're at a point where we have enough capacity to provide good, solid technical assistance on a consistent basis to all the code enforcement officers that need it, then maybe it's more fair to think about some kind of a fine. But until that point, we understood that there's just, it would not be fair to be imposing fines at this time. And so the types of misconduct and the appropriate penalties and disciplinary action, I think are, you know, there's a sequence here where we start with the lowest level of discipline that could apply, and it's progressive discipline, I guess. And so ultimately the committee of peers would be the ones that would be deciding if there was a tough call, if there was a really serious issue, they would be deciding what the appropriate penalty was. The next one. This is a great question. I don't know the answer about if the CEO is acting on their own behalf, not as a code enforcement officer. And so that's maybe something we could look at for language and make sure that it's not implied that their actions as a private citizen are implicated, although I'd want some feedback from the experts on that. Okay, a certificate holder does get the notice of complaint, and that is in
The dismissal.
Hmm?
The dismissal.
Oh, dismissal of complaint. Well, rather than take everyone's time, I can take a look and make sure that that's real. I think it's in there, but maybe not. You may have caught something, so I will double
The
check.
intent would be to tell the CEO if
Absolutely.
it wasn't going forward.
Right.
That's what I thought.
The thing that MMA raised, which was an interesting point, and that I think is important, is that they were asking, is it mandatory for MOCA to send, if we do a letter of counseling, like if there's an issue that really we just want to work with the CEO on and not have not make it a very formal kind of suspension or consent agreement or anything like that, does that letter automatically get sent to the town? And I think what we've landed on is that it doesn't automatically get sent to the town, but it is public information. So we'll let the town know that if they wish to have it, if they wish to follow up at the end, they can obtain one. But we don't want to automatically send counseling letters, you know, to towns on a regular basis. But they can have it if they want it. But definitely we should make sure the certificate holder gets notice of how the complaint is resolved. Confidentiality. So the way it's written is that counseling letters and guidance letters are public. An ongoing investigation is not public, but once there's final agency action, that final agency action is public, which I think is pretty consistent generally with administrative proceedings. And this was based on the Maine Criminal Justice Academy language, which is why it looks pretty similar, I think, to a lot of the others. I think that's the oh, I can answer the chief administrative officer thing. I asked the AG's office, and an agency is a company or a state agency or whomever, and the chief administrative officer would be whoever's the head of the entity that employs the either third-party inspector. So it would also apply to a company that's employing a third-party inspector. So if we were letting the employer know, and it wasn't a municipal employee, it was a third-party inspector who worked for a company, we'd be letting the company know. So are there other things that you would like me to pick out of that? I think I got most things.
Representative Cullimore.
Thank you. One thing that I find is unclear, even with your red line changes, which do help in some of the questioned areas, I think. So I'm a person who's trying to build something. I have a problematic CEO. Maybe we just don't get along and I don't enjoy them as a person. Small town Maine, that happens, right?
Yep.
But I'm really mad because they've denied my deck. And so I don't understand why they've denied my deck. So I go to Google and I Google, how do I file a complaint? And usually it'll bring you to the law and it'll tell you the thing, but the law doesn't tell me how I file a complaint.
Mhm.
So who are they filing the complaint with? Am I Googling it and it's telling me I'm going to my town and then my town's bringing it to you? Am I Googling it and then it's saying you have to go to MOCA, this division director,
Mhm.
and that's who you file? Is there a form? You know, that's the law is unclear on what the process is when I'm ready to file a complaint. Who am I filing that with?
Well, I can, so I feel like the law is clear, but I feel like the process that someone would go through when they're not trying to read a 6-page law could be outlined very clearly on a website that would pop up for them. And someone sent to me, I can't remember who it was, and so thank you for whoever it was, but sent me the form, the page for the EMS licensing board. And they have a page that explains what you can and cannot complain about in that system, and then where else you should go if you have a different concern. And then it has a little form you fill out. And so for me, that it's like one screen big, you don't have to scroll. And it's pretty clear about if your issue is X, yes, come see us. But if your issue is Y, like go see this other person. And I think that kind of thing could be really helpful to the public in understanding the nuts and like the nitty gritty of what they need to know about how to get started in this process. And I would think that that would be a really important thing for MOCA to do.
Are there other questions? Mhm. Go ahead.
Given the demands on what you are now calling the division director, do we really feel like you've said there's an increase in complaints, which they're going to have to, as this person, investigate every single one before it goes to the committee? Is the division director only one person? Or do you have sections of the state that are covered? I don't know if it follows the DOT areas, however that is, county level, maybe a couple of counties together, whatever. I just feel like there's a lot of homes in Maine that need to be built. 84,000 we keep hearing. That's 3 or 4 complaints a project potentially. And so I'm just wondering if this is actually the fielding method that we want, or are there people who work for this person who are like, this elevates to that kind of thing?
Right. Well, this will be a great primer for when I come back to you next week to do the budget work session. Right now, Greg is a state building official, and everyone who has an issue with building codes in Maine calls Greg. His voice mailbox fills up like every 3 days, and he empties it and it fills up again. And, it's just an impossible task. Greg has Shannon, who's the admin for the program. And so she handles a lot of the online licensing, that sort of thing. And she can triage things, and but she can't answer the substantive questions. So we are proposing in the governor's budget, there's another position, and then we're additionally going to bring to you a suggestion that's consistent with a working group report to have another position, so 2 additional positions. And that will help with the overall technical assistance workload. He's already getting complaints about this stuff with no good system to work people through. He's got to do his best to say, does this seem like bad enough that we need to prepare for court? Or can I try to mediate this? Or should I just tell the person they're out of luck because it's not substantial enough that we would go to court? He's facing those calls all the time. And the fire marshal's office has active investigations going on. So we're already in that situation where he's getting more calls than he can handle. The publicity around this may increase the number of calls, but if we have a clear system to put them through, where the committee should see hardly any of them, frankly, because a lot of them will be dealt with at a very low level. And if we have a standard form, a standard guidelines for folks, here's the system, here's what's going to happen, I think it's going to end up to be not a lot more work will avoid costs for contracting for investigators for court. And we will have a system that's more predictable and people understand. And so I would hope that some of the frustration around how, like people saying, how do I get my complaint addressed? There would at least be a clear explanation.
Yes.
So I guess what my big concern is we have the language in front of us now. And should the language be more clear, it needs to be more than one person. That's kind of where I'm at. Because I know there's a lot of complaints. When I was on the town council in my hometown, there was a lot of complaints, and I know nothing about the code enforcement thing, except that people didn't like him.
Mm-hmm.
And that was because he was very good at his job.
Mm-hmm.
And so I just, are we setting ourselves up for failure by saying it's only one? And listen, I'm doing this as somebody who hates adding more government positions,
Mm-hmm.
but I understand the importance of this, especially when we need to have more buildings and more consistency with that building process.
I hear you. And so, I mean, we've got three options, right? We can keep the current process where stuff either sort of hangs around or gets resolved informally or goes to court, which is a workload. We can do this, which is a different workload, but we don't anticipate it's going to be like orders of magnitude more and it'd be more predictable. Or we could do some other thing, but I've not heard any suggestion from anyone about what the other thing is. So I don't feel like this is such a jump in workload that it would be better to stick with the existing system. Like if we had a functional existing system that was great, then I'd say, let's not make more work for ourselves, but we don't. I think on balance, this is going to be a more productive outcome. Even if you all say no more positions, I still think this is a better outcome.
Thank you. Would like to hear from MMA, but stay here because just I see there's another question.
Okay.
And also, is there anyone in the regulated community that's here? So great. I would like to hear from both of you. So Chair Gear.
And just a quick question following on from that, because I'm kind of seeing the workload, and I don't know if you're talking about 5 a day, 20 a day, I don't know exactly what the volume is, but knowing that you sort of need a certain level of experience and expertise to kind of make that initial evaluation. I'm struggling to see if it was sort of someone who worked for someone here. It almost needs that person who knows what they're doing to say, this needs to be, looked into more. These, we'll just deal with it. Is that a correct sense of this, that delegating it to another person would be difficult in terms of, trying to streamline the process?
I think some of the mechanics, like the paper generation, can be delegated, but in terms of the decision about how to proceed on a given case, it does require someone with strong content knowledge. And so that's either Greg, or if we do get additional positions, where the one that's currently in the governor's budget is a circuit rider that has technical knowledge. And so that would be another person who could provide input. Greg also can call on the committee. So if there's something that he's not clear on and he wants to get it says throughout the document that the committee can get involved if that's the division director's preference. And so he can call on the expertise, especially if it's area certification. Like code enforcement officers can be certified in many different kinds of topic areas. And so Greg may not have in-depth knowledge about every single one of them, but the committee members will. And so he'll be able to call on the committee members as needed.
Thank you. Thank you very much. Is a representative from MMA here willing to educate the committee? Welcome.
Good afternoon, Tanya Emery, Advocacy Manager for the Maine Municipal Association. Thank you for the opportunity to make comments. We very much appreciate the work that MOCA and MBOA have put into improving this bill. It is significantly improved. During my testimony, you may recall, I specifically noted a lot of concern around lack of dedication of training and resources and focus on discipline instead. And that seems very heavy-handed. We're very pleased to see in the governor's budget, and we know MOCA has worked very hard to work on securing resources resources. I think I said to Samantha a long time ago, Greg needs to be cloned. Maybe we need 3 of him. So we are very much in support of that and very much appreciate the committee's support on those issues. I do think that one of the issues that we did discuss was this is immediately going to throw a lot of code enforcement officers into the box of being eligible for discipline because they are not currently certified, because the state has not offered enough certifications. I would like to see, or we would like to see, some assurance that that is not the intention, that there's a catch-up window, that folks will not be disciplined for lack of certification for a period of time. We know that there's a lot of interest in work in getting those training classes up and running, but we really would like to see a balance there, that we're not going to jeopardize folks' attempts to be in a meaningful career, which we very much need right from the jump. So I think that probably is one of our biggest outstanding concerns. I also just want to say, there is a tremendous amount of work that happens. I think it's sort of being skipped over. As someone who personally oversaw code enforcement department for 10 years, you spend a lot of time at the municipal level managing those folks. And so when there are complaints, they're first coming into the municipality. And so that is the first line of defense. And that's where you say, is this a code interpretation issue? Is this a personality conflict? I've had to assign different inspectors to work with different projects because sometimes it is a personality conflict. And so there are a lot of ways that municipalities are already working to mitigate complaints and concerns about code enforcement officers and interpretations. And I just want to make sure that folks don't skip over that process and the progressive discipline that's available at the municipal level, or the TPIs, the LPIs that are employed by other agencies or regional code enforcement projects that are now getting off the ground.
Great.
Yes.
Representative Walker.
Is it possible? Thank you, Mr. Chair. Is it possible that a municipality or individuals who normally would be taking this first level of complaint can see this bill as a way to not have to deal with the issues at all, and therefore make the process more extensive, more expensive, et cetera, less clear cut?
Thank you for the question, Representative. I do worry that that may be a concern because this is a workload that is added to already existing municipal workloads, and it may be something like, well, if there's a process, we'll send them there. Yep. The municipality is asked to do some sort of investigation, but they don't really have to do an exhaustive investigation if this goes to this complaint review committee. So I could see that there could be some communities that say, well, we'll let MOCA sort it out. That could add to the workload. I'm not sure. I haven't thought through what we could do to mitigate that, but I think that is something we probably should think through.
Representative Callamore.
Thank you, Mr. Chair. Speaking of the catch-up window, so one of the things that's mentioned in the certification language, which didn't get messed with, was the valid for 6 years.
Mm-hmm.
Would a catch-up window of 6 years seem reasonable so that we can, as of the time that the law passes, whatever that language is, that they have 6 years to get themselves caught up as the trainings are made available?
6 years is a very generous catch-up window. I think we'd be very satisfied with that. If MOCA wanted something a little shorter, I think we'd be happy to have that conversation.
Representative Gear.
Thank you, Mr. Chair. And just with regard to, like, where does that line happen, right? Because as I've reading the amendment, I really appreciated the additional clarity on what are the grounds for action by this office, as opposed to what's at the municipal level. Are you satisfied that there's clarity again? Because if it's, sort of a misconduct or, you're doing something really, really bad, that can go to the state. But if it's a municipal thing, managing an employee, mediating an interpersonal issue, that should stay where it is, definitely. And is there enough clarity in the way the amendment reads?
Thank you for that. I do think there is enough clarity. I think the lack of clarity is going to be the public. When Director Horn mentioned the EMS parallel, I pulled up the EMS website and looked, and it's a great, just put in your form. That can generate a lot because the lack of clarity is going to be in the person who is aggrieved, not knowing if that needs to go to the town manager or needs to go to the CEO's supervisor or it needs to go somewhere else. And when you Google it and you end up out on that form, you're just going to fill that form out. I mean, I know I would. So I think it could end up in a little bit of, there could be a little bit of a great wave of complaints and concerns unless we figure out a good way to sort of triage which ones need to go to the municipality. Have you talked to the municipality first, like sort of in the construction of that form? And I think that's probably something we could work out during rulemaking. I think that's more process than substance, but something to be aware of.
Senator Bennett.
Thank you, Ms. Emery, for
Yes.
being here. I may have missed what you said that the catch-up window in your best estimation should be.
I did not, thank you for the question. I did not make a recommendation. I think a year or two with a very concerted effort from MOCA. And I mean, Director Horn has been very clear that they do not intend to use this to penalize people who are not certified. I just worry that we represent small municipalities, we represent all of them, and many of them are very concerned and distrustful that if there is the ability to discipline in a position that is as politically fraught as CEOs, that it could be used. And that's why we greatly appreciate it not being in the hands of a political appointee as well. So I think 2 years, 3 years would be wonderful. I think we could live with something like that.
So that should be written into the statute. Is that your advice?
That would be my preference, yes.
And do you have specific advice to our analysts as to where and how that should be worded and all that?
I do not, but I'm happy to work with the analyst
Thank
and with
you.
the director of MOCA. Thank you.
very much.
Thank you. Thank you very much. Appreciate
you.
it.
Thank you.
For sticking around.
Thank you for the opportunity.
I'll ask our representative from the regulated community. Thank you. If you
Hello,
could
everyone.
please introduce yourself.
Justin Brown, unless there's preferences otherwise, I've got a quick statement on behalf of the association.
Please
and then
do.
I'd be happy to take any direct questions.
Yeah.
I'd like to thank.
What association is this?
Yes, sorry, let me start from the fresh here. Senator Curry, Representative Geer, members of the Housing and Economic Development Committee. My name is Justin Brown. I serve as Vice President of the Maine Building Officials and Inspectors Association, and I've been a code enforcement officer for approximately 20 years. I'd like to thank the Maine Office of Community Affairs for their work in revising LD 2097. The revisions made to the bill address several of our original concerns, and we appreciate that collaborative effort. We reached out to our MBOA Board of Directors, and as you might expect, over a holiday weekend, we did not receive much direct feedback to confirm our final support of this bill. At this point, I am comfortable stating on behalf of MBOA that our position is neither for nor against, but I really like the phrase used several times today of support-ish. We want to ensure that this process functions consistently and fairly and distinguishes between misconduct and good faith professional judgment. We believe that the revisions work toward that intent. Our goal is not to oppose the bill, but to remain engaged and help to ensure it works as intended.
Excellent. Thank you. I think that was really my question, which was where do you all stand on this? And it looks like, I guess I will ask this. We were talking about CEOs from the start. I was not using the language of licensed plumbing inspectors or third-party inspectors. Is that regularly viewed as being a part of CEOs, or are those considered very different?
Broad umbrella, generally called CEOs, and
Okay.
that comes in many different flavors. So
Okay.
you can hold many certifications or a few of them. So they're generally called CEOs. Broadly.
Okay, great. Thank you. Yes.
Thank you, Mr. Chair. And just a question with regard to this training catch-up window from the perspective of folks on the ground. Is the idea, like I would think that if you were a CEO in any of these forms and you were talking with one of the municipalities that you work with, and they were like, oh, hey, this comes down, you've got 3 years, is your certification current? And they would say yes or no. And hey, you've got this window of time to get it done. You know, you would already be working on that, right? I mean, is there some obstacle to within a reasonable time window to somebody making sure their certification is current?
None that I can think of offhand. I think a reasonable time frame, again, I think 6 years is generous, but somewhere in between with a good faith effort to move that forward is reasonable.
Thank you very much. Appreciate it. Senator Bennett.
Thank you. I'm sorry. Well, let me ask you this question first. It would have been suggested about the window of time for catch up. Do you think that 2 years from the effective date would be a good period from your vantage point? Do you think it should be shorter, longer?
I'm not offhand, I'm not sure I would say shorter. But again,
You wouldn't say shorter.
I wouldn't probably say shorter. Yeah, I'm not sure I can confidently answer that. I think
Okay.
6 years is generous if that gives you any ballpark of the range.
Okay.
My initial thought was there's a provision to allow for a gap at the beginning of a CEO's career where they can gain those certifications, but still do the job in the meantime.
I see.
That was my thought, and that is, I believe, a 12-month window of time. So the catch up beyond that is 2 years seems reasonable.
So if this just to, what I'm thinking here aloud is so if it's a 2 year from the effective date of the act, it would be, say we adjourn on April 15th, it becomes law 90 days thereafter, then it would be another 2 years beyond that for the catch up window. So it would be like July of 28. Any reaction?
I don't want to seem like I'm dodging the question.
No, that's okay. If you don't feel comfortable answering, it's fine.
Yeah, I think it depends a lot on the training available. And
Yeah.
I think that's a core part of
Okay.
the issue.
Thank you.
Thank you. I might ask if Director Horn would come back up. I'm getting a sense of the committee. I could be wrong, but that we might be ready to make a motion, but we're wondering about this effective date question.
Yeah, thank you. And I'll make a general statement about it. And then if you'd like to get into more details, I'd encourage you to have Greg Gilbert come up. But so I appreciate the concern about if there were a new requirement for to be in compliance, that you'd have to give people time to phase into it. That's just a general principle of public administration. I think it's worth saying that the requirement to get your training within 6 years is not new. Like, that's just the way the system works. So you take your test, you get your certification. You, over the course of 6 years, you get a certain number of continuing education credits. Then at the end of 6 years, you've either demonstrated that you've gotten your credits, or you can take the test again. There are alternative ways to get credits besides taking a specific training. There are a number of alternatives, like professional experience or taking a training out of state, or a number of other ways of doing it. Greg and Shannon ran some numbers, and the number of requirements, or the number of hours that are required was it like 110 hours over the course of 6 years to maintain your certification. If that's for all of the certifications you can get. And thanks, Greg. And there over the last 2 years, there were 578 hours that were provided across the trainings that we
That was
counted.
tallied based off of, so.
If you could introduce yourself,
sorry.
please.
Excuse me, my name is Greg Gilbert. I'm the Main State Building Official. Yeah.
Thank you. Welcome.
Thank you. So I'd sort of like to start by giving a few more statistics in that based on the 2020 census, I believe there's 87 towns that are required to enforce the MUBEC, or the Maine Uniform Building and Energy Code. On top of that, there's probably another 25 or 30 that have voluntarily adopted. Now, that means that out of the 470 or so towns, cities, townships, and whatnot we have here in Maine, that only 115 of those or so are required to have code enforcement officers that have the full myriad of certifications. Those other towns are only required to have a code enforcement officer that is certified in legal issues and land use or shoreline zoning. legal issues, shoreline zoning, internal plumbing, subsurface wastewater, legal issues, land use. So those 5 are required 12 hours each of certification recredit hours over that 6-year period. So that's 60 hours. The other 50 hours comes from the different requirements for the MUBEC certifications. So for an individual to get 60 hours of that, assuming they are the town's LPI and code officer for both land use and shoreland, over a 6-year period, when, as Samantha alluded to, or we, on our calendar, so we have a training calendar or events calendar that the Division of Building Codes and Standards puts on our website. We posted 578 hours worth of training in the last 2 years. So that is to say that I mean, I guess, I don't know if I should be giving my opinion, but I think that's providing enough training, more or less, to kind of cover what folks should be able to reach. I understand that there are some areas that are more difficult to get to some of the trainings, and, you know, with MOCA being so customer service forward, we're vehemently trying to expand our training across the state, make it more available, different areas, different platforms, things of that nature. But as it stands in the last 2 years, you know, in the last 2 years alone, we've provided 10% more than what is required for the base, and, you know, 5% more than what is required for someone that is fully certified across, you know, MUBEC and all other.
And I'll just say that there is currently and tell me if I'm wrong, but there's currently a provision for 1 year, up to 1 year of extension if the code enforcement officer is having trouble getting their certifications and communicates with Greg. And so that can be negotiated, and Greg can help provide alternatives if the code enforcement officer is having trouble getting training. So rather than granting an automatic extension, I mean, if there's more flexibility needed, potentially we could expand that, like that process that the code enforcement officer would go through to get an extension to, say, 2 years or something like that instead of 1 year. But I think that to say that the current process, where you go through your 6 years and then you can even take the test again if you want, is say that we just haven't been providing training for people to get through that at all, I think might be going a little bit far.
Representative Cullimore.
Thank you, Mr. Chair. So based on your numbers, we have approximately like 112-ish, we'll say, communities that have to have CEOs. How many CEOs do we, to do the MUBEC? How many CEOs do we actually have that are certified? Because I know we only get hours for 4 hours 1 time a week, and God forbid he goes on vacation. And then we have absolutely no one. So I'm thinking of these trainings and I'm like, is it my town that gets left out in the dust because he has to go to a 4-hour training? Who's paying for it? Is my town paying for it? Is it the 6 other towns paying for it? You know, this is it, because we have to charge his time, right? Mm-hmm. And so you're saying that you offer all of this stuff, but do they actually have the time to take it because they're already stretched beyond measure?
So I think you'll see in the governor's budget proposal that there's a 3-year pilot program, $1 million for incentivizing regionalized code enforcement to deal with exactly that problem, because it's a tough gig to have multiple small contracts. I mean, for anyone in any business, having lots of little contracts is just a difficult business model. And so the idea of moving toward a model where they have an employer who's going to provide benefits and training that is pooling several communities is probably a more sustainable way to go. And KV-COG is already trying it in Somerset County, and it appears to be successful. So I think that that's a challenge with just the overall model of how CEOs are employed in Maine with very small towns that we are trying to tackle. I think it's an ongoing, like, it's been the case for a long time that CEOs have had contracts in multiple small towns. And it's something that the CEO and the towns need to work out in terms of how you're going to get those training hours. But do you want to say more about it, or is that sufficient?
That covers the majority of it. And just to add that, like I said, we are working on expanding our training and trying to come up with ways to, apply to those individuals that are only working a day or a half a day a week in a specific municipality, so that if we could provide an hour training more frequently or just something like that. There's a lot of things that we're looking to work on towards.
Thank you for
Thank
giving
you.
us the chance.
Thank you. So what I heard from you, you would request, rather than a blanket, you request flexibility to extend up to 2 years.
Yeah.
Rather than, I mean,
That
if the
would be-
committee feels to extend up to 2 years beyond on that
Yes.
issue.
Yeah, and I think that would, and if there's any kind of a statement the committee also wants to make, either, in unallocated language or as part of the statute about the flexibility and the need to provide robust training, that's fine. There's already there's a provision in law that if MOCA doesn't provide adequate training, that then what happens? There's a provision where
You have to come to this committee in SLG and explain how you're going to remedy the situation.
I thought there was well, I'll find out. I'll get the other provision, but there's some kind of automatic provision where if we can't provide the training, there's an out, but we'll find that.
Section H and 4451, but I can't remember the
Look at you.
language itself.
Thank you.
Thank you.
Yeah.
I still have a couple outstanding things in the language that I don't think were clarified.
Good.
Is now a good opportunity?
It's better than after the motion.
That's what I thought. But, you are the chair. So the notice requirements and the investigation, the notice requirement in one section goes to the chief administrative officer of the agency, which generally is not interpreted to mean a state agency. So there's one notice that goes to the chief administrative officer of the agency, and that person may conduct an investigation after being notified. If they do, they have to turn over everything to MOCA. So it's important whether that chief administrative officer and agency is a private entity or a private and a public entity. Because if you're sweeping in municipalities, then you're going to be in contradiction to an existing law that basically says if a municipality conducts some kind of disciplinary action or investigation, that's their decision isn't confidential, but the material that supports it. Like there may be medical information that may explain why a code enforcement officer forgot to file a form. So one thing I think you need clarified is who's getting this one notice and who is being asked to respond and whose records are being turned over. And that was not clear to me. Because chief administrative officer and agency does not usually in statute equate with a municipality or a state agency.
Senator Bennett.
You're going to hate this question.
Okay, go for it.
So what should it say?
Well, I don't know what the intent is. I don't know who MOCA wants the notice to go to.
So what does the chief administrative officer want?
An agency. That's what the language says. That's what I'm not sure what they meant by that.
May I ask that question to Samantha Horn?
Yes.
Thank you. Thank you.
Have an answer and potentially a solution. So I double checked this because as we were writing this, I wanted to make sure that I understood what the terms mean. In this context, and legally an agency means any body that's employing those code enforcement officers, so it can include private companies. I think that what we could, I totally see your point. And I'm wondering if we can just, so on page 2, if we can strike in that paragraph 3, where it says report the findings, and then it says, and provide copies of any investigative reports. I wonder if we can just strike the and provide copies of any investigative reports, and then can you say where that is again? Sure. Page 2, Paragraph 3, investigation of conduct, notice of investigation, 1, 2, 3, 4, fifth line at the end. Where it says report the findings. So this is the chief administrative officer of the employer of the certificate holder. If they report the findings, but then we strike the part about and provide copies of any investigative reports, it eliminates the transmission of materials that might be private and just provides the overall findings of the investigation. I don't feel strongly that we don't need, we don't need all of the backup material, as long as we understand what the employer is concluding.
May I ask Ms. Westfall if that resolves the issue that you raised?
That definitely resolves the second issue, which is the transmission of potentially confidential information. I don't agree that chief administrative officer of the agency is clear that it includes either state agencies or local political subdivisions, which I think is the intent. So I would just ask the committee's permission that chief administrative officer of the agency employing could be expanded so it's clear it can be a private entity, it can be a state agency, or it can be a municipality or county.
Thank you. May I ask another question
Go ahead.
before we lose a quorum?
I think we're too late. Yep.
Never mind.
Process to our online people count on quorum.
They do, as long as there's a senator in the room,
Okay.
and there's two.
I'm here.
We need one more. We need
Just get
Representative
Representative
Gear
Gear
here.
back.
Yep.
I'm still here.
Oh, good.
Oh,
All
good.
right.
All right. He's
gotta show his
All right.
face, though.
Very good. He
I'm
will.
sparing you all from showing my face.
So may I ask?
Yeah, Senator Bennett.
So there was a second issue, Ms. Westfall, that you had unresolved, I think.
No, I think those were that.
Okay.
Being clear about who is getting the information, the notice, and that it's not confidential information that's going to be shared back to
All right.
MoCA.
May I make a motion?
Yes, please.
I move ought to pass as amended with the MoCA amendment with as further elaborated upon by the recent conversation over the last 10 minutes.
And that would include
That would include the language that Ms. Westfall is happy with and proposed regarding chief administrative officer and the
striking the language for the report back
Exactly.
and the flexibility for the second,
Correct.
the 2-year.
Yes.
Can you just remind me of the flexibility of the 2-year, because I wasn't quite sure.
So
From the requirement in the statute that says they have to complete certain amount of training within the 6 years, there's going to be an addition that the MoCA can waive that for up to 2 years?
yes, the division head can waive up to 2 years.
Okay.
Is that correct? Okay.
So move.
Did I hear a second down there? Thank you. Moved and seconded. I'll ask, any further discussion? I'll ask our committee clerk to, you want to caucus? Thank you.
Or the answer is definitely no.
We'll take a short break.
Are we good?
All right, welcome back, everybody. I'm looking for our chair. Oh, here she comes. Welcome back, everybody. Representative Collmore.
Thank you, Mr. Chair. So I will not be supporting the motion before us. I really don't like ambiguity in law or flexibility and that kind of thing. I want us to have a clear 2-year deadline after the implementation of our law to give people the chance to catch up. It was made very clear to us that they are working on ways to ensure that we have more flexibility with the offerings of courses. But I know how hard it is to just get a hold of my CEO. I can't imagine what it's like for him to try to get a hold of somebody else to tell them I didn't have time to take the training in Portland or wherever it's offered or however it's offered because I had a 16-unit thing that I was inspecting and meeting with. So I won't be supporting the motion before us because I want the law to be clear that they have 2 extra years and not that, you know, MOCA can say yes or no at whatever whim, no matter how generous they plan to be. I want it to be clear. Thank you.
For a vote. I'll ask the clerk to call the roll.
The motion on the table is ought to pass as amended. Representative Mingo.
Yes.
Representative Mingo voting yes. Senator Bennett.
Yes.
Senator Bennett voting yes. Senator Curry.
Yes.
Senator Curry voting yes. Representative Gear.
Yes.
Representative Gear voting yes. Representative Collmore.
No.
Representative Collmore voting no. Representative Julia.
Yes.
Representative Julia voting yes. And Representative Eater.
Yes.
Representative Eater voting yes. And moving online, Representative Lookner.
Yes.
Representative Lookner voting yes. And Representative Mallon.
Yes.
Representative Mallon voting yes. 8 in favor, 1 not.
And with that, we will close.
Here's the report.
Oh, thank you.
He doesn't care about my opinion. Well, given what the numbers are, I'm just going to do a straight ought not to pass so that you don't have to do the extra work.
Thank you.
And with that, we'll close the public hearing. Members who are not present have still have 2 business days. And so that will be on, today's Tuesday, so that'll be Thursday at noon. So just Thursday at noon, is that correct?
It's 5:30.
I'm not gonna do counting math.
It would be 5:36 on Thursday.
I'm not gonna go to the rules at this point. So with that, we'll close the work session on LD. What LD was this?
2097.
2097, and we'll open up the work session for our final bill today, which is LD 2124.
Yes, that's correct. Thank you,
Thank you.
Mr. Chair. And just a caveat, you're getting a bill analysis that says it's to LD 2142. It is not. It is for 2124. I just didn't want to print more pages. So this is an act to support emergency shelter funding using revenue from the real estate transfer tax from Representative Gattine. So under current law, 90% of the revenue from the real estate transfer tax goes to the state and 10% is retained by the counties, except that in 25-26, the percentage was reduced from 10 to 9.2, and then in 26-27, the percentage the percentage retained was 9.2 by the counties and 91.8 by municipalities. This bill reduces the percentage of the real estate transfer tax that goes to the counties by 1.8% and increases the state's share to 91.2%. It requires that 1% of that additional revenue to the state go into Main State Housing's shelter operating subsidy program beginning September 1 of this year, and then August 1 of next year, 1.8% of the revenue goes into the shelter operating subsidy program. And then beginning September 1 of 20, yes, that's more math, 8.2. Go. I have a bit of the history of the real estate transfer tax, which I am going to not to give to you today, but if you do want to know the different changes to the percentages and the different changes to the rates over the past several decades, that's there for you. There are a few potential technical issues with the bill as drafted. The first one is that it references in statute the Shelter Operating Subsidy Program, which is not an official program in that it's not part of a statute. Usually in law, you want to reference an actual program and not kind of a sub-program. Now, the Shelter Operating Subsidy Program appears in the supplemental budget. So it is an actual program, but I was going to, and I haven't found out whether this is actually part of Maine State Housing Authority's Emergency Shelter Matching Grant Program or another program that's defined in statute. If it is part of an official program defined in statute, my suggestion would be that this bill be changed to reference that official program. The other technical issues that were raised during the public hearing is, when is this 1% subtracted? So the way the real estate transfer tax goes is, first, Maine State Housing Authority gets enough funds to handle their bond obligations under the Maine Energy Housing and Economic Recovery Program. After that, after they get paid for that, then the funds are distributed as is on the top of the third page. 20% to the general fund, 32% to the home program, 30% to the housing production fund, 18% to the Housing First program, with an exception for the last 2 years. When is that 1%? Is it deducted off at the very beginning? And then Maine State Housing gets its funds, and then these programs get their percentages? Or is the 1% deducted from each of these individually? And I think that needs to be clear. We heard different testimony. Some people thought it meant at the very beginning, and some people thought it meant after. So as long as the committee is clear, I will make sure the language is clear on when that 1% is to come out. And the other thing I just want to point out is there is a provision in law, and I am at the part of my bill analysis right before additional information requests. There is a paragraph in law, paragraph F, that says that the funds to the home program cannot go below 50% unless Ledge Council and this committee are told about it 30 days prior to any vote or public hearing. Now, you were told about this proposal 30 days just by chance. You got the bill referred on January 7th, and you had the hearing on February 10th. So just by chance, that 30-day window was met. I'm not sure how Ledge Council is supposed to be notified of this. There's nothing in here that says what happens if Ledge Council isn't notified. And oh, by the way, as you know, you can't bind a future legislature, so you don't even need to pay attention to this. And it wasn't followed last year when they made changes to the real estate transfer tax. But if you want to cross your T's and dot your I's correctly, you would allow me to add some language in the bill that says, notwithstanding paragraph F. And let's see, I had one more technical issue, and that is the dates. This has the percent change happening September 1 of this year, which is within a fiscal year, and then August 1st of next year. So the timing of this change is not tied, at least the second one, the August 1 of 2027. Usually you tie the increases or the changes to a fiscal year. I'm not sure. I know why the September 1 of 2026 was put in there, because they're trying to pick a date that's beyond the effective date of the bill. But the year for 2027, I think you may want to tie it to actually the fiscal year. And then there is another provision that says that the $5.1 million in fiscal year 26 and 27 that's going to the home fund, that cannot be reduced. So I think you would also want to draft this in a way that the money, the 1% that is going to the shelter operating subsidy program, does not take away from the 1.5 million that has been allocated to the home fund. So those are technical issues that you can fix with language in the bill. But also you are going to want to think about, do you want this 1%? Do you want to, you can fix it and move around it, or you can change the amount that's been allocated for fiscal year 26, 27 to the home fund and have it lower than 5.1.
Question for Alan.
Thank you. So would we avoid that whole issue if we just said we wanted the 1% to come from the 20% that goes to the general fund? And then it doesn't steal anything from our counties?
So you would leave the 90-10 split?
Yes.
And then, so that is an alternative to have, well,
Because there's no thing saying that we can't reduce the amount going to the general fund.
no, there's nothing saying you can't reduce any of these amounts. The 20, the 32, the 30, or the 18. This bill says the way to get more money is to take it from the counties. What you're saying is instead of taking funds from the counties, you take it from the general fund. I don't know if it would be a straight subtraction of 20 to 19%, but you would, because
there's increased revenue, because it's increased. So therefore, we could take that increased revenue from the state general fund instead of from the counties that we have, like Washington County, trying to come out of a potential bankruptcy. And so we could avoid hurting them and the budgets they've already created.
Yeah, there are definitely different ways to give money out of the real estate transfer tax to the shelter operating subsidy program. And that's one of the options. There's other options too.
Are there other questions for the analyst? I know we had a lot of requests of different sectors that came before us, a lot of for the work session. And so I've heard from Molly Feeney that you had materials. Would you mind coming up? And I don't know if we asked the registers if they had any more information, but I'd be happy to have them come up next.
Thanks,
Welcome.
Mary. Thank you.
And I can't remember what we asked you to come back with.
That it is maybe easier for me then.
Okay.
So thank you, Senator Curry and Representative Gear. Molly Feeney, and I'm the Executive Director of Homeworthy out of Knox County. However, I get to serve as sort of a spokesperson for a coalition of shelter leaders really representing our programs from around the state. So I did narrow down a couple of questions, and I do have materials that I didn't want to just assume would be helpful, but I brought plenty of copies. This, I think, is probably the most useful. There was a couple questions, I think, Representative Collmore really talking about how are each county served, how are the constituents served? And so we just did a little bit of shifting of our data, and thank you. And that shows constituent coverage by county, and keeping in mind that our shelter coverage is 11 out of 16 counties, which includes domestic violence shelters. there's a nuance on that data that's on the bottom that does not include DV guests, however, because of privacy reasons. So, but it just gives you a really strong sense of the regional coverage by county, even when a brick and mortar shelter is not in existence in particular places. The other question I think Representative Collmer, you also asked, was just really trying to get a general sense of what some of the other programs are outside of ESHAP, which I don't have a ton to comment on, but I have an internal resource that we use at Homeworthy when we field phone calls, and this really breaks down everything that we try to access for folks, whether that is other shelters or not. But I think it just gives you a good sense both of who the service population is and where these programs are across the state. So if nothing else, this could just be useful in your own reference bank for constituents. And the second page of the maps there is really just the end of 2025 data around need. And I think that's really significant. That 4,000 and change number represents the number of identified unhoused human beings in the state of Maine at the end of last year. And keeping in mind, we have just 1,200 ESHAP beds. And so that is inclusive of folks that are currently unsheltered and residing in our shelters. Representative Gear, you had asked a question about just sort of some of the financial commitments of these shelters with our actual buildings. I have sort of half of an answer there, which goes on theme today, I think, of some ish. So Maine Housing was able to identify that out of our 37 shelters, there are 23 that own their buildings. I don't think it's safe enough to conclude what the other the other 38% are, but most likely there are rental situations that are at the mercy of rental market unless they have moratoriums on or relationships with those buildings. But I would just underscore too, most significant and cumbersome expense for all of us across the board is really staffing overhead and being able to sustain the safe and required amount of staff on our 24/7 programs. There was a question around which counties are sort of not represented with a program, and that's Lincoln, Piscataquis, Saginaw, Waldo, and Washington. But in the previous resource that we gave, it will show you which programs really oversee those counties in partnership. And I think that's what I have from my recollection of questions, but if there are others or questions of what we provided you.
Representative Pellemore.
Thank you. You said it provides who oversees it, and I see for Waldo County, it's the Mid-Coast Maine Homeless Coalition in Belfast, but it still says none for Piscataquis and Saginaw. So how do they get services?
So that's the breakdown. Actually, the Mid-Coast is not an ESHAP shelter. So actually Homeworthy is the ESHAP shelter that oversees Waldo County. It's going to be the other maps, which I did bring another copy, but it was from last week's testimony that shows you what the shelter coverage is. That's just programs that we have access to. And I have a copy here if you just want to look, but if you go to this, you can see where Waldo is served through various shelter programs. So I just have one of those, but actually Dr. White also equipped me with a question I think that had come up during her testimony around the aging homeless population. And so there's some research specific to those questions too. So we brought you a lot of paper.
Thank you. Yeah, I'll ask her quick. Thank you. And I
Sorry.
see you have a question from Representative Lookner.
Thank you, Mr. Chair. And I'm not sure if I asked you specifically. I'm unable to see who is actually sitting there right now.
This is Molly Feeney is the person at the chair.
Okay. Thanks, Ms. Finney. And I had asked a question during the public hearing about which counties, sort of like if you have information or if somebody had information about where, in certain counties like Cumberland County and Penobscot County and some of the bigger shelters, if there was information about the original residency of users of those shelters, in like what counties they're coming from. So like people from other counties, other municipalities being served in service center municipalities, if that was information that you had or somebody has, because
Yeah.
I'd like to see.
Yeah, thank you, Representative Blickner. And that question was to me, and I was wondering if it was one that might have been forgotten because we haven't gathered all of the data. But we do have, I think it's a tricky question because this is really more specific to sort of the higher density areas. And so we really are talking more about Cumberland and Penobscot. And we do have Cumberland County data from the service center that shows that 37% of the shelter guests identify their same zip code. And then what's tricky is where the data sprawls from there around sort of other and out of state. And so we have this in HMIS. It's a tricky story to tell in data, I think. But again, happy to provide it. I just think it's more relevant to the higher density programs because you're really serving, the question really becomes, are these larger shelters serving folks outside of their catchment area? And the answer is unequivocally yes, and that we are looking at the general region. I think in the smaller, more rural programs, the original maps tell that story best, which really feed in to say that out of 40 beds that we are serving over 50% of constituents from a sprawl within that county, and actually even up to, I think 9 counties was our average when we looked at every program across the state. So 37 programs on average are serving 9 counties worth of constituents in smaller amounts the further you get out. But we'll give you the information from Portland, and I just need to gather it from Penobscot. But that's that is what the HMIS data tells us, that it's not a majority percentage of constituents that are served from the same zip code.
Gotcha. And so just to put a finer point on that, it would be safe to say that some of these bigger service center shelters are helping other counties and other municipalities.
Yeah, and I really appreciate the question for that because that is true. I mean, there is no question a relationship between all of these programs across the state, primarily for geographic reasons, but also for subpopulation services, because shelters are built in a way that we exist with the safest regulations possible, and we're serving specific subpopulations, and we don't have each of those options within every county in the state. So all things considered, we have really pretty strong coverage. But yes, it becomes a very regional service.
Great. Thank you. Are there any other questions for Ms. Feeney? Seeing none. Thank you.
Thank you.
Thank you. Okay. And I'll ask if Ms. Kilkelly will come forward. I think we also ask you to come forward with materials.
I'll have to resend it. I was trying to send it from my phone, but I will do that. Thank you, chairs, members of the committee. I'm Marge Kilkelly from Legal Services for Maine Elders. I was asked to come back with some information about older people and their situation in terms of being unhoused. And what I will send to you is really a very brief overview and some resources about how some ways that we might possibly be preventing homelessness for older Mainers. Years ago, Lori LaChance was state economist, and she came up with a great slogan, I thought. There are no silver bullets, only silver buckshot. So when I went through looking for the one answer that was going to make a difference, there really wasn't one. It's a lot. One of the issues, but the key drivers of homelessness for older Mainers, one is income. We have a number of people who are on Social Security and only Social Security, don't have savings, don't have a retirement plan. And it really takes just one issue for them to go over and not have enough money for rent or not have enough money to pay a mortgage. Obviously, housing cost, you all know about housing cost, and the fact that, it's several years, in some cases, wait for someone to be able to get into a subsidized housing situation. I was a caregiver for my 90-year-old friend who otherwise would have been homeless, and we waited 2 years and still hadn't found anything, and she ended up in memory care finally. But it was really challenging, and I know that experience. We also have the oldest housing stock in the country, as you know. And so a lot of those homes that people are staying in because their mortgage is paid off are larger homes than they probably need. They're drafty in many cases. And we, it's very difficult to maintain them, and it's very expensive to maintain them. And suddenly they're, again, just living on their single incomes. One of the things I've included in here are some stories from legal services for Maine elders about people who have found themselves in very difficult situations and have reached out to legal services to assist them when they're getting evicted from a property they've been on for years, but didn't have a lease and didn't have a written agreement and didn't know where to go. And so they came to us. Just as a quick explanation, if there are two people and one is 66 and one is 62 and the younger one is still working, they've downsized, they're in a rental, they get SNAP benefits and fuel assistance, they've signed up for subsidized housing, but they need to wait for that to happen. Oil and electricity are expensive because they have to pay their own utilities because obviously we all know that some of the federal fuel assistance has been cut. And say their pipes freeze and one of them tries to fix the pipes and falls down and gets hurt and then is in the hospital. And I mean, it cascades. It just goes on and on. And, one of the things I know that some of us are very concerned about is that with the new work requirements for SNAP benefits, if a person is up to 64 years old and isn't able to work, or they're caregiving for a partner, we're not clear how that is going to work for them. So they may lose their SNAP benefits. And then that means there's even less money available for them. We also know that if they were to sign up for Meals on Wheels, we have a 900-person waiting list for Meals on Wheels right now. So even those kinds of basic supports are really challenging. So the real question was, what can we do? And there actually are some bills right now in the legislature that in fact could help. One of them is LD 814, which is a bill to fund comprehensive case management from the AAAs. And there's a thought now that sort of, the AAAs, you go and you can get all kinds of services. Well, they're limited. And so if you can have comprehensive case management where a person calls with a question and you can follow up and you can meet with them and whatever, there's a lot that can happen. But Mainers are wonderfully stubborn and have a wonderful stiff upper lip and often won't ask for help until it is absolutely a crisis and an emergency. But having that wraparound case management could really help. There are a couple of bills in the Energy Committee that look at reducing costs, and one of them has to do with replacing a federal program that's gone now that does some weatherization. If you've got that big drafty house and you're spending a lot of money, the best way to deal with that obviously is weatherization. Strengthening supports that people need in order to survive. For example, rural transportation. I testified on a bill the other day that is expanding reimbursement for community paramedicine. Having somebody able to go in the house and check someone's blood pressure, they can also figure out if the house is too cold or if there's some other unsafe stuff going on there. Fall prevention programs are critically important because what we know right now is that in terms of falling, that is about 20,000 calls to ambulances in the state of Maine.
I want to interrupt for just a moment here. And are there any other recommendations related to this bill aside from your support?
One of the things I put on here is some resources, and what I did hand out is a blog piece that is really looking specifically at older folks and their homelessness, and that was what I was asked to do.
Thank you for
There you
bringing
go.
that back to us. I greatly appreciate it.
And when you have another work session, I'm happy to come back.
Thank you. Thank you. I'll check in with a representative from the registers. I have to prevent myself from saying registrar because I've worked in higher education from,
It all depends on which county you're talking
oh, is
to.
it? Some call them registrars?
Yes.
Okay, all right.
Thank you. I'm Sherry Crockett. I'm the Register of Deeds of Oxford County and representing the Registrars Association. You tasked us with coming back with mansion tax figures.
Yes, thank you.
To remind you that we did only collect mansion tax for November and December of 2025. So that was a challenge for us between being notified of this on Friday, with MRS being closed on Fridays to us, as well as yesterday. So what we were able to do was pull together Lincoln County figures for you. What I would like to start by saying is, over the next year and a half, while we're at the 9.2%, we're looking at a remittance to the state just from Lincoln County at $528,697 per year. So that's just Lincoln County, which would put these funds, so the general fund would go up just over $105,000 just from that one county. The other three funds would be 158, 169, and 95. So what I would like to do is pull together all 17 collections, get that data collected for you, email that to you so that you can see that big picture of what the mansion tax would be projected for 2026, so that you can see that. And keep in mind that we weren't able to pull that together because mansion tax is collected at a different rate than the under $1 million tax. So with that being said, $64 million in 2025 went to the state as the reimbursement for the 90% and then the 90.2% in November. So, or September, I'm sorry. So considering that, we would just highly ask you to consider taking from the general fund. Representative Collmore, you hit the nail on the head. That is the piece that the state is taking more money. So, and we feel very strongly that based on those figures, we cannot afford as counties, as county governments, to be able to sustain that increase in the budget and then pass that on to our property taxpayers. We just got done hearing about the elderly having to go to shelters. That would be an impact to them, especially in our smaller counties and our elderly counties.
I greatly appreciate you coming up with these. Just to give you a sense of my workflow on this is my intention is to recommend or have a motion to table in a little bit after we've heard from everybody and asked questions, so we can get more information. And so if you are able to get any more of that,
yes,
yeah, that would
absolutely.
If we support that tabling motion, then we'd be able to get that in time.
Wonderful.
So thank you very much. Are there questions for? I'm sorry, I blanked on your name.
Sherry.
Sherry, thank you.
Yes.
What's your last name?
Crockett.
Crockett. Yeah, thank you.
Thank you.
No other questions? Okay. Thank you. And then last, I would like to hear from MMA. Welcome back.
Thank you. I remain Tanya Emery from MMA. My colleague Amanda Campbell was able to gather a little bit of information in response to the question about how municipalities routinely budget and support shelters as well. We asked municipalities, we were not able to get, as with the counties, a ton of response, but initial survey data indicates that about 15% of our responding communities do provide routine budget funding for shelters in amounts ranging from $100 to $400,000. And respondents providing funds related to donation requests are also equaled just a straight donation, not a budget line item, anywhere from $250,000 to $120,000. So between the two funding options, a total of about $1.3 million is being directly used from municipalities to support shelters directly. So happy to gather additional information. That was what we were able to get in a very short period of time.
Thank you very much for doing that.
You're welcome.
Lastly, I'll ask you. Oh,
Just a question about, was that just in the last fiscal year? Is that something that's been happening regularly? Is that over several
This
years?
was what was the budgeted amount. So asking what is your average budgeted amount? It was, again, a very quick turnaround. So we can ask questions a little more expansively if we have a little bit more time. But the question about donation requests was, have you ever fielded a donation request? And if so, what is the typical amount that you provide? So those are individual allotments. Yeah.
thank you.
Thank you.
Is there a representative from the counties? that we should, I'm not sure if we asked you to come up with anything or welcome back. I think that's everyone that we've asked to come back with information. What do we, I don't think. Yeah, welcome.
Thank you. My name is Carrie Kipfer. I'm from Lincoln County. And I have information in regards to how the counties are supporting shelters. And I also have a really back of the envelope projection on what kind of impact this has for county general funds and the state general fund for the mansion tax. So to give a snapshot of the shelter support, there's a range of different ways that the counties are helping, from funding food pantries, homeless shelters directly, Habitat for Humanity. There's an entire list here. Western Maine Community Action. I know that Lincoln County this year has directly funded Tedford Shelter in Brunswick, which is 2 counties over from us, just so that we can start that process of recognizing the effort that they're putting forth on our behalf. We also are funding the Elder Care Network, which is helping provide housing for the elderly. We are very much aware that Lincoln County has a very elderly population, and we want to recognize that they need some assistance as well. But it goes from a small amount of $5,000 up to multiple millions of dollars that the counties are supplying. And that's just from general fund. In addition to that, there's been major investments from ARPA funds. So the counties are really engaged in the communities with this. To dovetail on what Register Crockett mentioned on Lincoln County, we're projecting the 8.2% contribution to this bill for Lincoln County would be $35,000. That seems like a small amount, but Lincoln County only represents 3.26% of the total 100% that the counties are taking in. So if you take that 35,000 statewide, that would represent about $1.1 million. And if that's 10%, just to use the old math, which is more generous, the projection then would be statewide, there's $11 million that is coming in from this mansion tax. So of that $11 million, 9.8% is going to the general fund, in addition to what was already going to the general fund. So to go to your recommendation, Representative Collmore, there's going to be more money in the general fund from the mansion tax, not just to the counties. So there's a bigger picture here. We don't have a lot of data to go on right now, only because it was a short time frame, but we also are struggling with what's that mansion tax going to look like. We don't know because we only have a few months of data. So we can project it out as long as you're recognizing that that's a projection, and it's going to be our best effort.
Representative Collmore.
Thank you, Mr. Chair. First of all, I'd like to say how cool it is that my off-the-cuff remarks today are landing quite well. I'm
disappointed I can't use the ish.
I'm so sorry. I should have put something in there about that. What is the negative impact? And I'm sorry, I had to leave early. I had to go to another obligation that evening. So if you said it, I apologize. But what is the negative impact to the counties by losing this extra percentage that presumably you have put into your budgets?
So I can tell you that I have it in my budget. My budget started on January 1st. So if this bill goes into effect, I'm in the deficit immediately. And there's impacts to the net county tax. So every dollar of revenue that we don't bring in is one more dollar of expense, county tax expense, that we need to send out in our tax commitments. That goes to the municipalities, that directly goes to property taxpayers. And there's, sorry, I lost my train of thought there. We're very cognizant of the fact that our revenue streams come from 2 sources. It's transfer tax, it's state funding for county jails. And if we have increased expenses, which we all have increased expenses, and the mansion tax is supposed to help offset those increased expenses, this bill pulls the rug out from underneath us. We're trying to keep ahead so that we are not having deficits across the state. I'm fortunate that we're in a very stable position in Lincoln County, but that's not really how the rest of the counties are feeling right now. I can name off a handful of them that are struggling financially. I know that there's counties that are looking at double-digit budget increases. And if this goes through, their budget estimates for their new fiscal year are going to go up because they won't have the revenue to offset those expenses.
Are there any other questions? Seeing none. Thank you very much. Thank you for doing that work. I greatly appreciate it. So I will, at this point, I think a motion to table is in order, unless people have any discussion prior to that. Representative?
Thank you, Senator. I won't be voting for any extension on this because I will not be voting this. I'll be voting a no on this to begin with. Most of you can understand why the situation Washington County's in. Washington County has faced a budget increase of 38% over the last 4 years in a budget alone. And every taxpayer, property taxpayer in the county right now is getting 2 tax bills for 1 year just to try to fix the bankruptcy situation the county's in. So in no way am I in favor of this bill, no matter how it's written.
Representative Gear.
Thank you, Mr. Chair. In the spirit of wanting to address some of Representative Mingo's concerns in future session, I move to table.
Second.
All those in favor? Opposed? Motion carries. Motion carries. The folks on Zoom can't vote on that. It's a procedural vote.
No.
What's it? Yeah. With that,
We don't have a quorum?
you have a quorum to table. You don't. They can vote.
We can move to table.
We can move to table. Yeah,
The only
we
thing
can
you
move
can
to
do.
table.
That's
Yeah.
adjourn.
And we can move to adjourn, in which case I will
I'll move to adjourn.
move to adjourn. All those in favor? We will adjourn.